When you walk into the front of the building, you come to our main door, and I really like this door. It is so classy. This is our lobby, and we share it with our neighbors, of course. So there's a great big screen right there. One day I'm going to actually start using that to broadcast what's being recorded in the studio. So if you're sitting in the lobby, you can see what's going on in the studio. And you walk in, here's my neighbors. Got some great neighbors. There's the powder room and restroom right there. But right behind you, as you turn around, is Podium Studios. So let's go check it out. Let's see what's going on in there. And when you walk in, you immediately see the control center, the producer's desk. You see right there, we have another big screen. You can play videos as well as use it as a monitor. We use it as a monitor sometimes. Here's our producer's station, producer's desk. Usually come in and turn on the computer and get the day started. You see we have a Mac Studio M3 as well as the Elgato Stream Deck. We have 3 cameras. That big monitor right there is the producer's monitor, but have no fear because on the other side is another monitor for our guests. Here, of course, are 3 angled cameras. This is our confidence monitor or monitor for our guests. You can use it as a teleprompter, another video screen. And here at the desk, the infamous table, are 4 mics, 4 chairs. We have a great set of lights. I'll show you how those lights work in a moment. And of course, the big screen in the back. We can put whatever it is that your content on that screen back there. And here we have our Rodecaster. We control all the audio there. We have our ATEM Mini that we use to switch between different camera angles. I need to actually turn on the cameras real quick, so let's check that out. Usually when we first walk in every morning, we do these things, turn on everything to make sure everything is working properly. And now we are ready to go. This guy right here decided he did not want to come on. He had a long weekend, I guess. I don't know. And we sit on down at the producer's station. You can see this is where the producer's angle is. And now our ATEM is on, so we're turning it. You can switch the different camera angles, and a producer can see what he's recording. Now, the neat thing is on the confidence monitor on the other side, the guest can also see what the producer is recording. So they'll see who's being focused on when. So it gives them an opportunity to know what they're supposed to be doing. And that is our sign. Our sign is back. And really proud of that thing. It looks fantastic. And you'll get another chance to check it out in a moment. So, of course, we have 2 main lights and a hair light. And let's turn the lights out and kind of get a feel for it. And turn on our on-air sign for the ambiance. So now you can see here, this is what the guests could see if we wanted them to be able to see themselves, so they can make sure they're paying attention, make sure their face is right, or make sure they're close enough to their mic, anything like that. It's just another way to give them an awareness of what's going on. And that's me. So of course we do have 4 microphones, and each microphone has its own set of headphones, as well as a power strip in the middle for your laptop or any kind of equipment that you might have or you might need. We also use a tablet. This is our iPad. We use that when we're recording for ourselves so that I can control it from there. This is the side studio, and this has always been under development. So it's still under development. I'm going to get it done. I promise. And I want to be able to have 2 guests be able to sit here with one another and face one another. And so sourcing the right kind of chairs has been a little bit of a challenge. And keeping this room from becoming a stopgap has also been a challenge. But so far, I feel really good about it. The sound in there is pretty good, and I think it'll be red. The lights, the cameras, and the chairs. It'll really look nice. So one thing, we have lights in here that weren't turned on yet. So let me get those plugged in for you real quick. All right. So right now they're blue, and we're going to go real quick, and I'm going to show you just how I manage all the lights, because we can change the lights to whatever color that fits your scheme, whatever fits your ideas, whatever like that. And so this is how it would look from the back of the house, of course. And right here, I have an older phone that I've connected all the lights to, and I'm able to take that phone, plug in, tap in they're grouped. So the main house lights, the main studio are grouped, and the side studio are grouped. All right. So now you'll be able to see, notice they were blue. Now they're purplish. So I can change into whatever color I want. So just use that. This is a side studio. I want them to be green. Bang. Now they're green. So go back over here to the main studio. I can do the exact same thing. Want them to be a different color. Your wish is my command. Different color it is. So you want them pink, you want them yellow, whatever your color scheme is. Works out fantastic. Very responsive. And feel good about those. I really like the way that came out. This app was fantastic. It's really a great tool to add to it, because it really helps change, and everybody's feel and vibe might be different. So whatever it is that you're trying to convey, we can let those lights help you out a lot. I'm kind of biased to green, as you all have kind of probably picked up. But so that's those little lights right there. There, again, that's what they do. Now, we also have, one of the things I want to point out, like I said before, is each microphone has its own special set of headphones. And we have the over-ear kind as well as the in-ear monitor style that like musicians use in concerts and whatnot. So that's a great thing that we have. And then the very last thing is all of the lights in the building or in the studio are connected to a Google Home. So I can just tell the Google to turn off the lights, and it'll turn off all the lights. Or I can tell them to turn off the whole studio, and it'll turn off everything in the studio. So when I say, Google, turn on the lights, it turns on the lights. And I say, okay, Google, turn off the lights. It'll turn off the lights. But the podium sign is connected differently. So we gave that one its own special indicator. So that way that can stay on if we wanted it to stay on, to create some kind of ambiance or whatever like that. And you may have noticed that the lights under the table did not go off. And you also notice the lights under the table are their own color. The lights under the table are a different brand, so we weren't able to get them connected to the same light source that we're using for the side in the main studio. We'll get those changed eventually. So that's how that works. The side studio, hopefully next time I'll show you something new there, that we've made some changes. And there's our podium sign. Again, super proud of that. It looks fantastic. Let's go ahead and go back out into the hallway and wrap up this tour. So I really like this lobby. I keep saying that, but I mean it a lot. This is a fantastic look, and it really sets a nice tone. It's super comfortable. So when we have a lot of guests, they can just sit out here, relax, work on work and whatnot, and everybody's in a good to come in and do their actual recording. Our neighbors are super responsive and kind, so it works out very well. This is a great place. I'm glad you're able to do this. Grace and peace, everybody. Good morning to you. Good morning. Good morning. Happy day 106 of the YSL Trial. Good gracious. I can't believe we've gotten this far. I can't believe it's gone this long. I cannot believe it. But I thank you all so much for stopping by on this morning. We got I really have stopped trying to bet and say what's going to happen, because I have no idea what's going to happen. I just know prognostication is not my jam. Let's just say it like that. At the current moment, what we do know is that there are going to be some people in the courtroom, and there's going to be some lawyers in the courtroom, and court is going to happen. That's about all I can promise you right about now. At the current moment, nothing's going on. So let me see. Yeah, let me make sure I like them real quick. All right, Law and Crime has not started as of yet. So I appreciate y'all real quick jumping into the live chat. Thank you so much to the moderators. I'm getting some stuff done at the house today. So I appreciate y'all checking out that's my studio that I own with another brother. And that's Podium Studio that I showed you the video of. I'll do a walkthrough of my home studio if y'all want to see it. It's not as long, it's not as big and grandiose as a Podium, but maybe I'll do a walkthrough with that as well. I actually have the video done. I don't know why. I just need to upload it. Anyway, I've stopped prognosticating on what's going to happen in this trial because I think we all can agree nothing has happened that we anticipated. I don't think anybody, if you were, if you had a bingo board, or if you had if you were betting, you probably have gotten a lot of things wrong. I mean, from the judges to the change in atmosphere with the new judge, to all of the things that have been revealed, all the things that have come to the forefront and to the light. I don't think we had an idea. So all I can tell you and I can promise you is that court is probably going to happen down in Fulton County today. There's going to be a judge there. There's going to be some attorneys there, and some things are going to be said. That's about as best. That's the best I can give you today. Because my goodness, in the morning, I have no idea. I did not expect yesterday to go like it went. From Melnick coming in to talk about what happened to clear his name, to Kayla coming in to speak, and then several other witnesses to substantiate or disprove what Kayla said, and all of the shenanigans. If you follow Kayla on Twitter or on her own account, there's a lot of kerfuffle, if you will, around Lady Bumpus. This is a lot, and we still did not get a mistrial. I still believe Judge Whitaker is substantiating why she's going to declare a mistrial, but again, I don't know why it's taking this long, because it seems pretty clear. It seems pretty straightforward, almost like a guarantee, like this makes sense, but I don't know if there's. So here we are. We're still back here on day 106. So I appreciate everybody. Thank you so much to the new subscribers. Thank you much to the old subscribers, whether you're day one or this is your first day. My name is Jason, and I am a former classroom teacher who's retired that likes to talk about these type of topics. And so what I ended up doing is I started giving social and political commentary from a Christian male perspective. So that is my worldview. That is how I see the world. And I like to talk about these topics. And I enjoy interacting with you all around them because it's crazy. And by the way, I live here in Atlanta. So I live probably about 40 miles from where this is happening right now. And so I like talking about these things because they're right here in my own town, in my own little side of the world, if you will. And I do talk about other topics as well, but I like this stuff going on here because it gives me I see it in 4K. So I talk to people that know what's going on here. Literally talked to somebody this morning who knows a lot of the attorneys involved in this. So it's kind of crazy. So that's what I am. That's what I like to do. That's what we're doing here on this day. If you want to join the best live chat on the planet, hit the like button and jump on over here and say what's up to all the good people. Good to see my sister Kiana. Good to see my brother. Present, not perfect. Good to see you, sir. Grace and peace. Good to see you, sir. Mimi's in the building. Always good to see. There's so many faces have shown up this fine morning. So I'm glad I got a chance to say good morning to you all. Let me just roll back up here real quick. Good to see you, of course, Transplanted Texan. Always holding it down. Oh, by the way, we are going to be playing YSL Bingo. If Transplanted Texan has already dropped that link in there, I'm not certain. If you want to, no, everybody's a winner. So we're just having a good time paying attention during this. So the YSL Bingo link will be dropped in the chat in a moment as well, if it's not already there. Good to see you, Robin. Thank you so much for stopping by on this morning. Now, I love it. Rose, good to see you. Thank you, Rose, for stopping by on this morning. If you don't mind, why don't you just tell us real quick, give me in a quick summation, how are you feeling about this trial so far? Do you feel like it's going the way you thought it was? Maybe, I mean, you must be Nostradamus, because I don't think anybody saw it exactly like this. But how do you feel about this? Let me know what you think in the chat. Good to see you, Nora. Nora, thank you so much. Cocoa Beach is in the building. Good to see you. Thank you so much as well for stopping by on this morning. Hey, my pleasure. I'm enjoying this streaming. Now, I do have a meeting this afternoon rather, at the studio. So I'm going to try my best to either A, get it rescheduled, or B, we might call it at lunch, but I'm going to let you know for certain. I'm just interacting with my engineer. If I have to, we might call it, but we'll see how it goes. All right. Good to see you, Angie. Thank you so much for stopping by. Appreciate you. Shannon is in the building. All right. A good morning from soggy South Carolina. We need a little rain here in Georgia to cool it down a little bit. All right. What does Donna say? Siswit wants to have the trial, but the state is going to lose it for them. Oh, in my opinion, this trial is 100% the state's loss. I mean, they got their hand wide open on a windy day. And I mean, that's it. The state is going to lose this. There's so many ways for them to lose. I think that's a foregone conclusion in my mind. The defense has so many ways to collect the W on this. So many ways. Heather says, good morning. Found your channel yesterday. Thank you for the breakdown. Wow, thank you so much. Wow, so I guess you are a day 105. If we're looking at this trial as using it as a barometer, you're a day 105. That's wild. Welcome, Heather. Good to have you. Yeah, I am really interested. All right, so I asked before, just give me a quick summation. What do you think about this trial so far? And OG says off the rails. Is that an understatement of the year or what? Ken, good morning. Good to see you, sir. Lots of surprises and failures happening. Lots of opportunities for improvement. I agree. Like, I think this could be this case could be a class on how to mess up a trial. There's so many things that are wrong. Matter of fact, like, watch this. This is something I noticed, yet I thought about it after the fact, because you're processing this later on sometimes. Judge Whitaker actually made a serious error during Melnick's testimony, when Melnick was sitting in the witness booth. Do you realize that Kayla Bumpus was in the courtroom? Do you also realize that investigator Long was also in the courtroom? Both of them later on testified. They couldn't do that. They weren't supposed to do that. You cannot be in the courtroom and give a testimony. You can't do that. So now, granted, I realize they kind of called Kayla out of the blue. She wasn't expecting to come up, but she shouldn't have been able to come up. She should have had to wait another day or not so much at all. Same thing with Long, I think his name was. Neither of them should have been able to testify yesterday. Those are just some small things that I recognize. And again, I'm not even a law student. I call myself a pre-K law student because I know nothing. It's going in circles. That right there, that whole thing about the email, it was in circles. Just when you think you figured it out, it takes a twist. Absolutely. There's a plot twist all the time. I agree. All right. Q's going to be in a meeting today. You said I'm going to be in a meeting, but it doesn't mean that I haven't hit that like button. I hit that like. Did I hit my like button? I did. I got it. The like button has been assaulted. Absolutely. Yesterday was the craziest day yet. I hope we won't have a repeat today. Really? I personally think Woody was probably the craziest day because nobody saw it coming. We all were like expecting it with Melnick. We're like, something's gonna happen, something's gonna happen. Woody came out of the blue, like that whole, how old are you, grown? What does that mean? I'm of age or whatever. We didn't see that coming. The pleading the fifth, that was something different. So, okay, I'll give you this, Richard. As a sustained train wreck, yesterday was a long train wreck. Woody was a surprise that we didn't see coming. There we go. Long and messed up, Lovey says. No argument for me. I'm with Max Shard, Mimi says. Happy to finally have a judge that has stopped all the prosecution shenanigans. Judge Whitaker is a breath of fresh air. No argument for me. I agree. I like Judge Whitaker. It's telling how black justice looks on the inside, especially if compared to Baldwin case. Oh, un momento, por favor. Woo, today is starting off like that. Today's starting off with a right and an uppercut. All right, we're back though, y'all. Thank you so much. All right, law and crime has not kicked off this. Let me bring this in though, just so we can keep our eyes on the prize. They have not started yet. All right. All right. So I ask, what is your assessment? A one sentence assessment of this case so far. Hot garbage on a tin roof. No argument for me. Good to see you. Good to see you, Rebecca. Thank you so much, Rebecca Starr, for stopping by. All right, let me see. I think this is it right here. The state overreached with the entire case. I think that's the end of the sentence right there. That's probably the biggest example. Now, I did do a little bit of research. Like New York does RICO cases all the time. They got some big, giant gang RICO cases. They just did one. They just like arrested like 12, 20 people, something crazy just this past 2 weeks ago, right? To me, those are different. I mean, and another thing is there are like 9 government and federal agencies that are involved in that case up in New York. I might have to pull it up and talk about it. I don't see that same kind of veracity here in this case. It just seems like I hate to say it, it just seems like Fonnie Willis just wants to bring a RICO case. Whereas in other situations, I see lots of GBI, CIA, lots of letters, alphabets working together to bring against this RICO case. Here, I didn't see all of that. Maybe they did. Maybe they did. But it doesn't look like that. And so that's part of the problem, I believe, is they haven't even pretended to be ready for court either. It's a hot mess express. I agree. Like, tell me what, and I asked this last week, tell me who did what crime so far? According to your understanding, what crime was committed? At the current moment, yesterday, the crime was sending an email and cutting and pasting it so you can print it and having an ex parte meeting. Those were the crimes that we know of so far. The state can't even prove that I have a green hat on at this moment. That's how bad this looks. So I'm with you. They overreached and they definitely were out over their skis. Good to see you, Carrie. Good morning to you. What's going on, Black Law student? There he is. And everybody, do me a favor. Black Law student and Thugger Daily. If you are on Twitter, formerly known as X, please make sure you're following those two individuals, Thugger Daily and Black Law Student. Black Law Student, I think it's the hood_lawyer on Twitter. Please make sure you follow those guys. They are doing fantastic work. And really, all of LawTube and all of us pre-K law students that are talking about these cases owe a debt of gratitude to Black Law Student and Thugger Daily specifically, because they keep all this stuff, this information coming to us. So hats off to them. Thank you so much. Joanna says she's waiting for a mistrial. Corruption everywhere. Got to love Judge for her patience. I don't know. Yesterday, she was showing a lot of like, look, I done had enough of this. There was a lot of bless your heart, shall we say, going on yesterday. She probably said some other words after after the cameras went off. She seemed like she was having enough of this from everybody. Everybody was getting it yesterday. Yeah, Kayla did say yesterday that Woody was at the courthouse. I hope not, but he probably was. At this point, it's just becoming a dumpster. It is becoming an absolute dumpster fire. And I think you make a great point here, Matt. This is the USA every day. Nothing out of the ordinary. They just got caught and it's public. That's it. And I think that will be the takeaway from this young thug trial is the fact that we caught this in 4K. And I do think there's going to be opportunities to make corrections if we want to make corrections, or if we want to continue business as usual and the status quo, then it'll be what it is. I do think we should look at and consider how can we do better than what we're doing right now, because this is a mess. I don't think race has to be at all. I think it's in my opinion, is actually a cheap shot. Jess. If you watch my video where I called racism, I'm making fun of the fact that actually I'm making fun of the climate of America today. Because here we don't actually see racism. We actually see what most of us usually see: somebody doing the right thing, wanting to do the right thing. And it doesn't matter about their ethnicity. Kevin says, "What Kevin Crowell? What does he say?" But they let Nuts dad sit in the court for weeks before he got on the stand. Okay. If they did, then I think they were wrong for that too. They should not have been. I don't think they should have. All rise. The honorable black law student is here. There we go. Let's go ahead. All rise. You're out of control, man. Out of control. Lots of good family reunion. I love the conversation back and forth. Good to see you, Jarena. Fantastic content creator, making great content over there as well. Jarena, don't hesitate to drop your link in the chat and let us know what you are working on now. Thank you. Do I know Greek? I do not know Greek, Donna. I do not. But in the words of James Brown, I know Careza. All right, let's see. Grace and peace, Patrice. Good to see you, friend. Good to see you. Good to see you. All right. Yeah, long cry. Wait, am I on pause? No, I'm not. Okay. Yesterday I was on pause. Okay, now let me just refresh the screen real quick. I made a rookie mistake yesterday and was sitting on pause. Okay, here we go live. Nope, it's not. All right, I was sitting on pause yesterday and the court had already started and I was missing it. So I'm making sure I'm trying to be on top of this game, trying to be on top of this game. Hey, Gino, thank you for the very kind super chat. What does Gino say? Here we go again. Respect for you from Amsterdam. Well, thank you so much. That's another thing I think I appreciate the very kind super chat. I think another thing that we have to keep in mind is this case is now international. All eyes are on Fulton County. Win, lose, or draw, good or bad, people are looking at Fulton County and they're taking an assessment. I mean, most people, again, globally can see that there's something wrong with what's going on. Even if you're in the most kangaroo, banana republic system possible, some of y'all can say, yeah, something's not right there. And they're seeing it in 4K here in Fulton County. And we're on display. Dear Fulton County, let's fix this. Let's do the right thing. Because there's people all the way from Amsterdam and the Philippines and South Africa and Australia, all over the place, and way far away, like Cobb County, Georgia, that are watching this and they're seeing how we treat. I mean, there's a lot that can be learned from this, and how we treat the judicial and the law system. I think we should be aware of that. We should treat it with respect. Thank you again, Gina, for that very kind super chat. Thank you. This case has made me, whenever the bat phone goes off, you got to check to make sure somebody's not telling you. I want to make sure somebody's not telling me I missed something. All right. This case is not kicked off yet. Is Judge Whitaker running late? Oh man. Y'all, we're gonna have to revoke her wit card. Uh-oh, Judge Whitaker is late. Free YSL. I mean, at this point in the game, and I've said this before, like I don't know if these men committed the crime that they're being accused of. That's the state's fault. That's the state's fault. We should all be very, very clear. After 106 days of trial, and we're not talking about all the delays and all the other shenanigans. By that point in the game, everybody after 106 days, everybody should be convinced. There should be nobody. My cup of coffee should be convinced that these guys are as guilty as today is Tuesday. But at this point in the game, I don't even know what they're guilty of. I don't even know what they're here for. Are they here for a traffic ticket or killing somebody? I don't know. The state has proven nothing, and that's their fault. So at this point in the game, I'm with you. Free YSL. Why hold these men? Why hold them in jail when you don't even know what you're doing? Adrian Love, Simone Hilton, Fonnie Willis, and the whole shenanigans. Why? Why do they get this? Why do they have to stay? Because you don't know what up and down is, left and right is. The irony of the anti-corruption guy was hysterical. I agree. Yesterday was a lot. There was a lot of different twists and turns and ups and downs that really just, I think, encapsulated just how crazy this case has been. Yesterday, crime was Kayla pretending to be. Y'all put Black law student in 0-second timeout. Please put Black law student in 0-second timeout right now. Somebody put him in timeout right at this second. I don't even know what to do with you, my guy. I'm gonna actually find your name and I'm gonna put you in timeout. I can't find you. You're hidden on my end. I don't know why I can't find it. I'm gonna put you in timeout though. Once I find you again, you're going into timeout, Black law student. You wild. All right. Yo, I mean, Judge Whitaker is really, and this is another, see, this is the thing I like about these types of situations where we've watched them so long and we've been able to compare and contrast. Donna says this, Glanville, by letting the state do this terrible job. A lot of this is because Judge Glanville let them slide. He gave them so many passes, it didn't even make sense. He was giving homework. I'm a former classroom teacher. He was giving homework passes all the time. He was giving homework passes for end of the quarter tests. He was giving homework passes for everything. I mean, he was letting them slide by. And now the Judge Whitaker is holding their feet to the fire is looking really, really bad for them. Now, granted, it'll look good for Judge Whitaker because we're late, but maybe she's going to come in here and maybe she meant 9 o'clock today. I don't know. It clearly everybody thought 8:45, but I agree with you, Donna. Thank you again for the super chat. And that is very kind. Thank you for that. The state is like using the who's who of hood snitches and rumors and submitting it as ironclad evidence at any cost. Y'all, I don't even know what your name is. I can't even pronounce that. Egregiously darkly, but that is so true. That's so true. Matter of fact, y'all just type dark in the chat because I'm sorry. That's it right there. There's so much conjecture. There's so much I heard. There's so much didn't this person. I'm sorry. I think it's hearsay. It's dang near gossip. They on trial and getting gossip. Like, I agree. Y'all type dark in the chat. That's it. That is it right there. And I don't know where Judge Whitaker at. But no, you are on the money. Teresa says this. I believe this should be enough to finally call it mistrial with prejudice. Honestly, think she is still leaning toward continuing this trial. I think she does want to continue this trial. I think she does. I still believe that she should call. It should be a throw in the towel. I mean, however, yeah, I've talked to 2 or 3 legal minds that know way more than me. And 2 of them said, yeah, she's going to keep this thing going. She's got it. She's got it under control. She's going to get it back on the highway and she's going to drive it on the way in. It's going to be shorter though. This is the thing also. If she does, I don't believe that it's going to be nearly even remotely as long as it's been so far. And the reason being, if you ever want a good laugh, go to Law and Crime, go to their live streams, go find all their YSLs and just scroll through. Go back to like the early beginnings and just watch. There is absolutely not one trial, one video of the trial that is longer than 5.5 hours before we got Judge Whitaker. Once we got Judge Whitaker, we're cruising at 7.5 hours, almost 8 hours sometimes. Never. There's not one video. And mind you, those videos also got these extended comfort breaks. They got long 2-hour lunches, so on and so many pauses. But now that we've got Judge Whitaker, we're looking at they've almost added a quarter of the active time on camera, and they're actually working. Let's be honest. Yesterday, there was a lot of work done yesterday. Friday, there was even more. And that, again, they're bumping up at almost 8 hours of time in the booth. That's a lot of time. So I'm going to go, even if Judge Whitaker keeps this thing on the road, I think she should let it go. But I digress. Even if she's able to get this thing back on the road, because we still got to get the jury back. Even if she does, it's going to be fast. I'm going to say by Thanksgiving, this thing is over. Oh, here we go. It's live. Let's go.
To support the position that alleged violations of the rules of professional responsibility are sufficient to support disqualification.
Drop a 1 in the chat, please, if you can hear.
For a couple of reasons, Your Honor, I just ask that the court allow us definiteness on what grounds the court will continue to hear motions to disqualify. I know that we started out with the witness, that we were a necessary witness, and then after the June 7th transcript came out, there were other grounds. And today I'm addressing the ones that have been proffered by the defense. But my take on Ford is that it, like Piedmont Hospital, which Ford cites, they're both obviously cases regarding civil matters. And I think, Your Honor, that it's interesting that both of them also involve conflicts of interest. There are cases within the state of Georgia that do involve disqualifying prosecutors in criminal cases. And of course, there are, two general grounds. We've addressed that in a previous response. But as it relates to this, our position is that all that Ford does is addresses whether two attorneys who appeared pro hac vice violated the professional rules. And it specifically authorizes the trial court to consider those rules when considering whether to revoke the pro hac vice admission. That is, the question was whether the attorney who is not a member of the Georgia bar would be allowed to practice in Georgia. And of course, that's not the issue here. Ford cited Piedmont Hospital versus Reddick, which had held that it was appropriate to consider the professional rules on a question of disqualification. And one of the claims at issue in that case was whether an attorney for one party violated the professional rules when it contacted another party's board members and employees. And if true, that was something that the trial court could consider in a motion to disqualify. The Court of Appeals emphasized that the right to counsel is an important interest, which requires that any curtailment of the client's right to counsel of choice be approached with great caution. Disqualification not only curtails a client's right to counsel of choice, but results in expense and delay that are costly both to the client and to the administration of justice. And they go on to say that courts have been reluctant to disqualify an attorney despite misgivings about an attorney's conduct, perhaps because disqualification has an immediate adverse effect on the client by separating her from counsel of her choice. And that's Piedmont at 76 through 77. Finally, the court held that a party did not have standing to base a motion to disqualify an attorney to file a motion to disqualify an attorney based on a conflict of interest violation that did not involve that party. In Piedmont Hospital, the claim which was rejected was one entity's claim that an attorney was disqualified because of a conflict of interest, where that entity was not in an attorney-client relationship with the attorney. Here, Your Honor, the state did not violate the professional rules of ethics. We didn't violate Rule 4.2A regarding communication with an unrepresented person. The court has heard the testimony of Mr. Melnick, and the court can gauge the credibility of the witnesses after Attorney Melnick informed the state that he represented Mr. Copeland. The state had no further conversations with Mr. Copeland about the subject of this case without either Attorney Melnick or Attorney Bunkers present. And in its response to Mr. Melnick's email, the state agreed it wouldn't communicate with Copeland further, but noted that we had arranged for transportation and that an investigator would pick Mr. Copeland up the following morning for his court appearance. So that interaction was to bring Mr. Copeland to court as we had previously planned. For the reasons that we've stated in our prior filings, the hearings in chamber were proper. And even assuming arguendo that the court concludes otherwise, the state acted in good faith based on its understanding of the law. Indeed, at least 2 judges so far have concluded it was not improper. Disqualification is not an appropriate remedy under any event, especially given all of the circumstances here. We would ask that the court deny the defendant's motion to disqualify, and if there are other grounds, we would ask that the court, if they bring other grounds, we would ask that the court require that they list out all of the grounds that they're seeking so that we can address them at once, with Your Honor.
All right. Well, I think both Mr. Weinstein's and Mr. Shark's motions that are pending right now, Mr. Weinstein's for a mistrial and Mr. Shark's for a fair trial, set forth additional bases and suggest that as one of the potential remedies or grounds for relief. So I think the state has filed a response to Mr. Weinstein's motion on behalf of Mr. Kendrick. I don't know if y'all filed a response to the supplement, and I don't think I've seen a response to Mr. Shark's amended motion for a fair trial. So
filed Friday.
Yeah, that was filed Friday, and I'm not quite sure when the supplement was filed, sometime last week.
Okay.
So if y'all want to get something to me, can you get me something
Today.
When can you get me something?
Is Friday too late?
Yes.
You can get me something by Friday.
Oh, thank you.
Okay.
I'm sorry. She didn't write that. I'm sorry. I'm not trying to be anti Adrian Love, but she just read somebody's report.
And so I assume you have made the determination not to present any further evidence on that one issue about whether the state was aware of the proposition that Mr. Melnick might be representing Mr. Copeland. Is that correct? Okay. All right. Yeah.
One more thing. We did receive the communication from Mr. Steele regarding proffers, and if an attorney rejects a proffer and insists on evidence.
With regard to Copeland or?
He said it generally.
Oh, yeah. Oh, okay. No, proffers from an attorney. Okay, yes. Mm-hmm.
And so to the extent that that is the way that that we would move or operate, we would to therefore require, if we're going to put up evidence, we're going to put it up. I don't know how the court views proffers, and I.
Well, I mean, I think that the case stands for the proposition that proffers are fine unless one party objects, in which case then you need to present evidence. And so.
And so if that's the case, we would ask to any circumstance where proffers, we would, if we have to put up evidence, we don't want to be dueling proffers. evidence is evidence. Where properties are okay, I'm okay with that.
Okay, thank you. All right, how about on the discrete issue of the phone calls, jail calls?
Yes, Your Honor. So I went back and reviewed what all we covered.
Oh man,
So
poor brother, get off of him.
5 jail calls.
Get off of him.
Mr.
Leave my
Copeland.
man alone. He
And I
is,
also confirmed
yo,
with
it's messed
Mr.
up.
Sharp, Mr. Steele, we were in agreement that we handled those jail calls related to Mr. Copeland on Friday. Well,
Okay, I'm sorry, I just thought there were like 2 things outstanding that y'all said, let us huddle and then we'll get back to you.
That side was savage. That
So,
side was
I'm
crazy.
incorrect in that recollection.
in relation to the
Jail calls.
Jail calls, yes, Your Honor.
Okay, so, okay.
Great question. I'll answer in a second.
Well, can y'all do me a favor then and refresh my recollection about what it was that was decided about the jail calls? Because I don't remember y'all putting anything before me. Did y'all just come to
Make it up
agreement,
on
but
your
y'all
own?
haven't told me what that is?
Your Honor, there was some that we agreed on, and there was,
Mm-hmm.
other parts where, like, for example, one of them was detective Gaither. He asked if we could, you know, basically we either agreed or redacted or argued those 5 calls. And it was at the very end on Friday.
Okay.
And I will get, Deputy Hilton had the notes from that, and so I will work on, and we'll get those notes from Deputy Hilton.
Okay.
And capture as well, we discussed in our.
Okay. All right, so then moving on to our next issue. Yes.
Good morning, Your Honor. Good morning to everyone. I agree with Mr. Atkins, and we spoke last night. I think that the only outstanding issue on the jail calls for Mr. Copeland, the 5, was the redactions, and the court ordered us to look at it and then bring up any other issues with your court. So that's what I have in my
And
notes. And I
that's
think,
what I'm talking about.
and I think,
So,
yeah, but I don't think that the state or us have done that redaction yet. I think the state was trying to do it. If I'm wrong, Mr. Atkins, please correct me, but that's what I thought we discussed.
Yeah, and so, right when we left court yesterday, when you and Mr. Shard spoke about the jail calls, and remember I had asked, we covered everything with it, and we were in agreement? Yes.
That's right. And then the only thing we have to do is the redactions, and we have to look at them. That's my.
yeah, so I think that there was, I mean, I've got highlighted now, I made a ruling on those things. So, okay. So, but yes, there was still something outstanding y'all needed to do. So
Yes.
those 2 little pieces of redaction, I think. And y'all were going to get together on that and figure out whether you could come to agreement.
Yes, Your Honor. I will speak with Mr. Steele, Mr. Sharp. I guess there was some miscommunication because we spoke yesterday afternoon and thought everything was recorded.
That laugh.
I will speak with them expeditiously.
Okay.
to rectify that.
All right. Thank you.
That laugh right there is serious. She's like, man, what are you talking about?
All right. So then our next sort of big topic we need to sort out is what, if any, part and how we're going to handle the fact that Mr. Copeland gave testimony prior to the motion for recusal and then further testimony following the motion to recuse. And we all kind of agreed, okay, things that occur after a ultimately granted motion to recuse basically need to be redone. But if everybody can come to agreement as to, you know, these things, these parts of the testimony
Keep
are
Woody on the
okay
stand.
anyway, then y'all can by agreement say these parts are okay and we can move forward. So have y'all gotten together now
Keep
that
Woody
I
on the
believe
stand,
you
y'all.
have
Y'all want him.
all of his testimony thus far to decide what, if anything, you think, how to handle it and what you think might need to come out, if any part?
Judge, we had been in communication with the defense, and I believe that the last time that Ms. Hilton spoke with Mr. Sharp, that they were representing that the defense would get together and see if they came to some collective understanding about what it was that they wanted to stipulate to and get back with us. But if I read correctly last night, they indicated that everything beyond the point of Mr. Kendrick's motion, they wanted to do over. If I read that wrong,
I don't know. I mean, if y'all had email communications overnight, I don't know what those would have said. But does somebody want to represent to the court what the defense position is, if it's a joint position?
Your Honor, I can speak on behalf of Mr. Williams, Mr. Stillwell, and Mr. Kendricks. The stance is that everything post the recusal needs to be redone.
Okay.
Just because we feel that that's
Yes,
applicable
right.
law. And
We want Woody's statement. We want Woody to be on the
Where we're
stand,
at.
y'all. Don't start over
All
from zero.
right. What about Mr. Matthews? What's
Good morning to the court. On behalf of Mr. Healy, we are in agreement that everything posted in the future file should be taken from her.
okay? And then Ms. DeWilliams, what's y'all's position? Speak into your microphone, please.
Same position as Mr. Matthews, Your Honor.
Okay.
Who's that?
All right. So I've got another question for the
Oh,
defense,
you?
and that is, I think that everyone has joined into the assertion in both of the pending motions that I mentioned before that the
I apologize for interrupting the court. I think there was one more party that.
William Stillwell, Kendricks, Huey Ryan. Oh, guess, I don't know. Sorry. Nichols.
Clearly the forgotten person in this case who should be severed and who continues to object to the admission of any of Mr. Copeland's testimony against Mr. Nichols. So our first position is we object to the admission of Mr. Copeland's testimony against Mr. Nichols. Second position, that if it's admitted, it comes in with a 105 instruction.
All right, I've asked you a couple of times to give me a proposed one.
Yeah, we have it. We
Okay.
have it. We're going to give it to you prior to the time the jury comes in, if it comes in, because that's still outstanding.
Okay.
And number three, we would, as the third layer, and alternatively, we would join the motions on the floor.
Okay. So on the proposed limiting, I mean, jury's coming back before too much longer. So go ahead and get that to me and the state so that we can contemplate language and whether, I mean, I think it would be appropriate to give, so, but don't wait till the evidence is coming in. Give me a chance to look at it beforehand.
Assumes the evidence is coming in, and I don't make that assumption since the motions are still outstanding.
I'm trying to cover things in terms of eventualities and, you know, conditionally and things like that. So I understand that. I hope you're not chewing gum. Are you chewing gum? Okay, great. No chewing gum in class. All right. So It's my understanding that everybody has joined in the position that Mr. Copeland's testimony was coerced based on what occurred during the June 10th ex parte. So, and yet I know at least some of you want that testimony and said that yesterday. So are you waiving the issue of its potential coercion?
You should.
And good morning again, Your Honor. I am not waiving.
Really?
that
All right,
issue.
so then how do we handle that?
I thought it's two states. I was answering your question. If Mr. Copeland's resumes testimony, then my understanding of the rule is, or the law, is the way that the court announced, and I think all parties understand it, that once that motion by the Honorable Douglas Weinstein was filed on the 12th, everything thereafter is excluded and we redo it. And that's what we, Mr.
Right.
Atkins sent an email last night. That's what three of us responded to. I don't want to waive, though, the issue. I thought we should have a hearing with Mr. Copeland to determine did that in camera, if it's in camera, ex parte rather,
Okay.
June 10th meeting, did you feel intimidated, coerced under the Archer case, which from Maryland, I know it's from Maryland,
Right.
that we discussed? And if yes, we were going to ask you then, if a witness was intimidated, that he should not have to testify. You know, he could choose what he wants to do, and then we would strike everything. He said.
Okay, well then let's go ahead and find that out. I mean, can you get him here so that we can explore that issue? Because here's the thing is that, yeah, if you know, everything after June 10th, whether the recusal motion was filed or not, that's kind of a
Oh,
separate
please let
issue
Woody come in today. That'll be
from,
fire.
whether his testimony post June 10th ex parte meeting was coerced. And if it was coerced, then what then? Do we, then how do we still say, oh yeah, but I want, you know, some of that testimony? That's still good.
I thought you, and listen, I have so many, you know, going on. It's just the reality of our case.
Yeah.
But I thought you said that either yesterday or last week, that we will find out whether Mr. Copeland actually wants to testify, continue
Right.
testifying. And then if he doesn't continue testifying, my understanding of the law is then he would never have been given an opportunity to be cross-examined.
Right.
And therefore you strike all of his testimony. Then you give the command to the jury that wipe out everything that you heard, saw. There were writings introduced, all exhibits are struck. Give me your notes.
Right.
That's what I thought. Now,
Okay, I just didn't understand because, you know, and thank you for clarifying, because what I was trying to sort out is, are y'all kind of taking the position, it was coerced, you know, we have to redo all of it based on the coercion, but then also, yeah, we want to keep parts of it anyway. So if it's a, yes, if it was coerced, then we need to redo all of it. Or, you know, find out, does he at this point kind of redo are you intending to take a stand and testify, or are you going to be held in contempt?
that's what I thought.
Okay. All right. Just so sounds like, well, then we're on the same page. Just wanted to make sure y'all weren't wanting it kind of both ways. Ms. Levy, you look like you want to say something.
I was trying to get a full grasp, Your Honor, on everything that was being said. And when I hear that we're looking into whether or not his testimony was coerced, of course I'm going to defer to the court. I would object to that for several reasons. One of which is that the court has had an opportunity to review what went on there. And I believe that based on what is there, right there.
Bring us Woody.
The transcript, the court can see, and I believe could make a determination that there's not coercion. So based on the way that the witness has conducted himself, and based on the concerns that we have expressed, the concerns that the witness expressed during prior interviews before I even came onto the case.
Mm-hmm.
I would ask that the court not revisit or go back and see if have a hearing on whether or not he felt coerced.
Okay, so this isn't a revisiting of the issue because the issue is live and still pending before the court in Mr. Kendrick's motion and supplemental motion for mistrial and in Mr. Shart's, on Mr. Stillwell's behalf, revised motion for a fair trial. That's a big claim in both of those motions. And I mean, I just gave you to Friday to respond to them, but and yeah, I think that on the record, it's a legal determination to be made. We don't necessarily need to hear from Mr. Copeland because I'm not sure about Mr. Copeland's credibility on anything anyway, but
And so for those reasons, I would ask the court to not have us bring him in before that time that he has to testify. I'd also point out that his counsel was present
I know.
throughout. So thank you for hearing me.
Okay, well, I mean, I hope that it is not up for debate that some of what was said to Mr. Copeland in terms of potential ramifications if he didn't testify was incorrect. I don't think that there was any kind of
Thank you so much,
you know,
Gino, for the super chat.
purposeful or nefarious motive in that. But I mean, at least with regard to the notion that he could be held until the trial of even the severed co-defendants was completed, I don't think is a correct statement of the law. If you believe that it is, then please provide me with what you're basing that belief on. But I mean, I also don't think that he paid much attention to that at all. He doesn't even seem to have, you know, I mean, he kind of basically moved on from that, but that was incorrect. I think that some of the assertions about statute of limitations potentially were incorrect. I don't think that with regard to he seemed to be worried about a particular crime, the statute of which had apparently already run. But I think that in terms of the notion that he faced no potential jeopardy with regard to crimes based on statute of limitations. I mean, there's the immunity issue, which is wholly separate, but y'all are basically saying you don't even have to worry about it for the statute of limitations reason. They're saying, well, then how are we sitting over here charged with RICO for crimes, the statute of which, you know, this when the statute has run on the overt acts, they're in support of the RICO. And I can't remember right offhand what the other potentially incorrect
There was a
statement
lot. There was a lot of
about.
mistakes.
But, I mean, some of the this is or isn't perjury things are a little, I don't think, quite exactly accurate either.
Okay.
So I mean, I guess what I'm saying is you run a lot of risk, even if I say
Wow.
it wasn't coerced, if that is the legal determination I make. I mean, I'm saying it's a really close call. And it might be better to just pretermit that issue and deal with it a different way.
Wow.
Okay, so when that took me to the question I had yesterday, that I thought I had gotten completely wrong with respect to the motion to compel that we had filed. Because we got to a point where he's trying to not testify. We would, of course, ask the court to compel him to testify. And the things that have happened. And he was, as I said, he was represented by counsel is of course already acknowledged, but I do understand what the court is saying, and I will respond to the motion.
Okay. But I don't want to be dealing, and I can give you to Friday to respond, but I don't want to be us having no idea what we're going to be doing Monday
Friday?
morning. I want it sorted out this week.
Like right now.
And your motion to compel was filed when? To compel his testimony. I mean, that was, yeah. And the order was entered on the 7th. And I don't think there's any issue that can still be in effect. I don't think we need to redo that. If you want to redo it, and I'll consider it anew. But, I mean, the more prudent course would really be to just bring him in here like tomorrow.
Today,
and
right now.
Say, and if anybody wants to come up with, he's probably been advised ad nauseum about everything at this point anyway. But given that I just said, I think some of it's incorrect, a correct advisement of here's what the issues are, here's what you potentially face. And we're going to do it in court with everybody in front of us. Y'all can have some input on what he is advised of. Does he have counsel currently? I know he's gotten rid of Mr. Melnick and Ms. Bumpus at this point.
Yes, that's correct, Your Honor. Mr. Melnick withdrew representation. His Bumpus was fired, so no one has said anything to him
Okay.
about a lawyer on his part. So we are unaware.
Why don't y'all wait and just ask him to get a lawyer?
Any,
Okay.
representation. And I also point out just that since he is still under that immunity grant from the state, it's my position is that anything what he testifies about would not subject him to criminal exposure. We can't use it. We can't go out and.
But the feds can.
Yeah, and I agree that with regard to the immunity, he doesn't, but it's because of the immunity. It's not because there's some statute that protects, some statute of limitation that protects him from criminal liability. It's the immunity that would protect him. And he was not exactly accurately advised as to that, I don't think, at least potentially. Okay. So, I mean, I just think it might be cleanest to give him correct advice as to all of it, and then find out what his intentions are. Would that work for everybody? Can I get an affirmative if that is in fact the case, not just a, like on the record, yes, if it's a yes.
I'll be back from Ms. Williams, yes.
Okay.
Yes. Yes, Your Honor.
Yes, Judge, with the caveat that no party, no state, even though they say it's our witness, not have any communication with that person while he's on the witness stand, which he still is, presumably. Thank you.
Okay.
And Your Honor, with respect to Mr. Harvey's request of the court, I would openly request that the court allow us, because like we have had to transport the witness, I request in front of everyone that the court allow us the opportunity to continue transporting him, doing as we have been.
I mean, he's under your subpoena. Y'all are the one that needs to get him here, but no substantive conversations.
Woody can drive a
Understand?
Hellcat,
Okay.
race a ATV.
All
This
right.
is crazy.
And y'all think you'll be able to achieve getting him here tomorrow?
Your Honor,
Can you get him here this afternoon? I mean, no, that's fine, but can you get him here tomorrow?
I believe that we can.
Okay.
And Your Honor, how much inquiry is the court going to allow, or examination?
We don't need to examine him about that. What we need to do, I think, is, given everybody has agreed, is just properly advise him as to what the immunity order means, what the consequences or potential consequences of refusing to testify regardless of the immunity order mean, and find out what his intention is. Okay, so I would love to get from y'all a proposal on what to advise him of. And let's let everybody kind of agree to it before we do it.
They're not going to agree.
And then it might not be a bad idea to have counsel for him. I don't know whether he's going to want to hire somebody, or whether he is, I mean, he's not a criminal defendant, so he probably wouldn't be entitled to counsel from the public defender's office, but maybe I can find somebody willing to take it on, whether he can pay them or not. I don't know.
So, Your Honor,
Suggestions?
Your Honor, when the court just said about compelling him to testify regardless of the immunity order, we wouldn't seek to compel it without it because there is potential criminal exposure.
No, I know. I think you might have, I didn't mean to say that. The consequences if he does not testify despite the order. Any ideas about counsel? I mean, I think he's probably entitled to counsel if he wants it to advise him. I don't know. Hadn't done the research on that one.
Your Honor, on behalf of Mr. Williams and I think the rest of the defendants, it seems to me most appropriate for the court to at least inquire of Mr. Copeland himself, whether he is currently represented by counsel or not. Facts.
That's a good point.
And or what his intention is if he is not.
Sure. I mean, yeah, I agree.
Y'all just assume he didn't have one.
I guess I can't find that out before he shows up here.
Go online. He online. He probably in the chat.
Okay. All right. I mean, yeah, if we can find him and even, I mean, I don't care if he shows up by Zoom for me to ask those questions, you know?
No, we
That's
want him in
fine
the
with
building.
me.
We need Woody in the building. This is crazy.
All right. So if he ultimately then says, yes, I'm fine with testifying, then does everybody want to start everything over, have me tell the jury, we're doing a do-over to all of it and start over with him? Or then do y'all want to agree to using some portion of what he's already testified to, some or all of what he's already testified to pre-recusal motion? I can't hear you.
Yeah, this is so crazy. Judge Whitaker, this
Y'all
is
can think about
embarrassing.
that for a few minutes. Ms. Firstfields let me know that the 6/12 transcript, which was the last outstanding transcript of his testimony, has just been completed and is getting mailed out to y'all, emailed out to y'all. All right, so y'all think, ponder, and in the meantime, do we want to move on to the whatever motions in limine there are about Mr. Zachary? I think you said you had at least a good portion of that ready.
Yes, so counsel for Mr. Stillwell sent over a series of redactions that they'd like to see made, but we have objections to those, and so that is
Okay.
criteria.
All right. That sounds good.
Would the court permit me to just step out?
Sure. Is Mr. Atkins going to take it from here while you're
No,
out?
I'm just asking them about Mr. Copeland and see if I can get him on the phone and get an answer to the court today.
Okay. All right, so.
Please come in
The
today.
Zachary
Please come in.
evidence, can somebody provide that to the court? Whatever we're going to be
Yes, Your Honor.
sorting through.
I'll send the transcript from this interview, Your Honor, and if the defense counsel objects, I can send what Mr. Shard sent us so the court knows what
What we're walking through.
Yes, Your Honor.
That'd be great.
Because it's broken down by numbers.
Okay, good.
And does the court already have the transcript?
I do. No, but Mr. Atkins just said he'll send those.
And Your Honor, with respect to the transcript, they are uncorrected. There may be corrections that I make and then send to the defense.
Okay.
Make sure you like this video.
Yeah,
everybody.
and
Make sure
maybe
you hit
pick
that
up
like
your
button.
mic. And y'all, I'm trying, I think I told y'all yesterday, I'm trying to get longer stems for these, but
I didn't even turn my mic on, so I didn't even get through step one yet, so.
Wow.
It's now on and I am holding it. Mr. Atkins, Ms. Love, Mr. Zachary's statement, his statement that I did not review yet or I've reviewed it, but I haven't given you the total redactions. Are you planning on playing if allowed, the part where he talks to the AT feds about the guns?
It's possible, and there were two statements.
you should talk into the mic too, so everybody can hear you.
I keep remembering how loud I am. It is possible, and there were two. Yeah, I think yesterday when I spoke, I was expecting one more from you. There are two: the 2015, the August 2015 one, and then I think it's the March 2017 one. And we have your redaction request for the the August 2017 one. So do you mean for both of those, or are you just asking about the March 2017 one?
The transcript doesn't, I don't believe, say what date it was, but the time he talked to the federal agents after speaking to Investigator Gaither.
And so when you say put it in, I wouldn't, outside of impeaching him, I wouldn't have a need to put in all of that. I would be asking the witness on the stand about that. So I can, with the court's permission, I can break away and talk to you about exactly what it is that you're concerned about.
Okay, well, I'm gonna send over my proposed redactions for the statement to Investigator Gaither with the understanding that I didn't list out any redactions for the discussion with the federal agents.
Okay. So you're sitting over the 2015 one? And then,
Yes.
okay.
All right, so there's one that has been done completely, the proposed redactions, right? So we'll just start on that one, and then I'm sure we'll have a morning break at some point. Y'all can maybe, if you need to huddle more on the another one, then that's fine.
Thank you.
All right. I have no idea. This is crazy. There's no way this is not like a Saturday Night Live skit. I don't care what you're saying. I'm sorry. She literally told them that they were breaking rules. But she's letting them continue. I don't get this, Judge Whitaker. I'm sorry. I agree 100%, Cindy. I'm sorry, right here. I agree right here, Cindy.
Transcripts of Zachary's potential, I mean, I guess it's statements over to Ms. Persfield or?
Yes, Your Honor, and I was gonna also inquire, we have an extra physical copy of the transcript, if that
Right.
works for the board.
Sure.
And then I will just email the redaction.
Come on, Monica.
And
Yes.
we'll discuss it.
Okay. Waiting on that to come through and then we'll get started.
Yeah, I really don't. This is like the professor that tells you to bring in your paper and everybody comes in, bring in your paper on a certain day, and everybody comes in with all their research and all that stuff, and they actually have not done their papers. They're all sitting there doing their papers in class the day that they're supposed to turn them in and present them. That's what it looks like. Yeah, this is definitely. I I'm lost now. I'm lost. How is this not a mistrial at this point? You literally told them that they were giving advice, told them that they threatened that man by keeping him in jail indefinitely, and you're still here. Like, why are we still here? It should have been a wrap. This is amazing. I have no idea how we. I think they put him on mute. David is with me. I think that people should study this class. People should study this case because it's so poorly run. I think so. No, I agree. There's some political pressure. Absolutely. Yeah, it doesn't even make sense anymore. I'm sorry. This case makes no sense anymore. Why are we doing this? Again, this is study hall. We're watching legal study hall, law school study hall. They should have done this before. I'm going back with Monica. This is pre-trial work. We're watching pre-trial work right here. This is embarrassing. And remember, the state,
All
they
right, do
have
you want
the,
to hand up the hard copy of the
this is on the state.
transcript? Because I don't have the electronic one quite yet, but I'm sure it'll come through at some point, but we can go ahead and get started with the hard copy. Wow, that's a lot.
But see, even with this, Rose, she still needs a jury that's not biased. I don't think that's even possible. I think personally they need to poll the jury now because all the rest of this is a moot point if they lose a jury.
Thank you.
I mean, she literally outlined an appeal. Yo. That's actually kind of true. That's kind of foul, but it's true. That is true right there. And they still failed. Right. She gave them an ultimatum and they still have not met it. But she keeps giving them room. Like they should have thrown stuff out already. Yeah, Maya says the state spoke to Woody several times before the ex parte. I agree. I think that's beyond ridiculous. Un momento, por favor.
ready with the first one on, that's, I guess, page 11, lines 10 through 12. Is that what that means? Or is that a timestamp?
Your Honor, that is correct. There was a couple Mr. Shard had that, for the most part, I could follow. So if there's a
Okay.
discrepancy, I may ask Mr. Shard specifically what
Okay.
line he
All right.
wanted, but I believe for the first one, that is correct.
All right. And is this mine to keep, this teal one?
Yes, Your Honor.
I can write all over it if I want
You
to.
can highlight it, write it.
Okay. All right. So, Mr. Sharp, the document that I'm looking at that says Quindarius proper session proposed edits, and it's all numbered 1 through whatever. Okay, so where am I supposed to be looking with regard to that first one? Because it's a lot of different numbers. I'm not sure what they all mean. Okay. I assume 11, 10 through 12 means page 11, lines 10 through 12, but then it has 10 again, which I don't know what that 10 is, and then
It should be when it ends. So it would be like 10, I'm pulling up my document.
okay.
Go ahead and make sure you hit that like button, everybody. Appreciate you. Thank you so much, Willie Doc, for showing up on this morning. All these good people, June Lee and others. Thank y'all.
Sorry. Go ahead with what?
No, I'm done.
First one would be page 11, line 10 through page 12, line 10.
Okay, that makes more sense. Gotcha. All right. And is one of the objections to all of this going to be these aren't proper under the co-conspirator exception?
Well, not everything that he says in these sessions is based on what arguably a co-conspirator said to him. Some of it may be, so some objections may be it's improper character evidence, it's irrelevant, things of that nature. But there is a lot of things that he was told, and quite frankly, Your Honor, there's some that I don't know him to have allegedly been present for something, and the source of his information is unclear. It may be rumor, it may be something he was told, and that is probably something that we're going to need to wade through at some point.
Okay. All right, so the very first one is, I'm about to tell you something, and I've just said I wasn't there.
That's page 11, line 10.
Right. So it's obviously hearsay, so what's our exception?
Your Honor, part of it, when he's saying that he's at crucial,
No, he's saying I wasn't at Crucial.
when he's saying I was not at crucial.
Right.
And he can't speak about being at crucial.
Mm-hmm.
I don't have any objection to him speaking about or trying to speak about being at crucial. I don't have any objection to taking that out.
All right, so are you good with the redaction of 11 line 10 through 12 line 10? Have you had a chance to look at these proposed redactions yet?
I looked at them. I haven't synced them up with my transcript and my
Okay.
recording. So because I've read the transcript and listened to it so many times,
Okay.
I went through it with that knowledge.
Okay.
I haven't synced it up.
Okay.
Okay, I got to make a joke. Alec Baldwin
Alright, so
got a
that's
mistrial
by agreement.
during a comfort break of this trial. That's how quick Alec Baldwin's mistrial was. His trial was 3 days. We are now on day 106. This is insane. Insane. This has got to be a joke.
All right, so that one's out by agreement. Do you want to, is it,
Thank
if
you
I
for the
gave you
super
30
sticker, Willie.
minutes, could you decide which ones you agree to? Okay. Sarah, something else anybody needs to take up before we take our morning break?
No morning
and
breaks. Let's work.
Let Miss Love do that. All right. Anybody else? Nobody? Okay. All right. We're just going to take our little morning break early. So we'll be back at 10:30.
10:30. All right, let's check. Make sure nobody. All right, you got to make sure because you got to give them a second. Make sure they really truly are ending. Okay, I think they are. I am totally. At this point, there's no way you can't convince me that this is an SNL. This is not an SNL skit. This has got to be an SNL skit. She literally goes down and explains how the state was wrong for having an ex parte meeting and the problems with it, and literally outlines it for her. I'm sorry, Judge Whitaker. I disagree with you. This should have been out. This shouldn't be a comfort break. This should be a pack up your stuff, you're going home break. We're done. Like, how is this still? How are we still here? You could have full on Bible studies between these, right? Like, this should have been over with. The Twilight Zone. Matter of fact, for funs and games, give me a bad movie that this reminds you of. Just any bad movie that you're like, hey, this movie was horrible, and that's what this reminds me of. It just went on too long. It should never have been made or anything of that nature. Give me a bad movie that this reminds you of. Let's go. Bad movie or a movie that this reminds you of. God, I like Twilight Zone. I don't think Twilight Zone is bad. But I will say the Outer Limits probably shouldn't have happened. Oh, that was a great show. Limits. What's a bad movie that this reminds you of? Idiocracy. I agree. I don't even know what that even is. Willie Doc. Manos, the Hands of Fate. Godzilla versus the Smog Monster. That's, oh my gosh, that was horrible. Groundhog's Day. That's what this feels like. Johnny Dangerously. The Wall. So plain. Absolutely. Facts. All Tyler Perry movies. KSQ Freeze, you are true. Come on. Everything by Tyler Perry. This is how bad it is. Love does look exhausted, and she's going to have a whole week of this if Hilton's gone for the whole week. She's going to be getting bodied all week. I mean, she was up there to explain why they shouldn't be disqualified. And it was... Sorry about that. She was trying to explain why they shouldn't be disqualified, and it was terrible. Oh, Beloved by Oprah. That was, I never saw it, but I heard it was horrible. Hey, wait, hold on. Wait, yo, whoa. Michael, 916. I don't talk about it much. Look, we don't play with the Fast and Furious franchise here. No, sir, no, sir, no, sir. The Fast and Furious franchise is perfect. We don't play with that. I don't care. I don't even care. The Fast and Furious franchise, we don't mess with that. Fast and Furious is on point. I'm about to put you in 0-second timeout, my guy. Absolutely 0-second timeout. We don't play the Fast and Furious franchise. It is self-aware. It is not trying to take itself seriously anymore. That movie is just death, danger, and destruction. It's 3D. Death, danger, and destruction. And that's it. That's it. That movie, we don't mess with the whole franchise. And I mean the whole thing, all 10 of them. Don't mess with them. Leave them alone. Harris Henyard 24. I agree. Lost in Space. That movie was terrible. But the TV show was great. Liar, Liar. The Night Stalker. The Blob. I agree. Come on. The Exorcist. This is one of the bad movies that this is remind me of. Imagine having Medea as Woody's lawyer. That would be good. That'd be some must see for sure. I mean, I'm embarrassed too. I'm like this point, we should be done. There's no reason to still be going on. Okay. Groundhog's Day again. The Last Airbender. Okay. Oh yeah, make sure you check your bingo boards, y'all. Check your bingo boards. Let's see what I got. All right, I'm cooking today. I'm doing pretty good today. Let's see. All right. They haven't done jury instructions. I still got motion granted, Fonny, goaded, projection, ADA love looking frantic. I'm pretty sure that's happened. YSL Steel, frustrated soliloquy, DQ of Love and Hilton. That doesn't look like it's going to happen. Discovery, irony, motion denied. I think actually we did get a motion denied. Love self-basting. I think I got that one too. Weaver, inartful, and telephone ringing. Oh, technically we had telephone ringing because my telephone was ringing, and then candor. All right, I believe that self-basting was her, that whatever that was this morning when she was trying to explain the court case. It was crazy. All right, let's get back and finish up. What you people talking about? All right, there we go. Last Airbender. Y'all did not like Groundhog's Day. Wow, y'all are not. This is like the third, fourth time I've seen that. Yo, y'all said they're filming this in a Tyler Perry studio. Come on, y'all wild. You are wild. But by the way, I think you're right. There's no way you're going to convince me this is not a joke. There's no way. I can't believe that this is not a joke. Okay. Maya says, true regarding Alec Baldwin dismissal. They had a fair judge from the start. They proved beyond a doubt that the state had hid Brady evidence. And I think they had I think they've done that well here too. But that's the problem. Like, they've already proven every time there's something proven that the state has done wrong, whether it be the coercion, the Brady, fill in the blanks. They get right up to the line of saying this is completely unprofessional, completely inappropriate, and then they just pull back. They get right up to the line and then they pull back. And I have no idea why. It's crazy to me. Oh, okay. Thank you so much. Gino, thank you very much for the super chat. And he says, please explain the difference between the two options of mistrial and like this man. Thank you so much. I appreciate it. So mistrial. So let's say Judge Whitaker gets up there and says, I declare a mistrial. Now, there's a couple reasons why somebody who's at fault for the mistrial. So if the defense does something wrong, let's say I can't think of something off the top of my head. Somebody's going to comment in a second. What the defense, so that would be Young Thug. Let's say Young Thug does something that declares a mistrial. Then she would say that's a mistrial with without prejudice. So they can be retried for the same thing all over again because they messed it up. Okay. But let's say the state does something and we've just delineated at least 10 things that the state has done wrong. Coercion, the ex parte, the recuse. I mean, there's so many things that they've done wrong. So if she declares a mistrial with prejudice, that means no longer can the state go after young thug for the same thing that they've done. So they cannot bring this up again because the state dropped the ball. The state messed up. The state did wrong. I hope that makes sense. So they declare mistrial. That means the case stops. It's over. Now, why is the case over? Because the defense did something wrong and they need to be tried again, start over again. They can say the case is over, but the state has done something wrong. Now, she could say the state has done something wrong. Y'all need to go back and try again. That could be where she's giving them the opportunity to come back and try it again. Or she could say, y'all, double jeopardy has applied. You've already tried this. You've already tried once and you can't try it again. Therefore, the whole thing is done. And that's called with prejudice, or without prejudice is the other option. I hope I made sense of that. And of course, anybody with legal mind is welcome to say that I'm crazy. Yeah, at this point in the game, so I hope that made sense. Gino, thank you very much for the super chat. Thank you for the opportunity to explain that as best I understand it. I admit I could totally be wrong, but I got some other great people in here that will gladly chime in. Right there. See, that's what I'm talking about. See, just Susie, me and you right here. The Fast and Furious franchise is self-aware. It was the first series of movies that became self-aware. You know what? I don't know Tokyo Drift. Tokyo Drift, I don't know you. I don't know who you are. But the rest of the franchise, the time, and I knew that this was no longer serious when they dropped a tank out of a plane and the tank onto the highway. That's when I said, yo, this movie has now lost all semblance of trying to be serious. I think the movies previous, they were like trying to be serious, and there was like an air of danger, if you will, like, oh, this really means something. Somebody could really die. A character could really die. Once they put a tank on the highway, I think that was it. And I also think when they got chased by a submarine, I think that was also like, I'm sorry, this movie is no longer serious at all. So that's why I say, Fast, I like them though. I think they're hilarious. I think they're fun to watch. If you just want some good old make it happen. I thought John Wick 4 was good. I thought the most recent John Wick movie, but the problem is Hollywood at this current moment, and I could turn this in, y'all know I can go on a rant about movies and entertainment. Hollywood is no longer made by movies are no longer made by people who write stories. They're no longer story writers and people that are passionate about conveying an idea out to the people and creating an immersive world where all of this stuff can happen. Like, let's go back and look at like a Tolkien or other great movies and writers of the past. They're not doing that. What we have now is that people are taking old franchises and creating activism within the franchise. Look at Star Wars. Just take the time and go through Star Wars. Just do it like a wiki search and whatnot. And you'll realize this has now become an activist platform. It's no longer anybody's adding to the extended universe and the new ideas within the framework of what's being presented. No, they're creating new scenarios and, dare I say, even a new universe that's not what we're used to. So I think John Wick was fine. They just don't know how to stop. I think John Wick, there should not be another John Wick with Keanu Reeves. And hear me, I like all the John Wick movies. They're crazy, right? They're definitely up there with Fast and Furious. And if they make another John Wick with Keanu Reeves, I'm gonna be right there reporting for duty. They need to stop, however, because they're going to get to a point where they're going to become self-aware. And then that's when it just becomes a bad franchise. And then you potentially ruin the franchise. And then you have fragmentation. Oh, I only like the first 4, but the next 8 are completely garbage. That kind of stuff like that. So just stop. Just stop. I think they can continue the John Wick universe. Yeah, nobody, y'all. Okay, I'm sorry. I will save this kind of rants for like another show because this has nothing to do with what we're talking about today at all. But I'm going to continue anyway. So the John Wick universe has so much y'all can do with it, from the Continental to understanding the High Table to understanding the whole Assassins lore and all that kind of stuff. Mr. Nobody and all of these great people that you can dig into. You don't need John Wick anymore. It's okay to give John Wick a proper salute and let him be gone. It's perfectly okay. Keanu Reeves did a fantastic job. He crushed that role. He did a wonderful job at that. Let him go. But now explain the Barrio King to me. Help me understand Winston. Why in the world is the ballerina? What's going on with the ballerina? Those are things that you can explain and have a field day if you can tell good stories. Therein is the problem. Okay, I'm going to save that for like a members only. maybe that's what I should do, because I could talk. I mean, because you see it all the time. All right, y'all are wild with y'all still telling me who's going to play. That's another fun thing is picking. Since this is a movie, this is basically like an SNL skit. When people start picking characters or actors to play characters in this skit, it is hilarious. You guys are the best when it comes up to that. Yo, this right here. The Shady Lawyers of Fulton County. Did you really do that? That is so funny. Did you really? Wow, that right there. And Doug, that took the whole cake right there. You stole the whole cake. We got to put you on Rico because you stole the cake. That is so funny. The Shady Lawyers of Fulton County. Somebody is going to make a thumbnail of that or like a trailer of that, and it's going to be a hit. Like, I'm disappointed, Camilla Norris, because you know the jury is tampered. You know the jury is tainted. So all of this work that they're doing is for naught, because you're going to get the jury in and they're going to be like, yo, I got my free Woody t-shirt, and it's a wrap. It's over. I don't see how to pretend like the jury is not tainted, to me, is just, you're just lying to yourself. To act like, oh, the jury's going to come in here and they're going to not have seen any TV for 2 months. Say that out loud to yourself. A 20 to 60-year-old adult human in Fulton County, Georgia, has not seen what's going on in Fulton County, Georgia during an election season, mind you. Okay. If that's what you want me to believe, sure. Did somebody talk about Batman? Y'all slow down. Now, there have been some bad Batman movies, I will admit. There have been some horrible ones. But y'all lay off the Fast and Furious and don't touch the John Wick franchise. Y'all better leave Batman alone. Now, look, I don't want to start kicking people out of here. Cassie asked, where's Miss Hilton? Hilton had a scheduled event. I thought it was for the day, but apparently it's for the whole week. So she's not going to be there all week. As far as I know, yeah, this trial has jumped the whole shark. Yeah, that should be, let me find that, the Fonz jumping the shark, because that's where we are. You know what? I would get a copyright strike on that, because I know that I just thought about it. They'll take down the whole thing for that. I just thought about it. Glad I didn't do it. Electric Boogaloo. Wow. Shaq Fu 2024. Y'all are not feeling these movies. I don't think she's on vacation. I thought she had like some kind of medical event, but. So let me ask you a question real quick, Foster Cathead. You like Star Wars, okay? Not a problem. Do you like this is what I mean by you have to know when to stop. Do you like the original 3, or do you like the original 3 prequel, or the ones that came after that? or all of the TV shows. See, there's so many different levels to them that you have to like really start parsing through. Most people say, oh, I like the original 3 and I'm okay with the prequels. Okay. After that, all bets are off from there. So that's what I'm saying. Like there's instances where they have to stop doing certain things and build new universes. I used to be a fanatic for Star Trek. I thought Star Trek was the best thing cooking. I thought, I'm talking Kirk. I love Jean-Luc Picard. Give me Jean-Luc Picard. Oh my gosh. They introduced Janeway. I said, what are y'all doing? What is this? What is this? And now the franchise has lost it all. Why? Because instead of building on the lore, they took what was existing, the Starship Enterprise. Dare we all say, if you're a Star Trek fan, the Star Trek Enterprise is borderline sacred to some people, right? You don't change that. You leave that alone. But nothing stopped you from creating and going and dealing with other aspects of the Federation without changing the lore of what was there before. I thought the idea and the concept of the most recent Picard series was going to be good. I never watched it, but I read about it. I was like, oh, that sounds like it's going to be kind of cool. I like Jean-Luc Picard. I was like, okay, I can get down with that. I think that might be good. But apparently they went way off into activism. They're not telling stories. They're promoting ideas, a platform to push propaganda. They're not telling a story. They're pushing something else. So that's why it failed. So ask yourself, like, are you a fan of all the Star Wars? Because again, like they got 95 movies at this point, and there's a lot of them. They did do a series on Winston. That's what I'm saying. They could continue that. That's what I'm saying, Darkly. Stay there. Just keep building. Like, what's going on in the world that assassins are able to just run amok like that? Like they're just doing stuff. They're just like, there's no police here. Like, what's going on? What's going on here? I did a video one time. I said that the John Wick universe is a defund the police universe. Like, there are no police. There are no police in the John Wick universe. There are just people. And anytime you see police, they are definitely suspect. Okay. But there's no police in this movie. And even in the beginning, those police, they came to John Wick's house after the assassins attacked his crib. You know good and well those weren't police. They weren't. So anyway, that's my little rant about that. I'm gonna have to say that for members only. We'll say members only. Yo, what time did she say? She still has not come back. They're not back. Let me double check, make sure I haven't put my TV on pause. Nope. Okay. Okay, we're golden. At this point, friend, I have no idea, Kathy. I have zero idea. All right, hold on. Email coming in hot. Somebody just sent me an email. All right. I have no idea how we're still here without some I mean, I would be fine if she just declared mistrial. We were just cleaning up the wreckage and maybe cleaning, doing a little bit of follow-up. That'd be fine. But y'all, how long ago did I just say somebody's going to do a shady lawyers of Fulton County? How long ago was that? Was that just like maybe like 8 minutes ago? Oh shoot, where'd it go? I just said that, right? Somebody just sent it to me. Oh. Oh man. I downloaded it and let me just open up over here because this thing is getting real crazy. Somebody has sent me the shady lawyers of Fulton County. Man, you people are amazing. Already proving exactly why this is the best live chat on the whole universe. All right, let's see. Let's do it like this. I don't think they talking about anything anyway. Over there, let's get this. Well, not show y'all. Ah, here it is right here. No, it's not showing up. All right. User error. Don't worry about it. Don't worry about it. We're going to get it resolved. Let me pull it in this way. Will it pull this way? It will not. Somebody just sent it to me, and I am bumbling this up for y'all. I'm sorry about that. All right, let's see if we can do this correctly now. Like, this guy's not professional. What is he doing? Is this showing right? I think this is okay. Why is it not large? Darn it. All right, so the Shady Lawyers of Fulton County season 1. They done already made this. Let me see, make this larger for y'all. All right, so we got Love, we got Nate Wade, we got Judge Glanville, we got Simone Hilton, and we got Fonnie Willis. Now, there still need to be some more shady people in here, though. This is hilarious. Shout out to the Black law student for that. That was great. All right, I'll drop it in I gotta make a thumbnail out of that for sure. All right, let's keep this going. I have no idea how this is not a total mistrial. I have no idea. None whatsoever. At this stage of the game, I'm just like, I don't even understand how you're moving forward. To me, truly, I think that rather than worrying about Woody, I think they need to go and ask. I think the camera's moving. Oh, it's not. Okay. Rather than worrying about Woody, I think they should be worrying about the jury. I mean, it's almost a moot point. You go get Woody and he says he's ready to testify. And I'm ready to tell them my truth. I'm ready to sing my song, Judge. Well, you still haven't checked your jury. So you check your jury and you find out you ain't got no jury. Like, what's the point? All right. Oh, now we got Groundhog Day slander. I remember watching the movie. I just never watched it again. So I don't have like a running. Was that Tom Hanks? No, it was Bill Murray. Bill Murray. And like every day was like the same day, like or whatever like that. I understand the concept of Groundhog Day for sure. And I do feel like we're living in Groundhog's Day in this trial. No question about that at all. Oh, I was definitely going to show the jump the shark, but I know that they will absolutely take down your whole video for that. They're in recess, Gladiator Girl. Personally, I think this thing is stressing Judge Whitaker out way more than she thought. Way more than she thought it was going to be. So I think that's what the problem is. You've never heard, okay, if you've never heard of jumping the shark, look up Happy Days, Jump the Shark. I can pull it up, but I know that I can't play it. If you look up Happy Days, because remember the Fonz. Yeah, I do not want it. Here, I'll pull it up real quick and I'll at least show you. So okay, you remember right? So Happy Days was like super popular and everything was going on all cylinders. They was just printing money, right? But as shows go on over time, they kind of lose their luster. They have to introduce new characters and new dangers, so on and so forth. So they came up with this crazy idea to have Harry Winkler as the Fonz riding skis, being pulled by a speedboat, jumping a ramp, and there's sharks in the pool of water that he's jumping over. And so you see, he's literally wearing the leather jacket. So that's like, this is how corny it was, right? He's wearing a leather jacket, riding skis out on the ocean, getting pulled by a jet ski. He's going to jump I could probably, troublemaker. I'm not going to play any sharks. Oh, danger, right? I'm not. So he's doing all this. What is that guy's name? All right. So that's what jump the shark means. Richie. That was his name. That was his name in the show. Thank you, Axel Wheel. All right, let me cut this off over here. So yeah, that was wild. That was a high one. But usually when they say that, once you jump the shark, it's usually downhill from there. So usually, there's a metrics that shows, like, shows get to a certain point, they hit the high mark and then they go down from there. If they're telling good stories. Now there are some that are outliers, but for the most part, most of your sitcoms, most of your docudramas and stuff like that, they have a shelf life. They can only do so much. And you see it even on the more popular ones like Law and Order and Special Victims Unit Law and Order. They hit a point and they had to make a shift. They had to bring in new characters, bring in some fresh blood, get some new scripts and some new ideas, because otherwise they were going to go take on water. So that was it. Oh no, I like the term, because a lot of the time, I like idioms, by the way. So if I miss that, I want to get an opportunity to share that. So I'm glad you. Oh my gosh, why do people love me so much? It's always something. It's always something. Yeah, if you need a bingo, that was my phone ring. You can have that one for sure. The prosecution need to go back to pre-K law school. I mean, my goodness, in the morning. Okay, good conversation going back and forth. I appreciate y'all. Thank you so much. What do we have here? I got almost 675 of y'all watching. Thank you so much for that. I appreciate you so much for tuning in. What is going at the current moment? Judge Whitaker has everybody on a comfort break, on a stretch, and whatnot like that. So we're gonna give them an opportunity. We're just watching the Young Thug trial. Hopefully, we'll have some good resolution today. We'll see what happens. And let me make sure on my end I'm doing thing right. I think Judge Whitaker is through with this, but it's at this point, it's her own fault now. At this point, I'm team Judge Whitaker, but it's really her fault at this point in the game. This should have been thrown. This should have already been called. There's no reason for this to continue on anymore. All right, let me see. All right. Since we just talked about it, I figured I dropped a fun little poll question for you. Has this trial jumped the shark? Feel free to chime in on that one. Yes or no. The BBC is savage. The BBC is going to give them. I mean, we need honesty like that. And I love it. I'm here for it all. All right. Oh yeah, you don't need everybody to be there to mistrial. Yeah, absolutely. Cassie said, so if Hilton is away for the rest of the week, could Judge Whitaker ethically make a mistrial decision without all the lawyers being present? Yes, she could. She could. But the problem is, I don't think she's going to declare mistrial. I don't think, I'm not even holding my breath for that anymore because I was turning blue. I don't think that she's going to declare mistrial. I think she is going to try to rehabilitate this trial. I feel like to her detriment. It's not good to do it. But unless there was a way to like for Young Thug to sue after, because it's going to go to appeal. And I mean, yeah, to me, they're going to still be in jail. All that to me is it's not a good look. But I don't know anything about Kamala's vice president choice. People have been texting me. I've been trying to stay focused here, but people have been texting me about that, even called me about it. Thank you very much, Cassie, for the very kind super sticker. Thank you very much. Present, not perfect. Just ask, what do you think about Kamala's vice president choice? I know he was the governor of Minnesota. That's going to be, my political strategy is you don't want somebody that's too similar to you, and being the fact that he was very pro BLM, pro riots, pro open border immigration. What's the difference? So he's just another Joe Biden at this point. So I don't think that's a good look. But I wasn't supporting Kamala Harris to start with, so it doesn't matter, in my opinion. Thank you so much for that. Look, I don't have a problem. Somebody said, why is Hilton out on vacation? I thought she had like a medical event. I don't want to get into, people got lives outside of this. This trial is not the end all be all. Just like Melnick. I mean, granted, I feel like Hilton and fire in the hole. Let's go. Let's go.
Agreement on anything?
Judge,
One in the chat that you can hear.
Reviewing Mr. Sharp's proposed redactions, and there are some that I agree to.
Okay.
Not a whole lot, but we've already given the court the first one. Does the court have a copy of his redaction?
Yeah, the proposed redaction, yes.
Okay, so looking at Mr. Sharp's chart, number one, we've already discussed. Number 17 is the next one.
All right. And that's agreed to?
Yes, I don't have any problem with that. That's the discussion of the search of defendant Williams' home, revealing a gun, and the gun and the contents of that search were suppressed, so that should
Okay.
not come in.
All
As well as number 19, which is on page 73 of the transcript.
All right.
That is, just to call it out, speculation.
Okay.
Specifically, it's 67, line 15 through 19. No, I'm sorry. Mr. Sharp has a description that is different than the lines that are listed. So 70, so on page 73,
Mm-hmm.
I don't have any objection to lines 10. He has it right, lines 10 through 13, no objection.
Ms. Love, could you just give me the number of the section when you look at
17.
So 17 and 19,
Okay.
I also don't have any objection to. 23, I don't have any objection to.
Okay.
clarify what the first one you did not have an objection to.
The first one that I did not have an objection to was number 1. And number 1, if you have, you already have the redactions? Okay, so it was Mr. Zachary, after saying he wasn't at Club Crucial, he talks about what happened at Club Crucial. And Your Honor, I will say that as it stands, I'm not trying to get that in. I
Okay.
don't know if something else changes, but right now I agree that it should come out.
Okay. All right, so we had gone through 23.
24, 25, 26, I don't agree with. Going to 27, it is 9211. Keep out. All the way through 9422. Mm-hmm. 9211 through 9422. That's what I've gotten to agree to. If the court permits me to further review the rest of them, because some of them I was looking and I don't agree to, I'm ready to argue those, or
All right.
I can.
Let's do that right now, and
All
then
right.
over the lunch break, you can go through the ones you hadn't hit yet and see whether there's agreement on any of those.
Did
Okay?
Did the state agree to 27 or no?
It's,
No, we
no,
stopped.
sounds like so far just 1, 17, 19, and 23. Okay. All right, so I guess that means 2 through 16, we need to take up.
Yes.
Okay.
I'm sorry. This is an exercise in
And Your Honor,
futility.
will we just follow the same pattern we did last time,
Sure.
where the defense tells what their objection is?
Yeah, so I mean, the objections are essentially on the proposed redaction, so I guess the objections generally speculation about why they shot up a house.
So page 13, line 16 starts at Dennis talking with the witness about the house getting shot up. And this is following, I think you have to go back a little bit further to page 12 to get better context. In that conversation, the witness is talking with Demikion Garlington about people that call him that night, starting on page 12, line 14. And Quindarius Zachary is talking about his girlfriend telling him what's going on.
Right. Yeah, so it starts at 13, line 16. He doesn't have objection to him saying, hey, this house got shut up. It's why the house got shut up, which the objection's speculation.
The state has no motivation to
my
move fast.
Argument, assuming I established the proper foundation, is that with Quindarius Zachary saying that Trevante was helping D-Fight. He's talking about Demikion Garlington.
Right, so what would his basis of knowledge be? You would need to establish that he's got a legitimate basis to know that.
That's the point that I'm making. Like, without doing it, I wouldn't, if
Okay.
I were not able to do it, I wouldn't proffer it or even try to play
Okay,
it.
and so you think you can?
Yes, that's the point. Especially, Your Honor, when we're talking about, he goes all the way through to line 2.
Right, 14 line 2.
Okay, I was looking at line 14.
And
Unless if I don't establish that foundation, I won't tender that. But if I do, I just want to be able to play that part about his.
okay, so how about this? Right now, it's out on the,
Okay.
granted as to speculation.
Okay.
And if you establish it,
Okay.
then that'll be a different story.
That'll work. Okay, so the next one being page 25. So 25, page 25, line 9 through 2512 is a direct statement from the witness about an incident that's listed as an overt act on the indictment.
Okay.
And what they were doing, it's an admission.
All right.
It's an admission against his.
All right, so what's our objection there, Mr. Short?
My objection is drug use. And the character that's associated with that, and the statement, they didn't, where is it? They really didn't care. That's speculation about someone else's mind state, or state of mind. The reality is, within this context is a story about that Mr. Zachary gives, that he describes my client, as well as others, shooting up houses. And I'm not, of course, I don't want that to be admitted, but that's a fight for another day. But I'm not objecting to that on any of these bases, but I am objecting. So I'm not objecting to him talking about that at this time, but I am objecting to him pontificating about my client's state of mind as this was going on, because he can't really speak to that.
So that would just go to the, they really didn't care part. And then you're saying the fact that he's saying they were taking Xanax is.
I don't know his basis of knowledge of that, but I don't believe that to be true, but I don't know his basis of knowledge of that.
All right, Ms. Love.
So Judge, my argument right now until I speak to him is that he is in the car with the persons that he's speaking to the detectives about. He has the opportunity to observe them up close. The question posed, as the court can see, is did they feel some kind of way that you didn't get out of the car? We believe that the evidence has shown and will continue to show that these people he's in the car with that are shooting up these houses are his friends. He's known them for a long time, and his personal observations of them and personal knowledge of them is what allows him to make the assertion that he does, that as to why they didn't care that he didn't get out of the car while they're facing arguably danger. They're the ones getting out, according to Mr. Zachary, doing the shooting, but they were high, essentially. So that's the reason why they didn't mind him not getting out of the car. We'd argue that it's intrinsic. It could go to why they would be so brazen as to do something like that. But the fact that they were high while they were shooting, the fact that it incidentally touches on someone's character.
Okay, so I don't have I don't think, I'm gonna overrule it as to character. And if you can establish that he actually knew they were on Xanax and high, that's fine. On the they really didn't care part, are you maintaining that part should come in?
Yes.
Because his observation is that,
That they didn't mind. He's offering up an explanation as to why. Basically, the investigator's a little bit incredulous that, wait, you.
right, what's the motive? The motive's just, they were high.
Yes.
All right. Well, if you can establish that he knows that they were on Xanax, then I will let you
Yeah, how do you know that though?
use that part. So overruled as to character and sort of like to be determined as to the basis of knowledge on whether they were high or not.
I put subject to foundation.
Okay.
So that is number. So the next one is further down. Mr. Zachary is asked by the prosecutor, what was you all's intention when you all headed over there? He says that we were going to kill one of the boys. And then the prosecutor says, and one of the boys, I know we talked about a bunch of names, but which of the guys were you looking for? And then Mr. Zachary responds, the request is to take out 17 through 25 all the way.
Yeah, I think just
I'm
17
sorry,
through
25.
17 through 20.
Yes, I'm sorry. So 17 through 20.
Right.
He's specifically talking about their intentions when they went on this shooting spree. I think that it's not only relevant, intrinsic, it gives a motive for what they were doing. He has personal knowledge of it. He was in the car. They were riding together.
Okay, well, as long as you establish that he knew that's what they were planning to do, and it's not.
And he doesn't say they, he says that
Oh,
we
he's-
were going to kill one of the.
Oh, I'm sorry. Actually, I maybe need to put on my glasses. Thought that said they were, but that we were, yes, so.
So, Your Honor, let me just back up. So this is an incident where houses were shot up. Mr. Zachary was charged, and in this proffer session, he's given testimony to try to get himself a deal. And I understand that's subject for cross-examination. My client was never charged.
Okay.
Mr. Zachary is throwing my client's name into this. And I understand that's subject for cross-examination as well. But when he says, what was y'all's intention? Now, it strikes me that Mr. Zachary can speak to his own intention, unless he says, Mr. Stillwell was there, and this is what Mr. Stillwell said, or something of that nature. He can speak to his own intention, what his intention was, and the state can ask him on the stand, Mr. Zachary, when you went over to the house, what was your plan? But unless someone else articulated their plan to Mr. Zachary, I don't think he's authorized to speak to what anyone else's plan was or intention was. And when he starts saying, and it's not his fault because
Of the way
Mr.
it's
Bailey
asked.
inartfully asked what was y'all's intention, and that prompted him to speak for other people.
Well, I understand, and it may very well be that you can establish that they all had a joint intention because they had had some sort of talk about it beforehand, or.
And they actually he reveals earlier in the interview that they do discuss it.
All
that they
right,
are
so
having
where's
talks.
that?
So up. On line 4, he says, because he said we're not going to shoot a house, leave that to them. So on line 2, Investigator Dennis asks, why does Muntung, and that is actually Antonio Sledge, it's spelled wrong, tell you not to get out of the car? He said, Mr. Zachary said, because he said, we don't shoot up houses, leave that to them. That's one point that they're talking. Further back on line, page 24, when Mr. Zachary is talking to Detective Dennis about the kind of guns that they have, he's naming them.
Okay, I mean, it does look like they kind of had,
Well, Your Honor, he's
Line 9.
talking about what Muntung said.
Oh, she did say
Muntung's not even
inartfully.
Here, my client is not Muntung. And so I don't find respectfully what Ms. Love said to really address the issue.
all right, so where is it that your client gets, what is it that is indicating that he's talking, his speech includes your client if your client's not in the car?
No, my client is supposedly in the car according to Mr. Zachary. But what Ms. Love talked about is Muntung telling Mr. Zachary to not get out the car, saying, we don't shoot up houses, leave that to them. What that has to do with my client's intent to kill someone, I'm not seeing that link at all. And my whole point is this, Your Honor, if they can establish that that through Mr. Zachary, that my client indicated what the intent was, what the plan was, that's not in this transcript. That's going to come across through live testimony, which would render these prior statements, out of court statements, irrelevant anyways, because it would have been established through live testimony.
Right.
So I don't know why we would keep this in the transcript.
Judge, I thought that the whole purpose of this exercise was assuming that
Well,
they
it
don't.
is. It
Okay.
is. Okay, so assuming you need to use it as a prior inconsistent statement. or-
Yes, and in response to Mr. Sharp, Mr. Zachary is talking about his own intent and his understanding of what the conspiracy was. Arguably, this is a conspiratorial act of going out to shoot. We were going to kill one of the boys. So he does not, I don't think that it's improper for him to be able to talk about what the intentions of the group that he is acting as a part of were, as shown by their actions and their words throughout the course of the conspiracy itself.
But if his statement is just based on assumptions he's making through the actions of others, then the jurors are in a similar place as Mr. Zachary to make that, to draw that conclusion.
But Mr.
So
Zachary,
I don't understand why Mr. Zachary, his conclusion about what my client's intent was would be particularly helpful or relevant to anything unless my client articulated it to him. And from my understanding of what Mr. Zachary's saying is he gets a call from his girlfriend, Summer. Mr. Garlington and Mr. Sledge leave the club. Mr. Zachary doesn't know, according to his story, he doesn't know how Mr. Stillwell gets in the car because he wasn't at the club. And then they pick up Zachary last. And Zachary does not describe any conversation in the car on the way to these houses or anything like that. He doesn't give any context about communication. He's just kind of like, I got in the car and this is where we went.
so Judge, this is also the third interview that Mr. Zachary gave. He gave one earlier in 2015. This one occurred in 2017. So there are statements about this same incident in the 2015 interview.
Hey,
as well.
team, everybody, real quick. I'm going to take
we
a pause for a
we
hot
haven't
second,
gone through that.
just to real quick address something. In order for this to remain the best live chat on the planet, I'm just going to ask that we, hey, I get it. There's a lot of going on with Adrian Love, and lots of people have an opinion about her and her dress and so on and so forth. I got it. I understand it completely. I totally agree with you that there's definitely some, but let's not do that. Let's not get on her about the way she dressed or whether you like her heels, if they match, or skirt, whatever like that. That's not really what we're doing. Like, we're not listening to actually her argumentation. Her argumentation is actually really, really horrible. And I think that's where what we're here for. So if we could tamper down the discussion about her dress, same thing with Hilton, same thing with Shard and all of them. Let's leave the dress alone, because I don't think that it doesn't help us, and we borderline just, not being the type of channel that we would like to be. So I appreciate it, though. If you don't like it, I totally get it. I understand your point, but I do ask respectfully that you're not. And then, of course, the moderators are going to deal with this accordingly from there. So I appreciate you. Let's bring it back. Let's get back and hear what they're talking about. Thank you so much.
The
So
shooting of
this,
the
this
houses.
one, we have given the list of 30 witnesses, and one of the first witnesses after Mr. Zachary is the young lady who lives at this house, and her sister getting
Okay.
shot at. So there hasn't been,
Did somebody get shot at this house?
yes.
And that evidence will come in through this
The-
other, what's the name of that witness?
Miss Bell and her sister Cecilia.
So they're coming to testify.
I see him on the witness list.
You don't see them?
Yeah, I do. I see Denise Bell. I don't know what the other person's name is. So you intend to call somebody who says somebody at this house got shot? Okay, so then that is all right. All right, number 6. And I guess let's make this 3-page proffer of proposed edits a record of part of an exhibit to today's proceedings. So in the event of an eventual review, whomever is reviewing it will know what we're talking about when we say on to number 6.
Can we make, you don't want us to use the one we're writing on, you want to make
Yeah,
it,
just a
easier.
clean copy.
Okay.
Yeah, I know we're all writing on ours right now. So yeah, just a clean copy, and it can be,
We can do that.
I don't care who makes it an exhibit.
Okay.
It's basically just for purposes of the record. I can make it a court's exhibit to today, court's exhibit 1. I'll print out a clean copy right now. All right.
So the next one is page 29, line 10 through 29, line 11. So going back, Your Honor, you can see from page 28, line you can go back up as far as line 7, but you'll see that there's context. You want to pause?
No.
Okay, you can see that there's context. Mr. Zachary is talking about where they went, what they did. And at line 18, he's talking about the house on Oak. And later on, you have Investigator Dennis talking about his familiarity with the house.
Right.
The fact that he offers a concrete fact, his knowledge about the house, and Mr. Zachary doesn't correct him or doesn't say anything about it, I would argue it just goes to the
correct him
effect.
to that?
I mean, it's not something that by itself is very material. There's just,
Then take
I
it
don't,
out. Strike it. Granted.
you're, okay. Out.
All right. I'm just writing August 6, 2024, Courts Exhibit 1 as to this 3-page
Yes, Your Honor.
proposed reductions. Okay.
So the number 7 is page 33, line 1 through 35, line 14. That actually starts back up on page 32, or actually 31, where Mr. Zachary is talking about Trevante. So page 31, line 16, where Dennis says, got it, you were sitting behind Montun, Demikian is in the back with you and Shannon is in front, and then and then Mr. Zachary says they were in another car, yeah. And they go on and talk about that. My argument is that the portion that they're asking to keep out is all information Dennis is exchanging with Quindarius Zachary about activities that YSL and rivals are sort of involved in. Mr. Dennis talks about how they thought it was Kale, and Mr. Zachary says, no, he corrects them, no, and then Dennis says, well, enlighten me, and he's like, no, you go ahead. But Zachary later on line 17 says they tried to say that we did it, acknowledging that there is a we, acknowledging in a way that helps to prove count 1 in our indictment. There is a they who is an opposition group who tried to say that we did it, we being YSL.
Where is the part where the opposition group is saying they thought we did it? I see the investigator saying we thought y'all did it, but
No, line 17, where he says they tried to say that we did it on on page 33.
oh, it's back on page 35. I'm sorry. Okay. Okay. And so this would be to establish
the existence of the enterprise, the gang, and the fact that there is an opposition and a they and a we.
all right, Mr.
So,
Sharp.
I mean, that's not factually accurate.
Okay.
On this
Pull your
alleged,
mic towards you if you don't mind.
on this
It
alleged,
moves, so you can just move it up on your desk, maybe. I don't know.
with
I
this-
know they're all annoying. They get in the way.
with this alleged incident, the shooting up the houses, Mr. Zachary also puts a gentleman, two gentlemen, a Trevante Turner
Yo,
and a
thank you so
Tay
much, Mel, for the
as
super
being the
chat.
caravan
I
of
know
them
this is
shooting up
boring,
these
man. That's the
houses.
thing. Like, I
Trevante
want them to
Turner,
change this. This is terrible.
Sadly
But
deceased.
I'm gonna let it keep
He
going. I
has
appreciate y'all.
never
Thank you so much for the support. Thank
I've
you for hitting
never
the like.
heard
Let's go.
anyone
Let's go.
allege that he was a member of YSL. The paper just reported that he was associated with I believe it was If Gang.
I'm
but
not sure. I'm gonna go on what the paper says.
I understand, but the state has never alleged that. He's not charged in this.
Okay.
This is a gentleman who you know has not. There's been no allegations that he's been affiliated with us. I believe that there's a suggestion that he's a friend of Kenneth Copeland's, but that's it. So I don't have. I mean, I don't want it to come in, but I don't have a legal argument at this point against them. Mr. Zachary saying Trevante Turner was part of this mission that he's claiming
Mhm.
existed. But at the times that I highlighted that I have a problem with, it's talking about a wholly unrelated incident where Trevante Turner, who's not one of us, and Shell Kell, who is Kelvin Watts, were having their own side beef and shooting at each other. And I believe Trevante was shot, maybe by Shell Kell. Mr. Watts was maybe shot by Trevante, but it has nothing to do with this indictment. It's not alleged as an overt act, and it has nothing to do with, if I were to, for the purpose of this argument, agree that there's a group called YSL and it's a criminal street gang, which obviously is an issue here, this incident would have nothing to do with that. And it's just talking about, and they're just really treating it as small talk. You know, that he's telling a story and then it's a little aside about Trevante, which has nothing to do with this case.
All right, Ms. Lett, what do you have to say about that?
We had served in discovery a PowerPoint that involves, just as it relates to the assertion by Mr. Sharp that Trevante Turner was not associated with YSL. And in that PowerPoint that we served, we reflect on one of the slides at January 27 of 2015 incident 15-026-2801 on Stanhope Circle, where shots were fired, specifically where Trevante Turner was shot. And it's listed that he is an associate of YSL/30D. Just to go to the assertion that there's never been any indication about Trevante Turner being YSL.
Well,
but
an
that's,
associate of YSL and a member of YSL aren't the same thing.
they aren't, but I'm not asserting one way or the other as it relates to associate or member with respect to Trevante Turner. What I'm saying is that in saying that they tried to say we did it, Quindarius Zachary, when we charge the gang act, associate or member, it doesn't matter. Associates commit acts with the gang. So it doesn't in any way cut against, is my position, my argument that in saying they try to say we did it, he's not just talking about a random group of men. He's talking about them as a group that operates as YSL is the argument that I would make.
Well,
Who's the they here?
The person,
Go ahead.
she does.
so
All right, let me,
so if gang is the gang that
so
they're
is that the they here? This is the
associates
part of the gang that
yes.
there's the alleged beef back and forth and the
Yes.
series of shooting, the members that are involved in this little, even if it's a side incident, are all that gang?
Yes.
Okay.
Well, if that's the money line, they tried to say, like, how's that admissible? They, they tried to say we did it. I mean, false accusations by an unnamed group about something that the declarant, in this case, Mr. Zachary, is actually saying they were wrong about. How's that admissible to anything? And if that's the key section, that's inadmissible in itself. But I think this whole section is just wholly irrelevant and it confuses the issues.
And if the court goes on further down,
Mm-hmm.
and investigator Dennis elaborates, that basically you all were laying in wait for Kelvin Watts. It says Watch, but it's Watts, W-A-T-T-S, Shell Kel, who also has a gray Charger. Just in the continued conversation with everything he asserts, he is making an affirmation about the existence of the gang itself. Yeah, that's what they say. Is what Quindarius Zachary says. He's not pushing back against the notion that they would be laying in watch for Shell Kel. He's just saying, yeah, that's what they say. There's an acknowledgement still of an opposition and of a group that he belongs to.
All right, so,
She's trying to make this case. Bless her heart.
right, but she's not offering it for whether it happened the way they said it happened or not. She's offering it for the concept that Mr. Zachary is saying, yeah, there's this we here that is YSL, and that is certainly relevant to the issues in this case. And if you want some kind, I mean, if it even comes in, because I assume, this is all if he doesn't testify as the state thinks he will, and then they have to impeach him, although, it would be interesting to see how you use this and what you would be using this to impeach for. Because if your purpose with it is to establish there's a we and a they, then he'd have to testify inconsistently to that for you to be able to use this. Do you understand?
Yes.
Okay.
And Your Honor,
And if that is what you're able to then use it for, I mean, I'd be happy to limit that this is only for the purpose of that, and it's not for whatever may or may not have happened with regard to some side shooting incident.
And let me just say that in his statements, Mr. Zachary, in his statements, and if he testified, I anticipate, he doesn't deny that there's a group called YSL.
Right.
He doesn't deny any of this. So I don't think that these issues are really.
Yeah, that's what I'm saying is this one may be one that never materializes, because I would say this is potentially admissible as impeachment on the issue that you're saying you want it for, not anything as to whatever this actual shooting is. Understand?
yes, and
Okay.
my understanding about the exercise overall is just to identify those portions that just absolutely cannot come in.
Right. So I don't want you up here saying, so, hey, tell me about this time that, you
Right.
and whomever were involved in this shooting with the, whatever it is.
So unless, right, I understand fully. Like,
Then
in
he
other words,
says
don't
something
try to
different, you're
get
like,
him, don't
"Ah."
try to impeach him just to get in some ancillary, otherwise inadmissible thing.
Correct.
Yes.
Okay. All right, moving on.
Can you imagine if you were the jury on this? Just as confusing as this is right now.
Being 30,
Can you imagine
page
being a juror
36,
having to listen to this?
lines
a
1
wrap.
through 30.
I'm sorry, I haven't read it all, but if it is gang members being happy because Gaither's not working anymore, how's that relevant?
So, Your Honor,
Yes.
I would argue. But I can concede that and say that there's really not, I can let that one go. I
Alrighty.
can stipulate to that.
Okay.
I just like it.
And Your Honor,
And that,
I think I may have made an error on that. 36, 1 to 24 is certainly about that. I'm not certain 37, 8 to 18 is about that same thing.
Okay.
I thought we were just doing the 1 through 24 first.
Yeah. All right. Well, I mean,
If the
he's got
judge
it
is
all
laughing
as
at
number
you,
8,
that's a good sign
so,
that you should stop.
Okay.
All right. So agreed that 36, that part is out. So turn into 37, 8 through 18.
So in 37, 8 to 18, as I understand it, they're trying to identify Tay, and they're showing picture of Tay with a car, and they're saying, is that the car? And then Investigator Underwood and Dennis and Zachary are agreeing, no, that's not the car. That's the car that got shot up by another person named Kel. It's just about Tay's other car that was not involved in the April 28th, 2015 shooting up houses being shot up. It's just
Okay.
talk about another car being shot
All
up.
right, is
Has
that
nothing to do-
relevant?
So Judge, in context 37, Mr. Sharp's objection goes all the way into page 38, unless I'm reading it wrong.
No, it's 37, 8 to 18, right?
It's-
Correct.
Okay. For now, Judge, I can stipulate to that. I don't see any reason to keep that part in right now.
All right, so that is also out by agreement.
And Your Honor, should anything, and I don't anticipate it, but should anything come up that causes me to ask the court, hey, there's something I agreed to that I need to get in now because.
Let's
this
not wait
happened.
until the last minute to do it. Okay.
It would only be it would only be by virtue of something happening on the stand.
Okay, I mean, can you imagine a scenario why it suddenly becomes relevant that some other car that,
It's not the car being shot up, it's Mr. Zachary giving the description of the individuals and his knowledge of certain individuals.
Tay?
Mhm. And
Okay, so
and
that's
boy called
lines
KL.
3 and 4. Is that Tay? Yeah.
And 16, where he's talking about the other boy called Kale. Those sort of instances. I don't foresee them being necessary, but I didn't want to not say to the court, hey, this might come up.
Okay, well, so maybe if there's some issue as to who Kel is. Okay.
And then I think that the next one on number 8 is all of page 38.
Yeah.
It's 38, line 8 to 39, line 11.
Hold on. 38. 8.
Okay.
Through 39, 11.
Really to 39. It's
Through 39, line 1.
the end of 39.
Okay.
Oh,
It's two different incidents. It's a discussion about Tay, people saying on the street. Again, I'm just trying to clean up this transcript. It's just going to be confusing to people. I don't care if.
It's confusing to us now.
I'm in against about Tay one way or another.
Right.
But I'm just trying to limit confusion that
Right.
the jurors would have. And they're talking about people on the street saying that Tay shot up Rich Homie Kwan's dad's barber shop. Rich Homie Kwan's
I have no
father
objection
is a
to-
barber and runs a barber shop.
All right, she may agree.
I have no objection to 8 through with the clarification that he made because I thought it was the whole page.
Okay.
So I have no objection to 8 through 24
Okay,
of
so,
page 38.
all right.
And then on 39, uh, 30 to 39:19, 1 to
39.
19.
39, 1.
39, 9 through 19, or
1
just
through
all?
19.
One, okay.
I have no objection to 1 through 13, where he stops at,
Okay, so 13 is the end of the Rich Homie Kwan
right,
barber shop. And then they
yes.
start talking about Tay shot Kel.
And
I don't represent Tay. Tay's not associated. So, but it's just I just
Alright,
think it would be
is-
confusing.
Why is it?
Tay is associated, that's what we were just talking about, Tay being Trevante.
Right, who is dead and not on trial here, right?
That's true, unfortunately.
Okay, so is it relevant?
In it,
I mean, I would assume you want a clean, clear story to the extent you can have one as well. So is this relevant to the story the state is attempting to tell?
Yes, it goes into over
No, it
into
doesn't.
page
You're lying.
40. There's a video that we're gonna
Not a
have.
video, no.
About with Quindarius Zachary, Antonio Sledge, I think Demekion Garlington, and they're saying they're talking to Shell Kell, who is Ifgang, and I think that they have a gun. That's my memory, that they have a long gun, and they're saying we ain't going back and forth, and they're saying disparaging things. And it's over a girl named Antrevia Smith. And when the court sees Tree in this transcript, they're talking about Antrevia.
Okay.
So to the extent that
This is ridiculous.
that we're talking about one associate or member of YSL Trevante, and we're going on into the fact that Antonio Sledge and Shell Kell were seeing Antrevia. We're getting into information that we've noticed the defense that we're gonna introduce anyway. So I don't know why this would not.
I don't know or understand the nexus between Mr. Sledge threatening Kel on social media over a common girlfriend and Tay shooting Kel. I mean, I'm not talking bad about the guy. I think there was probably a lot of people that had problems with Mr. Kelvin Watts, and
We'll take it out.
Tay shooting.
All right, they'll take it out.
We'll take out. So it's gonna be 15 through 21.
All right, so we already agreed to 39, 1 through 13. So I think this would start at 14. 39, 14 through what?
14 through 21.
I have 4215. It bleeds into number 9. I think that's why I was unclear. I made it its own separate one, this issue.
Wait, what?
To number 9 on my list is the continued discussion about the beef between Kel and Trevante, and they start out with Trevante shooting Kel, and then they talk about how Kel allegedly shot up Trevia's house. Again, something that I don't believe that the police believe is true. That was Mr. Zachary.
We don't.
Saying his understanding was that Kel shot up his girlfriend Trevia's house.
All right, hang on. Ms.
So
Love.
in as much as Mr. Sharp said that the police don't rather believe that Mr. Zachary's line about Kelvin Watts shooting up Antrevia's house, that part is correct, because Antrevia Smith relayed to police when she gave them that video that Kelvin Watts was in the house with her. So in as much as Quindarius Zachary is attempting to push responsibility from what we believe is one member of his group to a member of the opposition group, I would think that would be relevant. It wouldn't be the first thing that I would ask him. It's something that I don't think is inadmissible, but it's also something that at this time, we're going to talk to him. We've noticed the defense about our intent to talk about when Antrevia Smith's house got shot up. It's just not every line of this portion that Mr. Sharp has labeled number 9. We may not get into every single line there, but the topic itself is what we did notice them that we're going to introduce evidence of.
Okay, I think I figured it out. And I'm just going to cut it off, pause it for a second. I don't think anybody's really arguing about this. Okay, I think what the problem is, the state is trying to prove that all of these men here are this humongous gang. So it's not necessarily, but most of us, the watching audience, have been watching it just for the murder of Donovan Thomas. Big Nut. That's the person that we've been watching it for. And that's what we think they're trying to prove. They're trying to prove this humongous, again, this is where the racketeering and the RICO really falls flat. They're trying to prove that these gentlemen are all a part of this gigantic enterprise, you know, and Young Thug is a CEO of crime. And most of us are like, what are you talking about? That's why they keep going around all these different topics, from the club to shooting somebody's house up to Woody's jail interrogation. It's all trying to prove this RICO, not primarily prove the killing of Donovan Thomas. I think that's what we're missing. And if I'm wrong, let me know in the chat. And by the way, thank you so much, Jim, for the very kind super chat as well. He says, DWC, just thank you for rocking it. New to your channel. Love what you do and how you do it. Rock on. Thank you so much, man. Grace and peace. Thank you so much, friend. So I think that's it. Let me know what y'all think. Let me bring this back in and let's make it make sense. I don't know if that's possible, but we're going to try to make it make sense moving forward. Let's go. What you talking about?
You would use to impeach him on a relevant issue and then maybe get back to us on this one?
Yes.
Okay. Because I mean, I kind of hear you saying, even you think not all of it is anything you would want or need. Okay.
And that's all the way through 42.
All right.
So. So the next one is number 10 is 42. Line 17 through 44, line 6. So when the objection is lack of personal knowledge, I am laboring under the assumption that Mr. Sharp's belief is that Mr. Zachary lacks personal knowledge. I would just ask that the court allow it, because it's all opposition actions towards one another. Shell Kell shot up the gambling house. On McDonald Boulevard, Dennis asks on page 43, line 1, that's when Thug's car got shot, right? I believe, if we haven't already, I believe that we have gotten in, we've touched on that there was a shooting where his car got shot. But it may have been with Kenneth Copeland and some of the stuff that we have to redo.
Right.
But Mr. Zachary is saying, yeah, shot up Thug's car. Thug wasn't studying it. All of that information, maybe not like that, but that information we anticipate bringing out. So to the extent that Mr. Sharp objects and has as his basis lack of personal knowledge, I would just ask that the court find that it's admissible subject to the proper foundation being laid for it.
I'm okay. I mean, that seems reasonable if you can lay the foundation.
Okay.
Yes.
Okay. Okay. After consulting with others, we're going to withdraw our objection.
Okay.
All right. All right.
So I'm gonna take that out.
All right. Number 11.
45.
That should,
Or 15.
number 11 should be 46, line
Okay.
15.
46, 15 through 16.
Yes. Well, maybe I'm wrong. I'm wrong. It was supposed to be 45. I'm sorry. They're all talking about an unrelated, they're talking about a girl named Clenethia Rant. And then Mr. Zachary just says she's dead. And then they talk about the circumstances of her
Okay,
murder.
I don't have.
all right, that, she agrees.
Coming out.
Okay,
What's her name?
So
that's 45, 15 through 46,
Yeah.
16. I agree. Okay, let me interrupt y'all a minute. I have word that Mr. Copeland is here and available right now, so why don't we pause what we're doing with this and
Wait, what?
have him in, see if
Wait,
he
what?
has an attorney, see if he wants an attorney.
Woody is here.
We don't yet have anything put together that I'm going to advise him of, but
I'm good.
We-
All right, let's go. Something
get
good.
through a little bit more of this, tell him to hold tight.
No, don't hold tight.
Take a
Let's
lunch
go.
break where y'all can come up with something. But I could at least find out about the attorney issue right now. Okay.
Let's go. Woody in the house. Something interesting. If Woody come in here and say, I'm gonna declare, I want to know who told him that he had to submit to the immunity agreement. Oh my gosh. Oh, talk about end of the day, midday fireworks. Uh-oh. Let's go.
Hi, good morning, Mr. Copeland. I'm Judge Whitaker. I think you've been before me before in unrelated matters. But I'm the judge taking over this case now. So go ahead and have a seat. What I want to ask you right now, I know that you have been given immunity with regard to your testimony. And there had been, at some point, you didn't want
Let's
to testify. At
go.
some point, you did want to testify. The first question I have for you.
I know one to testify.
Okay, the first, well, right, want to is maybe the wrong term, but my question for you right now is, do you have an attorney at all?
I don't know.
You don't know whether you have an attorney? I would think that would be a no then, if you don't know
I
whether you
said I was talking to Melanie, but
Melnick?
yes,
Okay, didn't he ask to be relieved as your attorney, and did you sign something saying that's okay, you can get out of this?
I don't.
You don't remember? Okay. Does anybody know whether that actually occurred?
I don't believe it occurred.
Okay.
I believe that Ms. Bumpus,
I know she was stand-in. and
she was standing and I believe something was said on the record to the effect that Ms. Bumpus was relieved. But
Yeah, I know
don't-
she was.
There was
but-
nothing about Mr. Melnick to my knowledge.
Okay, maybe
There was, Miss Bumpus actually said yesterday, I believe, during her testimony, that Mr. Melnick had directed her to tell Mr. Copeland that he could either exercise his, he
well,
could do
choose
one
not to
thing,
testify.
right? Or if he chose to testify, according to Miss Bumpus.
Yeah, I remember she said, there's this paper I'm supposed to get him to sign. I'm trying to figure out whether it got signed.
So I never got Mr. Melanie off my case.
Okay, so he's still your attorney then?
Facts. There we go.
Yes.
Okay, all right. Well, then that's
That's it.
the answer we've got for that. All right, so I'm going to try to get a hold of Mr. Melnick and see if he can be here with us this afternoon, because some of what I suspect you recall when you were brought into Judge Glanville's chambers with Ms. Bumpus and a couple of the people from the
She brought it
state.
up. It's over.
And there was a discussion that Ms. Bumpus and Ms. Hilton and Judge Glanville had with you. You asked some questions. They gave you some information. Some of that information was not actually factually correct. And I want to make sure that you have the opportunity understanding what it is that the immunity order means.
Yes, come on.
What the potential consequences are if you do testify or if you don't. We're basically going to kind of start over and
So
do
if I
that
don't
over.
testify, so if I don't testify, how long you gonna hold me in jail?
So, I mean, that's still an issue that you can be held in jail through the end of this trial, but I'd rather have Mr. Melnick here to advise you about the potential drawbacks of and benefits of what, if there are any,
This
of any
trial
of
right
your.
To the end of this trial,
Yes,
not the other people.
not as far as I believe, but the state, what, did you want to do some further research on that?
Yes, just to advise the court
Okay.
of.
Okay, so I just wanted to know, first off, do you have an attorney? Because if you do have an attorney, then your attorney may have some information, advice, and research for me about that. So I want to make sure that I tell you the correct thing about that, okay? So we're going to take a lunch break in a little while, and why don't we plan to have you back here on standby at least. I don't know who was in communication, but we need to reach out to Mr. Melnick, see what his availability is. So just be on standby in case I need you here like at 2 or 3 this afternoon.
2 or 3?
Yeah.
You got something to do?
About to take a lunch
He got a
break before
podcast.
Too much longer.
What do you got a
So
podcast?
You're okay to leave for the next couple of hours, but stay where the whomever reached out from the state can reach you to let you know whether you need to be back here this afternoon or potentially tomorrow instead. Okay.
All right.
All right. Thank you. So, I
Wow.
don't know who. Okay, my litigation manager is going to reach out to Mr. Melnick, see if he can get a hold of, see if she can get a hold of Mr. Melnick and find out what his availability is. And depending upon his availability, we'll just see when it is that we have Mr. Copeland back. Because I want him to have the benefit of counsel. And then I also want y'all over the lunch break to work on whatever you think ought to be the correct advice to him. And if you, the state, believe that it is possible to hold him past the trial for which he is under subpoena,
That's
then
wrong.
you show me what authority
Yes, Your Honor.
lets you believe that. Okay.
Your
All
Honor,
right. Yeah.
one thing, I think that the transcript reflects this from June 10th, and as well as Ms. Bumpus's testimony yesterday. She was emphatic that Mr. Melnick said, if you testify, I'm not representing you. So, and with the fact that Mr. Copeland said.
No, what he said was,
Come
if you
on.
plead the 5th, I'm not representing you. So I don't know, what that means. I'm just going to reach out to Mr. Melnick, and at least Mr. Copeland thinks Mr. Melnick is still representing
Right.
him. And if Mr. Copeland never signed whatever that was relieving him, I don't know exactly what their arrangement is, but let's find out from Mr. Melnick.
Yes, Your Honor.
Yo.
Okay, so let's get a few more minutes in of this before we break, because it's not even noon yet. And
All right, that was-
making some progress.
That was interesting.
All right, so we were
Wow.
on
Okay.
number 12.
Okay, a couple things. I'm just gonna pause it. I'm just gonna mute that because it is going back. They're just horse trading back and forth. Matter of fact, let me just turn it down low because I want to say some things before we go to lunch. Because hey, Woody was in the building. We got Woody and Judge Whitaker. they meeting up. That's going to be serious. There's going to be some fireworks there for sure.
Number 12 being page.
I think Love
47,
is scrambling because she knows good and well she's not, that man has an attorney.
14 through
And
page
Judge
59.
Whitaker also mentioned the ex parte. So we know even if Woody pleads the fifth now, the ex parte has been brought into the mix on this side of the conversation. So even if Woody pleads the fifth or they throw out everything, whatever, the ex parte is there now. So now they can talk about witness tampering and coercion and false legal advice, all that kind of stuff like that can be brought up. This is terrible, horrible. Oh my gosh. Let's finish this up.
More than one member of YSL, more than one alleged member of YSL. Mr. Bloody J,
Bloody J,
who is a member of If Gang, was on the other side of the fight from YSL, and other people who are in the courtroom now participated in that with them. So Mr. Zachary's rendition of what happened, that we would argue it's Mr. Zachary's knowledge of and participation in this
Here we go.
gang is what allows him to be able to tell this to Detective Dennis. Mr. Shart's assertion, it does not appear that he was there, I don't think is a ground to exclude it. Assuming that the court is satisfied with the foundation that the state lays for Mr. Zachary's
Being
ability
a
to
co-conspirator.
yes, we would argue that it's admissible. It's
So do you know whether he was there or not?
so
So let me ask Mr. Shart, is the basis for you saying you don't think he was there that no on line 23 when is that the basis of it?
What page, line 23?
47, line 23? Because I don't think that no is actually an answer
Oh,
to.
no,
Okay.
it's not based on that.
Okay.
I
You have no
actually
reason to
do not
believe.
know.
Okay.
I actually do not know
Okay.
he was there, and I haven't heard anyone talk about him being there.
Okay. Do we
And
know whether
and
he
this
was
is-
there?
48 line.
At this stage of the game, I think I was there. Okay, let's look. Everybody was there. All of us were there at
Oh,
this
so
point.
we went back there. Yeah.
Okay,
Okay.
if he was in fact there, then
And
I
then
would
somewhere
draw-
else, he says, would he, okay, all right, well then you'll withdraw that objection?
If he was there, then yes.
Okay. So that number 12 is withdrawn. All right, number 13.
My understanding is this is page 54, line 18, through page 55, line 11.
Yeah, let's take that up first.
So the state has no objection to page 54, lines 18 through 22, where investigator Dennis says, who they say killed him, meaning Donovan Thomas. Zachary repeats the question. Ultimately, Zachary says, shoot, they say Woody and them, I don't know for a fact. So I would agree and argue that he don't know.
Okay.
So it's
He's
not,
telling them,
Okay, so 54, line 18 through 22, you concede should be redacted.
so, and let me also give further clarification. Mr. Zachary, later, he tells earlier in 2015, he relates to law enforcement about statements made to him by two people in the courtroom now. And two people admitting having killed Diamond Thomas.
Okay.
This statement right here is after 2 years later. So, when he says, they say Woody in them, I don't know for a fact.
Mm-hmm.
If somebody argued that that's an inconsistent statement that should come in, I'm not objecting to it coming out because what I feel is a lie is irrelevant, but I'm not objecting to it coming out.
Okay.
So, Your Honor, we got a lot of moving parts here. Because eventually, I agree with Ms. Love. Eventually in this statement, Mr. Zachary claims that Mr. Kendrick told him that they killed Nutt and Mr. Stillwell told him that they killed Mr. Thomas.
Okay.
So I anticipate, because, you know, I was doing this for Mr. Stillwell, but I anticipate other counsel in this courtroom arguing that are affected by this, arguing that this is spilling the beans and it's not a statement by a co-conspirator and therefore not admissible.
Which part are we talking about?
Okay.
I think,
Okay. So, right. Okay.
okay.
So, if I guess I'll rewind. I will say that if there is testimony, either through direct testimony or cross-examine or impeachment,
Mhm.
that my client said something to Mr. Zachary, or that Mr. Kendrick said something to Mr. Zachary, then I would want to get that in.
18 through 22.
Right, because it would be inconsistent with the claims he says later on. You know, here he's saying, well, they're saying Woody and other people,
All right.
but
I
then
don't know.
later on he says, my client directly said this.
All right.
So if that comes in, I'd want to use that for impeachment.
I'd have to know who the they is here. Right, before that could be, if the they is Mr. Kendrick or Mr. Stillwell, yes. But if the they is some random amorphous gossip rag,
Well,
no.
it would be relevant because if he's telling the truth, okay, assuming he's telling the truth.
Oh, I see
He is
I see what
holding-
you mean.
yeah.
If he's already said, or he will later say.
He's going to say that he already said in a different statement, and later in this statement, he's going to say that my client told him
Okay.
at night. And if he's holding that information, then him answering, they saying Woody and them, I don't know.
All right, I still need to find out who the they is then, because the question posed by the investigator is who they say killed him,
I think
right?
ask
So,
who the streets are saying.
okay, well then, for Mr. Zachary to say, here's what the street is saying, is not inconsistent with, but I actually know because the perpetrator told me it's the perpetrator. So that would not be this 18 through 22 would not be inconsistent to a statement by Zachary that Mr. Kendrick and or Mr. Stillwell told me personally that they're the ones that did it. You see what I mean?
I see what you mean. I would argue that would be the time a reasonable person would say, who they say did it. Well, if my client had said he did it, say, well, I don't even need to tell you who they
All right, well, I would reject that argument. So that's out. All right, so next. Is what, 20, page 54, line 23 through 5511, is that all gonna be the same
That is all.
chunk of whatever? Okay.
So we're starting at page 57, line 22.
No, 54. Because all we dealt with was 54, 18 through 22. It goes all the way through 55, 11. So, okay, you was with them at the condo afterwards. I was there. I mean, that,
All of that, we would object to it being redacted out. All of this is, Mr. Copeland talking about.
okay, so, all right. The,
Not Mr. Copeland, Mr. Zachary, not others. So I don't know how.
okay, so now I'm seeing Mr. Shard as I read on further. He's going back to the, well, that's what they say. I don't know for a fact.
Right.
I see
How
what
crazy
you
would it
meant.
be? How
I
crazy
read
would it
that part
be
before.
if after all this, they realize that they have no jury?
God, I don't even know if we're talking about the street here because you was with them at the condo
Look,
afterward.
I knew I was muted. It was a test.
That what
There
they
you go,
say,
see?
I don't know for a fact.
The fact that they ever had a
I'm
jury was just
saying,
a
who
hoax.
did they say killed him? He may at this point mean, who did they, the people you are at the condo with, say? So
Or that the
can
jury is
anybody
compromised.
actually point me
The
to who
jury's
the they
the
is?
jury's gone.
If I flip back far enough?
The
They have
jury's
to at least be
finished.
compromised.
This particular interview, no, not.
Like they had to have
Oh, good
seen
Lord.
something.
There's no way. There's no way. And not just something. So it's not just you have to be able to see something. And I'm sorry. And if
Yeah.
I, I'm gonna lower this down. Everybody, if you're not familiar, this is
there a video
Miss
of
Mandy
this?
Reacts.
All right, I may
My
need to watch the
wonderful
video
second
of
chair has been
this
helping out a
part, 'cause
lot in
maybe
the back. Thank you so
inflection
much.
will let me know whether
It's not
he
just that
means-
the jury
Let
has
me watch
seen
the video
something,
on this. Can
is that the
y'all
jury
send
has
me that
developed
and
an
then give me a
opinion about
timestamp
this
for
because of
part?
this.
Let me
There's
revisit
no
that
way in the
whole
world you can convince me
thing,
that,
including the 18 through
again,
22
as
part.
where I live right here, I live about 40 miles from Fulton counties,
If you
from the
said-
courthouse,
I don't know if you have
and not very far
times
from the
for-
Fulton County line.
but if
There's
you
no
said,
way in the world you can convince me that Fulton
video
residents
that's-
don't know
shows
what's
Mr.
happening
Zachary's
here,
face
and the
and his
12
head,
or 16
I think
jurors
it's an
don't
MP4
know.
video.
There's
I
no
think
way.
it's,
All of this is
right
for
around
nothing. You're going to get those people in,
27
whether it be tomorrow or
minutes,
Thursday,
30 seconds.
and you're going to find out they
30
got Young Thug
seconds.
tattoos.
Thank you.
They've been
For
watching
reference.
Woody on 20v1.
thanks.
It's over. It's done. I'm sorry.
Oh my gosh. Somebody's got a Woody bumper sticker going on.
I'm trying to tell you, they've been racing Woody on. Please understand, Woody has been so reckless in these streets.
Yeah, no, I'll
There's
take
no
a look at
way.
that offline
There's no-
unless
this
y'all
is
got
Do
for
you
it.
hear about
nothing.
it a lot 40 miles away?
I hear about it all
I'll
the
take a look
time.
at that offline
And now,
again.
So
granted,
you know they hear about it even
Yeah, so,
more.
yeah, let's do-
absolutely. And
if-
imagine if you were a part of it and you
if
didn't know, like,
5722
why have I been off for 2 months? Is the case over
Because you know
with?
you got that friend, right? You say, don't tell me anything about it. Don't tell me that. But I got to tell you just one thing. And they text them.
But if you're watching the Olympics here in Atlanta, they'll just do a news blurb right in the middle of their games or whatever's going on, and they give you like the highlights. And they mentioned the longest trial is going on right now. And you're like, oh yeah, that's the jury. I'm a juror on that. Yeah, that's right. There's no way you're not going to know that.
Yep.
This
Yeah.
is just
Well,
an
Chad is
exercise.
smart.
This is an exercise in
All right,
foolishness. I keep saying, man, Maya, that I was gonna go, but I didn't want to go down there, travel down there, and maybe get turned away, or travel down there and can't get in, or whatever like that. That's the only reason I haven't done it. But I probably should. It probably would be fun. But
I'm going to withdraw that.
Okay,
Thank you.
so that one is not objected to.
yeah, this is craziness.
That would be awesome. You could live stream from outside the courthouse.
Moving on to number 14.
Because I would have ran into Woody if I was outside. I would have ran into Woody. He's been out there. Hey,
which
let's go grab
is
something to
page
eat, man.
60,
I got you. Don't
line
even worry, my guy.
19 through 61, line 20.
I could go with Sylvia. I've talked to Sylvia about it. Free Woody. You know it's bad when your case has got people cheering for somebody who just 3 or 4 years ago was named one of Georgia's most violent criminals. You got people cheering for his freedom. That's how bad it is. That's how bad this is. Now,
Sounds
mind
like
you, on that
Karen
same
Lee
list
case.
of the
Same thing.
10 most violent criminals of Georgia, nobody that's being tried in this Young Thug case was on that list.
I'm going to withdraw
I'm
that
not
one.
saying anything.
right.
I'm just saying that.
Okay, then.
Agnew
our
said
next
Woody Putin.
Item is on page
Oh, no, they did not go
65,
there.
lines 8
Why
through
why
20.
why would he
We're on number 15.
Yes.
Listen, all right, Donna, I got you. You're correct.
Oh my goodness.
Oh, you know Woody's been paying attention. There's no way he didn't.
He's watching right now. Y'all say hey to Woody.
Just
Say
Hey,
shout out to
Woody.
Woody. What's up? What's up, Woody?
rendition
Oh
of the
yeah, Woody
law,
came by. Monica, you got to roll back the tape. Woody came
Investigator
through.
Dennis is explaining Quindarius
He's gonna be there this
Jackson finds
afternoon.
Guilty by association.
Yeah, yeah, and I suspect he was not offering that as here's what the law is. He was offering that as here's what we law enforcement consider you to be, but I can understand that. You wanna agree to that, Ms. Love?
Judge, if the court will give me, my counsel is in here whispering in my ear. If the court will give me 1 second.
To get there and consider it, yes, I will give you a second to do that.
I'm here in the court.
We'll see.
The bad thing
Saw
is,
that.
the bad thing is Woody probably he's known enough. He probably would have been a good choice.
He's more qualified.
Right. Shout out to Woody. What's up, man? Well, the problem is the state is, I think the reason they
Give you
come
about
across as domineering
10 more
is
seconds to make your decision.
because they
and I'll
don't
just
have all
make
their
my
ducks in a
ruling.
row. Somebody said it earlier. This is pre-trial stuff. And a lot of this is, but because Judge Glanville was given duck and cover for it, they were able to get away with this and he didn't have to do all this work.
That is out by agreement.
And Your Honor,
Yes.
Wait. I would absolutely. Hey, if somebody wants to shoot, if you live in Georgia or in the metro area and you want to, let's make it happen. Shoot me an email. We'll do it. We'll do it. DearWolfC@gmail.com. Hands down, this is like, again, this is like kids that were supposed to have done a project. They come into class with all the materials to do the project. This is what this is. If you're familiar with the shoebox diorama, I love the shoebox diorama.
I've done
So
my share of shoebox diorama.
They're bringing all the stuff and they're doing it in class. That's what we're watching. And you're supposed to grade them on the rubric, but they're literally doing the project, the typing, the research, the gluing, the cutting, all that stuff in your classroom. That's what we're watching. You know how y'all be doing those projects, those trifold projects, the day before is due, science fair projects? That's what we're watching right here. But somebody's life is
But
on
they're
the line.
bringing all their Hobby Lobby stuff in with them and they're ripping the packages open. That's what they're doing right here.
But we're watching sadly, somebody's life is on the line. 6 men's lives are dangling on the line. It's not just a grade in a science project.
Yeah.
It's somebody's life.
And somebody's in jail waiting, been in jail waiting.
For that part. Wait for this to get done.
saying what it came back to. And then you have Mr. Zachary saying that's Moon's done. But he is acknowledging that he and Mr. Sledge, who the state alleged.
Somebody, hey, look, I love shoebox dioramas. I don't know why. Those are some of the funnest projects I ever did. I love teaching shoebox dioramas. Because I would, you know why? Because I could give like 9 grades for that thing. I was coming up with all kinds of ways to give grades for that.
At lines.
That's why I like
8,
those. Because they would like, this one project could get rid of 9 grades for me. I love
12
it.
through 18.
I do have an issue with 12.
I think I got one of my daughters in the basement. I'm going to find it.
I don't have an issue with him saying that he gave the gun to Moontoon or that's Moontoon's gun. That's fine. What I have an issue with is saying with Investigator Dennis, saying that the ballistics from that gun matched the May 7th shooting of Lucci's Bennett's mom's house. And there's a couple reasons. It's not Bennett put in evidence.
Okay, well, hang on. Maybe we can address your objection and still
It's crazy.
have in the portion that Ms. Love wants it
Okay.
for
No, we
So
don't.
by
really 16 to-
redacting a smaller part of it.
I should have said 16 to 17. If I
Okay.
was
That
to
is
be
one of the
more
funnier names.
precise.
Okay, so.
You spelled it
any
right,
issue
too.
with
That-
just taking, with redacting out
better than me.
16 and 17, Investigator Dennis's statement about it having come back to that.
Not for the purposes of Quindarius Act. No objection.
Okay. So. So that's 66, 17 through 18. Out by agreement.
I don't know, John.
Okay,
I
and
don't know.
next we move to.
I'm not a big news
68,
watcher like that.
24 and 25.
Surely they did.
Yep.
It's,
I was,
Or some YouTuber called it out.
I don't, Mr. Sharp, did that have some issue?
right.
All of this has
They're going
issue.
back
All
to
the whole thing
Lucy's
has issue.
mom's House, and then they're saying the gun you got caught with has something on it until you didn't know it until you went to court yesterday. So I think that should come out 6819.
Okay, so that's, and then maybe we just aren't lined up with
Yeah.
line numbers.
Yeah, that's my.
So 68, 19 through 21, right?
I would say,
25,
because then they go to Lucci mom again.
well, 24 maybe,
Oh,
Right.
yeah, Agnes. I'm
Okay,
sure he's
like-
watching every second.
right?
Yes.
So
Yes,
19
yes, we'll be
through
here.
24.
Cammie.
Out.
We'll be here.
And then
All right, hang on, let's make sure that we've got agreement on that.
so when 19 through 24, so that's page 60.
It's page 68,
Woody's coming.
lines 19
We
through
got to
24.
look. What is coming? Look, we gotta get that in 4K. Might be the most interesting part of
Do you
today.
agree? It's basically the same issue.
The issue that I have here is that I would object to that because Mr. Zachary admits that it has shootings on it. You know, it's one of the guns used in one of the shootings. So even though.
This right here.
As it
Grandma.
relates to the previous portion that I
Uh-huh.
agreed to, and arguably even with the previous portion, the effect on Mr. Zachary, him not denying that or him not expressing surprise, but instead saying, oh, that's no Jules gun. In this particular case, when Dennis says what he says, Mr. Zachary doesn't say, what? Oh my gosh, no. Instead, he says, it has shootings on it. Yeah, it has some shootings on it.
he says
That's
that
some
because
shooting
they
gun.
told him in court the day before. He didn't know.
But Judge, Mr. Sharp can't be the.
All right, so good people, they're gonna keep horse trading
My way
here.
of transcripts.
And I think at this point, we all realize that they don't know what they're doing. I'm sorry. No offense to Adrian Love, but I do not think that she has a grasp on this at all. There we go.
I mean, honestly,
So
it looks
I
to me
want to
like
thank
he's
y'all.
saying,
Hey, this has
yeah, I
been
mean,
a
now that I
pretty
know, I'm
interesting morning.
surprised.
It started off cold, I have to admit,
I mean,
but we got a little bit of wood thrown on the fire.
make that argument.
See what I did
but
there? All right, everybody have a great lunch.
I didn't hear that argument.
I know they're
That
gonna
was
go to lunch
bad.
eventually.
That was so bad.
You see, I did that? Come on now. Come on. That was a good joke. All right. And besides, Cammie knows how to spell Monktunk. And that's hilarious that you actually know how to.
So
The
you're
fact that you knew
saying-
how to spell that is amazing to me.
Hey,
But I've been
Mr.
thinking, like,
Sharp,
how would you spell that?
68,
Anyway,
where is your
we will be back
provision
after
that
lunch. So
rejects
whenever they go to
this?
lunch,
19 to
I will roll the banner
19
across
to
the bottom
24, okay.
and let you know that we'll be coming back.
I
The
am
goal
gonna
is to be back
exclude
here
that.
with Woody and probably Melnick. I don't know if Kayla's going to show up. I don't think so.
All right, now moving. to
Hopefully she's not. She realized
69,
she's
lines
been severed from this, so hopefully she won't have to be there, but we'll see. And that's it. You got anything you want to say, Mandy?
Nope, I'm good. We'll see you then.
All right. Yeah, we're gonna let them keep talking. I'm gonna duck out of here. Lady Dear World Christian has been calling me. So I'm gonna duck out of the way, but I will be back shortly. See you in a second.
Yeah,
Yes.
lines 2 through 6, starting with on January 26th. I mean, they're basically again saying, hey, you had this gun at some point and we know that it was involved in this shooting. We'd like to know who gave you the gun. And they don't have an issue with, we'd like to know who gave you the gun. Just we found out later this came back to the shooting.
That's fine.
Okay, so that is 2 through 6, starting on
I'm gonna
January
stick
26th.
with you guys
are
until
outlined.
lunch. And then we'll be back as soon as they come back.
Okay.
Guys, okay with me till lunch?
And then 17 we already did. So the next one is actually 18, page 69, line 25 through 7213.
And here, let me get this thing.
And
Okay, so Judge,
mhm.
when Detective Dennis asked.
Can you turn your microphone on, please, Miss Love? Miss Love.
On page 69 at line 25.
Mhm.
And Mr. Zachary gives them an answer.
Mhm.
I would argue that all of this is information that
I would argue that your microphone's
should
not
be
on.
able to ask him about. And if he doesn't, if he testifies inconsistently, we should be able to come in.
And
I'm not looking at his reason for.
Really? Come,
yeah,
are you
your,
serious?
There's no
18.
how he knows?
To the extent that my client was there, as he claims, there's no indication that he was there, and there's no indication of what his source of knowledge is. I think he's just passing along rumors. And so if he says, I was there when Lucci.
Is it just me or is the stream low?
And it was Shannon Stillwell that did it, then I don't really have a leg to stand on, but I don't believe he's going to say that, and he needs firsthand knowledge or another exception or another hearsay exception, and I don't see it in the state just kind of saying, oh well, he knows, so therefore it's admissible. There's just so much rumor and back and forth in this case, and I think that the investigators
Stream is low.
criticize them,
Let
but
me
they're just trying to gather information.
see if I can find one that's a little
in
higher.
preparation of trying the case.
A little bit
but
better
just trying to
volume.
get, some broad, generalized, what the word on the street is.
So, Your Honor, as with any evidence or testimony that we elicit or tender, we have to establish a foundation before it's admitted. So we would not be seeking, and this we don't believe is just rank hearsay. So we just have a different position, and we would ask that the court just allows the opportunity to lay the foundation and present it.
All right, and I assume that your foundation is going to be co-conspirator exception, that they all know this because they're in the gang and they communicate and they need to be able to know that argument. I mean, I would think so. And frankly, even on 73, when they asked about what about
See if this
the
one's a little better.
stepdad's house, he actually says, I don't know for sure.
Well, this one's
that
flat.
one. So I mean, he's clearly, if he doesn't know, he's like,
Hang on, bear with me for just 1 minute. I'm gonna take this one down and bring this one up. No, that's not the right one. Give me just a second.
I think that they need to establish who said what to whom and
Okay.
where in the circumstances of that statement, so we can see if it falls under 801 D2E. And
Well-
so I'm in the blind right now.
Okay.
As far as how the state plans to get into that. But
Tell me
what
if the
I don't
volume is
want
better on this one.
is the state, when Mr. Zachary's on the stand, to try to bring up, well, who do you know who shot Lucci's mother's house? And he says, I don't know, I wasn't there. And then they say, well, didn't
Still
you
low.
tell the
Maybe it's
investigator
just low then.
that Woody and Shannon and Pokey did it? And it's like, it was just based on nothing, but it's already out there now.
And Judge, that would be a leap, that would be to say who did it and then didn't you tell them, I would at the very least establish a basis for his knowledge.
Yeah, it seems clearer.
He has said previously or from things that he says on the stand. So it wouldn't be as if it would be some kind of backdoor way to get in somebody's name that, you know, is sitting here in the courtroom. It would be the proper pulling out of evidence of the witness on the stand. It would be established.
I'm going to try 11 alive.
Okay, but we're assuming if this
Oh,
comes
bear with
in,
me.
that it's coming in
I'm
because
working for you.
coming in as an inconsistent statement, you're impeaching him, right?
Okay.
I mean, obviously, if he gets up and you asked him about it and he,
So I'm going to try one more. Okay, here we go.
you know,
Yes.
so I don't know if you,
Okay,
he'll swing back around to
let's
that one.
do this one.
Okay,
Okay.
let's see.
That's clear and sounds good.
I mean, and frankly, it's probably going to be the same.
That
You're going
sounds
to need the
much
same
better.
information for a foundation, regardless of its as to his testimony on the stand or as to this. You know, but yeah, it kind of let us know what that's going to be, so that I can make a determination of whether it comes in, you know, potentially. Well, that was 18. You
Same.
agree about 19,
sounds
so
better
we're
to
moving
me.
to 20.
Sorry, Donna.
And y'all just let me know when lunch gets here and we'll break. Oh, it is here? Okay. We're gonna
She's
break
ready
then.
now. Oh, sis, we just got a dream.
Great. So it's 12:15 right now. So far, Ms. Rosser has not been able to reach Mr. Melnick. So, you know, it's probably more likely that it'll be tomorrow than today. So why don't we, I don't know, maybe I'll know more after lunch, but let's break
Did you,
until
Susie?
1:30. Is that enough time, deputies, for getting everybody fed? Okay. See y'all back at 1:30.
And we're back to the seal of Georgia. What are we thinking so far? Lots of objections, overrules, and stuff that should have been done either voir dire or on a pretrial. This is voir dire stuff. This should not be going on right now. This is absolutely ridiculous. Wow. Ugh, nuts. Absolutely nuts. Okay. So I'm going to put on some music. I'm going to let you guys decide what we listen to. How about some? No. What is with this music, StreamYard? I'm going to need you to do better. That's a little bit better. Now we're talking. refilling this for lunch. Okay. All right. Let's do it. Interruption for lunch. All right. So 1:30, she said. I will see you guys back here about 1:15. Just have fun in the chat. And please follow the moderator's rules. I know y'all will because y'all are the best live chat on YouTube. I'll see you guys in a little bit. Okay, there's only so much of this music that I can take. It was pretty hype in the beginning. Now it's getting to me. So let's change the music. Sounds like a haunted house. I'm kind of feeling it. Oh, okay. I hear talking. I hear talking in the courtroom. I'm not sure what they're talking about, but let's see if we can if we can spy in. I just heard someone say, "You've got to be kidding me." Gain the volume up so we can listen to all the whispers. Okay. Oh, they muted the volume altogether. Oh, they're on to us. See, they do watch Dear Woke Christian. I knew it. I knew it. Well, I tried, guys. I tried. Hello, hello, hello. How is the chat doing? Leave Milnick because I already spoken to Woody about being his attorney. That's why Woody was so sure he is. You may be right about that, actually. That's a really good point. I'm sure there was some kind of conversation going on there. We can't be certain, but that is a very good point. Chicky, that's a good point. As soon as I see motion in the courtroom, I'll of course shut up. But yeah, that's a very good point. Thank you, transplanted Texan. I appreciate you. You guys don't know, like, it's hard to find a good moderator. I have a moderator training course on my channel if you want to check it out at Miss Mandy Reacts. But it's hard to find a good moderator. I've trained many a moderator and like no training needed. Like Transplanted Texan is just the bomb.com. See if I can find some like. Hey, Suski. See if we can find some wild moments. See if we can find some wild moments in this case. I hate voiceovers. I don't know why I hate voiceovers, but I do. But let's see. I'm going to drop this for a minute. We're going to watch some wild moments while we're waiting. Okay. This is the craziest moments in the case so far. Let's see what we got.
Since jury selection started in 2023, the trial, which initially involved 28 defendants, then 14 in 2022, and now 5 in addition to Young Thug, has been consumed by disruption, chaos, and mayhem at every turn. After a grueling 10 months of selection, the trial officially began on November 27, 2023. But during both the proceedings and the actual trial, unbelievable moments have happened. And since it's live streamed every day, many of them have been caught on camera. Here are 11 of those craziest moments. Number 11. Judge threatens to arrest anyone for making outbursts in court. When Gunna appeared at his third bond hearing in hopes of getting out of jail on bond, Judge Earl Glanville denied the YSL rapper for the third time. There were then a lot of loud grunts and groans in the courtroom, particularly from Gunna.
Which I'm just going to say, let that man out of jail. And this is just my opinion, but let that man out of jail. If y'all can't figure out what you're doing, let him out of jail while you figure it out.
Supporters. The judge didn't like that response, so he delivered a stern warning, telling people they could leave if they didn't like his decisions. He then made it clear that if anyone else had any outbursts in the courtroom, he would have them arrested. That definitely set the tone for what type of show Judge Glanville was running.
And if anybody's in the gallery and you can't otherwise control yourself,
sorry, forgot to turn my camera on.
if you want to make any inappropriate comments, then you can leave at this point in time. No harm will come or nothing else will occur. But if you remain in this courtroom and make any outbursts, I'll have you arrested.
Number 10, Judge recites Young Thug's lyrics. As Judge Glanville
He did not recite Young Thug's lyrics. Y'all.
Considered whether to include Young Thug's lyrics as evidence, there came a strange moment when the judge actually read some bars out loud in court.
Tell me he did not.
The questionable lyrics are from Thugger's 2016 song Slime, and Judge Glanville recited them in the most deadpan delivery possible.
Hey, this is that slime. Hey, YSL. Hey, killing 12. Hey,
I'm so embarrassed for him right now.
Cooking white brick. I'm not new to this. Hey, so I'm not new to this. Hey, I'm so true to this. Hey, I done put up a whole slime of 100 licks. Slime or get slime.
The judge allowed the
Judge
lyrics to be included as
Glanville.
evidence, a controversial decision
so
many hip hop
embarrassed for
fans
you
and
right
free
now,
speech
Judge.
supporters are against. Number 9, a Zoom bomber yells "Free Thug" and mistrial. Young Thug fans have been pretty diehard supporters since his arrest and very visible during the trial. One motivated Thug fan even hacked the Zoom link set up by Fulton County to live stream the trial
That's
for attorneys
funny,
who are
actually.
remote. The fan made sure his support of the rapper was known by yelling "Free Thug, mistrial" twice,
Thug.
delaying the trial by several hours as officials had to figure out what happened.
Free Thug, mistrial. Free Thug, mistrial.
Number 8, YSL lawyer tells judge it's cap.
It's cap.
In another strange moment, a YSL
Cap.
attorney responded to Judge Glanville's allegations that he and another attorney were giving their clients candy and offering them cell phone usage before trial by saying it's cap.
I was saying that it's just not true. It's cap, to be honest.
The phrase is popular in hip-hop culture, but not so much in the legal sphere. Yes, it was inappropriate and comical, but it was not very surprising during this trial. Number 7, Young Thug YSL RICO trial witness admits he's high. The YSL trial has been filled with some interesting witnesses,
Wait a minute.
several of whom
Wait a minute.
clearly didn't.
A witness admits he's high and they let him like continue to be a witness? Surely not. They pulled him off stand like immediately. You're high. You cannot testify. Come on me. No. How is this not a mistrial? Like, I know I came in kind of late to the game, but how is this not a mistrial? Like, the Karen Reed case was a straight up crazy disaster, and it got a mistrial for less than this. Are you kidding me?
Didn't want to be there, and it showed. But no one was as blatant about their disinterest in being a witness as Adrian Bean, who admitted on the stand that he was so high he was about to fall asleep.
Oh, is that the guy that said he was
I'm
wrong?
so high right now, y'all. I'm about to go to sleep on y'all now.
After making that confession, the lead prosecutor then handed Bean a bottle of water, and Judge Glanville reassured him a break was coming soon. Number 6, juror jailed for filming court proceedings.
No, they
During the
did
jury
not.
selection process,
No.
a potential juror was
Maya, no.
sentenced to 3 days in
No.
jail for filming the court proceedings. Juror 1004 was handcuffed and ushered out of the courtroom after Judge Glanville reprimanded her for violating courtroom instructions. After authorities discovered a recorded video in her phone's recently deleted folder, the woman argued it was her first time as a possible juror, and she didn't know she was forbidden to film proceedings. Judge Glanville didn't buy it, and off to jail she went. She was released after 5 hours, though.
Contempt is punishable by a fine of $1,000 and or 20 days in jail.
Number 5, judge threat.
I'm sorry. I don't care if you've never been a juror before. You know you can't record it. You know you can't record it. Stop. You was trying to be YouTube famous. Stop. Stop with that craziness. Now that's cap.
YSL lawyer with jail time assigns him an essay. Attorney Eric R. Johnson, who is representing Christian Eppinger, a YSL co-defendant, reportedly refused to buy lunch for other attorneys, and Judge Glanville held him in contempt of court. The judge ordered
He likes
Johnson to write a
contempt of court, don't he?
17-page essay on the
He should be
importance of
held in
professionalism in court. The essay was supposed to be APA style and include 20 primary and secondary sources. Judge Glanville made it clear that if Johnson didn't turn in the assignment, he would face 20 days in jail. It's unclear how the
This
essay
man
turned
likes
out.
putting people in jail.
How are we doing on that paper? I mean, the importance of professionalism.
Number 4, porno gets shown to court on hacked Zoom link. During Young Thug's
They did
very
not
first
get
court
porno.
appearance after his arrest, a fan hacked the Zoom link set up for remote attorneys. The hack showed a pornographic video on screen for the whole room
They
to
got
see.
P-bombed.
The clip also included the words "Free Young Thug." Court officers scrambled to shut the screens off, and the hearing suffered a delay due to technical difficulties after that. Number 3, YSL Polo's erratic behavior in the courtroom. YSL Polo's bizarre courtroom antics caught lots of attention after he made a series of bizarre movements and gestures threatening the prosecutors and jurors during a bad day on trial. The judge did not appreciate Polo, real name Cordarius Dorsey, acting out in his court and asked his counsel to have their client get it together.
Your client, I noticed, has been doing the same behavior, and I believe Judge Adams inquired into it as well. So I don't believe that he may be doing just for the purposes of just drawing attention to himself.
Number 2, Young Thug handed drugs by co-defendant. A drug transaction between Young Thug and another co-defendant was caught on camera during the trial, and it shocked many. Khalif Adams walked over to where Thug was seated with his attorney and dropped a Percocet into Thug's hand. A deputy confronted Thug, and the rapper gave the pill to authorities. To make matters worse, deputies also discovered that Adams had Percocet, marijuana, and tobacco on him in the courtroom. The items had been wrapped in plastic.
I ain't just gonna walk up to Young Thug and hand him a Percocet like, hey, bro, I'm sure you're hurting. Here you go. I got you. This ain't the streets. This is a courtroom. You can't just walk up and hand him a pee. What?
Plastic and sprinkled in food seasonings to conceal the odor. And coming in at number 1, courtroom evacuated after Lil Rod screams during strip search. One of the most disturbing moments in the trial so far happened when a co-defendant was escorted out of the courtroom to be strip searched in another room. Defendant Rodalius Ryan, aka Lil Rod, was removed from the courtroom after he allegedly smelled of marijuana. As deputies searched him behind closed doors, Lil Rod wailed and screamed repeatedly for help and claimed cops broke his arm. Since the courtroom was given no warning prior to Lil Rod's removal, the sound stirred everyone in the courtroom as attorneys struggled to figure out what was going on. The courtroom was evacuated, and deputies did end up finding 2 bags of marijuana sewn into his underwear. The YSL trial is nowhere near over, so more wildness is sure to follow in the coming weeks, months, and maybe even years. Visit the XXL store to buy merch.
Wow. I mean, just wow. All right, I'm going to bring it back up now. Yeah, they should be back on in about 2 minutes, Bruce. I just thought I would show the wildest moments so far. Drug transactions, people having drugs sewn into the drawers. What is wrong with people? Sewn into their drawers. Sure, Maya. I know Judge Witt. She'll be back probably early. Let's see what else we can find here. Thank you. Transplanted Texan. What are some of your favorite moments? Like out of everything that's happened so far, what is your favorite moment? I liked Woody's testimony. I got to admit, I did like Woody's testimony. Yeah, here too. They will take your phone. You have to put it in a basket, and they put a piece of tape with your name on it and put it back. Yes, Woody is going to make an appearance. I think they said tomorrow. I'm almost positive that's what they said. I think they were going to see if they could get him here today, but I think right before they went to lunch, the judge said, why don't we just shoot for tomorrow because we're losing hours today. If I'm not mistaken. Let me go back and see if I can listen to it. Miss Love was speechless. You mean all day today? Her favorite word is So take that back. She's not speechless. She has a word as Listen when she comes back if that's not her favorite word. Trying to find Melnick. Okay. seen where, okay, we have movement in the courtroom. No sound yet. Why is it not coming up on my screen? There we go.
We got everybody? All right. All right, what I know
Nobody sees the representation.
Mr. Melnick at this point is that he is going to be available by Zoom 3-ish, and he was going to, I didn't talk to him. My lit manager talked to him. So I'm not sure we have a super clear answer on whether he currently represents Mr. Copeland, but Mr. Melnick was going to reach out to Mr. Copeland. And maybe by the time we hear from Mr. Melnick at 3, we'll know the status of that representation. All right. Yes.
Hey, Connie.
Am I cold? Is the
Oh, you're
court
welcome.
cold? No, the court's never cold because these robes are really heavy and hot. So no, but I mean, I realize that it is probably objectively a little cold in here, so I might nudge it up a half a degree for y'all. And then if y'all, okay.
Me
Now,
too.
there are 2 other thermostats somewhere in this room, and if y'all want to nudge those up, somebody just go back there and do that. That's fine.
My volume down. Okay. There, my volume's down. Let me see if I can gain up the volume of the courtroom.
All right, so we were, I think,
There, is that any better?
item number 20. Were you able to look through any more of them? And
So what I was doing was the other assignment, which was to look up the law and to look up what we should tell Ms. Copeland. I don't have.
oh, perfect. Yeah, that's probably more pressing. So, okay. What do you know on those?
So I'll start out with just the fact that the language of the statute itself is part of the basis, well, actually was the basis for the interpretation that we had regarding.
Okay, let me get maybe to the statute. Give me a second to get on Lexis. Unless you have a copy of it for me.
I don't have.
That's fine. It'll just take me a second to get it pulled up. So you're talking about 24.5.507?
Yes, Your Honor.
Okay.
So this was the statute to admit that phrase or not admit it?
All right.
So just the plain language of the statute.
Okay. Thank you, Techie. She don't want to move from her desk though. See, there's that problem.
So just the plain language of the statute, Your Honor, which is And in
Hang on a second. Can you not hear her? All right, can you, I don't know, do those mics move?
it wasn't on.
Okay,
It wasn't on.
there we go.
So as I was saying, the
Says
language
what?
of 24.5.507 lays out very specific steps. Only the state can grant immunity, but the court can compel the testimony, which we obviously can't do. And 24.5.507 is a statute that allows us the leeway, the grounds rather, the pathway to get a witness to testify after they have pled
Right.
the fifth. And so
He's not a judge.
Section B of 24.5.507 says, if a person refuses to testify after being granted immunity from prosecution and after being ordered to testify as
This is not a grand
in
jury.
section, such a person may be adjudged in contempt and committed to the county jail until such time as such person purges himself or herself of contempt by testifying as ordered without regard to the expiration of the grand jury. I don't know why it only references the grand jury and not a petite jury, because the top portion of the statute in section A refers to both. And it talks about the fact that if you're needed in a criminal proceeding before a court or a grand jury, if your testimony is deemed by the district attorney necessary to the public interest, then the DA may ask the court to compel that person to testify. In any event, the last line, which says that if the grand jury before which such person was ordered to testify has been dissolved, such person may purge himself or herself by testifying before the court. I don't have the reason that they refer to the grand jury and don't reference a trial jury. But given the fact that the statute itself refers to them almost interchangeably in section A, when they say if you're either brought before the grand jury or a criminal proceeding. And so the fact that even after the grand jury is dissolved, the court can keep you there
Let's see
until
if I
you
can find
purge
a
yourself
higher fee.
of the contempt by giving the court testimony. The extrapolation that I made was you can be kept until you purge yourself of the contempt by testifying, because you don't have a right to assert your Fifth Amendment privilege.
Right. So one thing I would wonder about with regard to that argument is it's sort of a kind of basic canon of statutory construction that if certain language is used in a part of a statute and then it is not used in another part, that there's a reason that it's not used, that there's some significance to at one point saying before a court or grand jury, because
Who that are
they
streaming
clearly knew they
lower than
different language. So the fact that they didn't include it all in the second part, there might be a reason for it.
hey.
So that I think kind of cuts against the argument that I can hold Mr. Copeland throughout all three trials. So I think we need, if there's some sort of case law that indicates that if the testimony at issue is before, like for a trial, that somebody can be held even after the trial is over until such time as they decide to come testify in front of a court about it. So
Thank you. That is much better. Okay.
Haven't fully got it. It's in re long 276 Georgia App 306. I'm
got a case that says the opposite, then that would also,
We know how this volume is.
that answers the question the other way. It just seems to me like if he's under subpoena for a trial, then the point in which it would logically end would be when the trial is over. And I get he may never still purge himself of the contempt, but Mm.
And in reading, and it's a 2005 case, Judge, so I haven't looked carefully at it, so I don't know if it's cited in the annotations.
It is for a different proposition. I haven't read it myself either, but I don't know that this case really answers the question we're asking. Anybody have any other kind of case? I mean, my position without a case to say it clearly one way or another is I sort of feel like it couldn't go past the end of the trial.
But it doesn't say.
But I know that. I mean, one way or another, I'm willing to be persuaded differently if we've got law.
Your Honor, I don't have a case on point, however, it would make logical sense that it couldn't go past the end of the trials. However, Mr. Copeland purged himself of contempt at the interim time between two trials.
Yeah, I mean, I guess the same way that they suggest that
Oh, boy.
if the grand jury
Oh,
is over
boy.
with, you can come purge yourself by testifying in front of the court. Not that either of those really achieves the end that is sought by the immunity order, but it's a way to
They're looking
purge.
for him.
Yeah.
Mom gave me.
Testimony would be under oath and available. I'm
It was not going to be available at, I mean,
not at that trial.
right.
Unless, yeah.
So I'm sort of going with through the end of this trial unless somebody tells me differently. All right, has anybody come up with anything
Yeah,
else
case law.
that he ought to be advised about?
Your Honor, I know that the court did advise him that. Westmoreland, can you hear me? I know that the
Oh,
court.
this
advised
today?
him
Okay, Woody will be in today. So in an hour.
entirely accurate. And just listening to the testimony and looking at the transcript of what he was told, as the court sits now, are there particular points that the court has concerns about? Because regarding perjury, the statute sort of
Yes.
lays it out. And I know that before he testified, the last time, Judge Glanville, I think, gave him a
Gave
copy of it.
Ms. Bumpus to give to him, I think.
No, actually, while Mr. Copeland was on the stand, I think.
Oh, in court.
Yes,
Okay.
he gave to Mr. Copeland, read to him or gave it to him a copy of the statute and apprised him. I think he made.
Okay, right. But all of that was before the ex parte. Y'all, it's already too hot, so I'm gonna have to turn it back up.
Okay.
But I went up a whole degree, so I'm seeing if a half degree will make a difference.
I will survive. So
what were we saying? Oh, yeah. So that was in court, but then the ex parte occurred after that.
It did.
And much closer in time to when he ended up testifying. So I'm thinking that probably was well, who knows, but that may have been the
Who knows?
thing on his mind at the time. So one thing, and I mean, there's, this is he comes in on page, at 10:03, and it goes until 11:30. And I mean, there may have been a break or two in there, but So I realize that it's not just he's told one thing at one point in time, and that's really unclear. I mean, it may be that the gist of it gives him the right information, but for instance, I know there was one thing about perjury that I didn't think was exactly accurate.
Yeah,
Just
it said
as an
judges.
example, if I can find it.
And this
Okay,
is not
so
a grand
on
jury
page
testimony.
1, the example, and I know what Ms. Hilton means. I don't think that anybody is purposefully trying to mislead anybody. I think we're all, you weren't there by the time Mr. Copeland came in, but I think Ms. Bumpus, Judge Glanville, and Ms. Hilton were trying to make sure he understood. But Ms. Hilton says, your example that you gave me, what if I said I did something and I know you didn't do it, and you said before you didn't do it? That's not perjury. That is a prior inconsistent statement. Well, I mean, yes, it's a prior inconsistent statement, but it might also be perjury. It might not be, but
It might
I mean,
not be.
there
What,
has to be some,
what did that
proof
statement have?
that it's a lie. But to say that's not perjury is technically not necessarily correct. And you're also talking to a layperson. And he clearly, I don't think, understands. I mean, he even says, I don't understand any of this at the outset. And, we're talking about purge versus perjury. And I just think we need to make sure we give him clear instructions, and then he can make a decision.
Yes, Your Honor. And
They're
I
reaching.
know that
They're
I think I
reaching.
said on the record regarding his attempt to sort of get that information before he took the stand, when he was trying to speak with Ms. Hilton out there in the foyer area.
Yeah, and then, we also discussed the immunity versus statute of limitations. And yes, the immunity, because he has been given immunity, protects him from being prosecuted
Shout out to
based
Dr.
on
Daly.
anything he says, if he says anything. And that is true. But he was also sort of told, you don't have any statute of limitation worries either. And that's not necessarily true. And it may have no practical effect, because if he can't be prosecuted, he can't be prosecuted, even if it's for something within the statute. But it was technically not necessarily 100% accurate information. Whether
Technically
he
not
anyway relied
necessarily
on that,
100%.
I'm not saying that at all. But I just want to make sure we do it entirely, to the extent we can, correctly and accurately.
So would the court be inclined to read him the statute and then respond? I don't know. I'm asking. Respond to questions, because for instance, I even heard, it may have just been a misstatement. Obviously, and people communicate differently, but when Mr. Melnick was saying regarding how his
I know,
testimony
Robin. Is that not nuts?
we use the testimony to, we can't.
So I don't know. Some people keep saying he's got use, and then some people are saying he's got use and derivative use. So I probably need to look at the order.
I wrote the order, and I literally modeled it after the exact words in the statute. Like, I took the statute.
Your AI modeled it.
For the most part. And so the part of the statute that says that no testimony or other evidence required under the order, or any information directly or indirectly derived from such testimony or evidence, shall be used against the person in any proceeding or prosecution for a crime or offense concerning.
That sounds like derivative use to me.
And so that, that was in there from the start. And
all right. And yeah, do you want to, I can, what's the perjury statute?
I will look it up.
And frankly, I'm not sure that either giving him or reading him any of these statutes is going to be particularly helpful. But that's why I would like for him to have counsel, so counsel can explain to him Here's what the perjury statute means. Here's what your immunity order means. Here's what a prior inconsistent statement is. Here is what you face if you decide not to testify regardless of your immunity. And then, sure, if he has any questions of the court, still we can entertain those. But
And I don't know how wise it would be to even make the request that if his counsel seeks to understand the extent to which the immunity exists, like if he would speak to us, but he.
well, maybe we
Can
can
you-
dial down from all of that too. That's been several weeks since y'all all made, assertions about whether or not who knew what when and who was professional and who wasn't. And maybe I'm going to ask Mr. Melnick and you to move past that. And
I'm beyond it. I would.
you're beyond it. Great. We'll see if he is.
And I would endeavor, I would love to be able to fully explain, to allay any fears that he has or concerns about his client's criminal exposure, but 161070 is the person.
I miss Mandy.
And then I ought to know prior inconsistent statements by heart, but which one is that? 24 something. I don't know. I'm sure I have it in front of me somewhere, but I think those would be the 4 relevant things: the order 507, perjury statute, and prior inconsistent statements. Whatever, I'll figure it out later. I can find prior inconsistent statements.
24-6-630. Wait. Twenty-four, 6-6-13. Witnesses prior statement. 24-6-6-13B.
That's what I was thinking, Bruce. While she is looking something up again, I will say.
Ms. Percival's been doing some research,
never
and
mind,
at
I'll
least
take it.
the federal statute on contempt related to kind of their version of immunity is that the confinement can't exceed the life of the court proceeding. So that's sort of, I know we're not the feds, but.
Is court proceeding the indictment, or is it the trial of a severed, because if people are severed? Like
I don't know the answer to that. Yes. Yes, I don't, who said that? You did what? Say that again. Ah, okay. To
Thank
Ms.
you.
Persfield, okay. And do you have a short answer for me?
Yeah, we don't just hold people in custody. As U.S. Supreme Court cited in footnote 1.
Do these people hate microphones?
Our issue is a deposition. The person who testified on the trials coming up. They're not set yet. The government's position is like the state of Georgia.
Government's position is like the state of Georgia here. Just hold the person because the case is not resolved. And the middle district, the district court judge gave reasons. And in the footnote, they gave the U.S. Supreme Court that the contempt is punishable for this trial. And after that, we don't do for other trials that are not set. And the government can't continue the same contempt over and over again. They can bring an obstruction of justice indictment against the person or a contempt criminal charge against the person. But we don't just hold people because it becomes, and there's other cases I can send you, at some point it becomes just punishment. The whole point of civil contempt is to coerce the person to do the act.
Right.
And at some point they're not doing the act.
Yeah.
Otherwise, according to Ms. Love, I mean, according to Ms. Love's reading, we could just hold them until it's 50 years later. Yeah.
Yeah.
I mean, at
Which
some
can't
point,
be the law. And I know you're not arguing that,
Could
but
the court permit me a moment to just review the case that Mr. Steele just sent over?
sure. Did you send it to everybody?
He did. I got
Okay,
it.
yeah.
I just want to read it.
And just
Mr. Matthews.
Similarly, is civil contempt, and I'm looking at in re estate of Banks. In re estate of Banks is going to be 339 Georgia App 144. It says under Georgia law, when the trial court orders incarceration for an indefinite period until the performance of a specified act,
The contempt is civil. A trial court, however, may not continue incarceration for civil contempt when the respondent lacks the ability to purge themselves. Imprisonment under civil sanctions is always conditional, and a party found in contempt may apply for release at any time upon a showing of inability to comply. The moment it appears
Sounds
that there
like
is
the
inability,
judge agrees
clearly
with them on
judge
release, which is
discharges the
good.
party because the purpose of civil contempt is to provide a remedy and to obtain compliance with the trial court's orders. The justification for imprisonment is lost when the compliance is impossible.
Thank you. I think you have hit on the exact case we needed. So that
Oh.
answers the question for me. You can look all
Should
you
we
want,
release him?
but I think that pretty clearly answers the question. Logically speaking, that was kind of what I was feeling anyway, but now we got case law to back it up. Good deal. All right. So
She ordering release?
So I am proposing that if Mr. Melnick is in fact representing Mr. Copeland, I ask Mr. Melnick to please make sure he understands the order, the scope of his immunity, which I read to be derivative use as well, and what perjury means, what false statements mean, what could get him either of those charges, legally speaking. And I know Miss Love, you and Miss Hilton had said there are certain things that even, okay, well, in your discussions conceptually with Miss Bumpus, but I'll leave it with Miss Hilton, had said,
This is great.
I am not intending to charge you with perjury if you do X, Y, or Z. I am intending to charge you with perjury if you do A, B, or C. And Miss Hilton's not here, but you could speak for the state, I would think, as to if there are certain things that you absolutely know, if you say this, and we know we have proof, whatever you need to establish perjury, that you're lying, then we do intend to charge you, if you know.
Oh my gosh.
You know, if you get up and say something that's not material, like, you know, oh, the sky's red today instead of blue. I mean, it's not red, it's blue, but who cares? It's not relevant. Then I'm not going to charge you with perjury for that.
And I think that was along the lines of what the intent was, but the intent isn't really an issue. It's reading it. I'll just say I agree with what the court is saying.
And, you know, if you then say, I don't know, I don't remember, blah, 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 to whatever, every question we ask you, then we will impeach you with prior inconsistent statements. This is what this means. And you don't have to explain that. Mr.
This is
Melnick
actually
can
really good
explain all of
news.
that. But I would just propose to make sure that I ask
I'm
Mr.
trying to
Melnick
find
to
the screen
explain
so
all
I
of
can
that. Then
pause
he
it for a
can
second.
confirm, yep, we've done that. And then if he has any questions, we'll take questions. And I'm even happy to say, you know, sort of when you get a jury question, we can huddle and go, I'm planning to say this. What do y'all think? If y'all want me to do that, or I'll just wing it either way. If y'all are fine with me winging it, I'll wing it, but don't wing it. Okay. All right. So that's kind of what I'm thinking we do at 3 or 3-ish or
great.
whenever we have Mr. Melnick available. And then maybe give him, assuming he is the attorney, overnight to fully advise him of everything. And then we'll have him in maybe first thing and find out what he's intending at this point.
Overnight? What's up with that?
May I inquire of the court regarding the court's earlier statement?
You can ask the court whatever. It ain't gonna matter.
Matthew cited. When it talks about an impossibility,
I'm trying to pause the feed, but it won't let me for some reason. I'm sorry.
understanding of that after the trial is over, after this particular portion of this indictment is over, it's no longer possible to purge oneself?
It would no longer be if you've said,
Listen to this
I'd
part.
have to have your motion in order in front of you, but as I understand the motion in order at this point, we need his testimony for this trial. Now, you may
Okay.
also need his testimony.
I'm going to pause it for just 1 second. So that's what she's saying. As long as he does not plead the fifth and he does not perjure himself, then they are going to let Young Thug out of jail. That's what she's saying.
I don't have it in front of me. I can look again, but that's my read on
Okay, I'll cut
this.
my-
I mean, you
I'll
may
cut my
never
volume
try
down.
another person. We don't know that. So how can it not be that, as far as we know, he's no longer able to purge once this trial is over?
Theoretically, given Part B of that statute, would he not?
I've made my decision and I get it, but I don't think that, I just don't think that that supports your argument. So I think unless and until you can bring me more law,
She's made her
I'm
decision.
done
That's
with
it.
it might mean with this part of it. Okay. All right. So let's go back
I
to
thought she was saying both, Monica, but I could be wrong.
narrowing down, figuring out what needs to be redacted out from these
Free Woody,
statements
not
of
Thug.
Mr. Zachary.
Okay. All right.
Your Honor, may I inquire one more thing? If Mr. Melnick intends to not represent Mr. Copeland, what is our position at that point?
I guess we can ask him, does he want an attorney? And
But Woody's not in
have
jail.
inquired, because I don't know the answer
Woody's
of
not in
the
jail,
public
so it would have to be
defender's
Thug.
office, whether in a kind of situation like this, where you have somebody who could have been indicted, who's not currently indicted, who's been given immunity, assuming he would qualify for their services, could they or some conflict attorney
Yeah, Woody's not in jail.
provide
So
representation?
it would have to be Thug.
Judge, I would tend to agree that seems to be the most sensible thing to do. I mean, at any point where someone's liberty is at issue, the court should at the very least inquire as to whether or not there's representation that can help a layperson, Mr. Woody is, navigate his way through these things. So I would agree with the court's inclination.
And if for whatever reason, no, a public defender or conflict defender cannot represent a witness, although I would think they could because of what you said, as long as they qualify, his liberty is potentially at stake, then, but if they can't for whatever reason, then I don't know, we just have to.
Then I would suggest that the court take it upon itself to do the best the court can to advise the witness appropriately without any input necessarily from either party. The court is less vested. Mr. Copeland's testimony in either
So she just ordered.
side, and so
Did
I
you
think it
hear?
would be the court's responsibility at that time.
Well, it's certainly ultimately my responsibility, but I am
Have to run.
soliciting from both sides.
You got it. Thank you so much,
whatever
Mandy.
they
Appreciate
think
it.
would be appropriate.
Everybody drop Mandy in the
to
chat. Tell her thank you so
advise
much.
them about.
I'm back
And
up
I
in
can
here. Let's
then take it
go.
all and look at it and
Sure.
put it together. I'm not saying just because y'all asked for it, I'm going to advise it, but I would like your input on it, particularly given issues that have been complained about his prior advisement. So,
Good.
all right. Okay, so let's turn to, somebody needs a bathroom break. So I know we just got back here 30 minutes ago. Y'all should have gone to the bathroom before then, but we'll
Call
take a
the restroom.
bathroom break
Call the
quickly.
restroom.
I'm just going to stay here.
Well, you stay right there. You stay right there. Okay, so I don't know. I'm super bothered by, at this point in the game, it's fair to say that Woody is a difficult witness at best. At worst, I'm sorry, he's a difficult witness. At best, He is the worst thing that ever happened to the state's case. The amount of hoops that they're jumping through. Listen to Love talk about this man's freedom just all willy-nilly. Like, that's bothersome to me. I don't know why that thing is bothering me. How quickly you all are talking about, oh yeah, we just throw you in jail. Wait, why are you okay with that? Why are you okay with that? You're literally saying, oh, we'll just throw you in jail because you don't do what we want you to do. Hello? Why is there not another option? That's wild to me. I don't get it. I thought Woody was going to come back this afternoon, but it sounds like it's a little bit of conflict if he's coming back today or tomorrow. Does he need Melnick, whatnot? So I thought the last when he was there, I thought she said, just hang around. We might need you around 2:00. So I'm not 100% certain I'm right on that, but one way or another, we will see. So I thank y'all so much. Yeah, Donna is so on the point right here. The state doesn't get any. They've abused time. Like, this is well beyond a speedy trial. This is well beyond a fair trial. At this point, I mean, they're literally doing their homework in class. They're doing the project in class while other people are doing the presentations. That's crazy. They should not. And I'm sorry, that did sound like some threats. That did sound like some threats to me. I was listening like, is this not a threat? They're arguing about whether he can stay to the end of this trial or to the end of whenever, to whenever I decide to let you out. Like, that's not a threat. That's not coercion, right? That's not. Okay. All right. Now I didn't hear contempt mentioned, and maybe I might have missed it. I heard if he perjured himself or if he pled the fifth, if I'm not mistaken, but I hear contempt. So I'm just wondering, like, what's he going to jail for? Maybe I missed it. Maybe I could have missed it. It's very possible. This is just, I don't know. They're just so flippant about it. Like, that's kind of weird to me. Y'all are really cool with just talking about somebody's freedom. Like, you're talking about a gnat somewhere. Oh, there's a gnat over there. Oh, there's freedom for this guy. That's crazy to me. And again, I'm not a legal expert at all. I admit I don't know anything about the law. This right here just seems to be problematic that they're so flippantly talking about this man's freedom. Because at the current moment, he's free. He out there in these streets doing whatever he's doing, living his life. So he's currently free, enjoying life, enjoying the beautiful Georgia sunshine away because he's not doing what you want him to do. You gotta make that make sense to me. I'm sorry. You got to really square that peg because I can't see how you're doing that. All right, let's see. His freedom is in jeopardy for sure. With these people, it's in jeopardy. I mean, sorry about that. With these people, I mean, they're just gambling with the man's freedom. I mean, yeah, like those are threats. I feel like those are threats. Maybe I'm wrong. Please let me know in the chat if you think I'm wrong. Like, JC, you're just a softie or something. I don't know. To me, that sounds threat worthy to me. We're definitely cruising into threat category for sure. Yeah, and in my opinion, I feel like the defense comes in and clears up stuff because the state muddies it up. They muddy up the water, or they say things that are deliberately not right. That's problematic to me. I don't know. That seems super weird that they're able to do that. And let me just make sure I have this ready. I'm confused, Bruce says, about the compelled to testify. The state thinks they can't. They can. I only thought a judge could do that. Right there with you, my friend. Right there. Me and you on the same confused bus together. I have no idea. I thought that the man don't want to testify. Like, why? If your case, again, if your case is so weak that it requires Kenneth Copeland in order to go on, in order to be successful, you don't have a case. My name is Jason. I said what I said. You don't actually have a case. If you need Kenneth Copeland to be the marquee, to be the cornerstone of your case, you don't have a case. You can go ahead and back it up now. Go ahead and take it to the house now, rather than keep wasting people's time and money. Well, thank you so much, Mike. I appreciate y'all. Thank you so much for hanging out with me. What does she say? Laura says Love already planned on threatening Woody with staying in jail until all defendants are tried before the ex parte because they knew he didn't want to testify and his attorney didn't want him to. Come on. To me, I'm at this point, I'm just, and again, during lunch, I talked to a legal expert and they don't even understand. And these are people that know what they're talking about and they don't get like what in the world is happening here. So yeah, I have no idea what the problem is because it's well past like, okay, now we're well overshot mistrial. Okay, here we go. Now I did miss whatever. Apparently, her and Love had a little conversation. I feel like I missed that part. I have to go back and find that because apparently, Siswit and Love had a little come to Jesus. I heard. Oh, I totally believe Love is being vindictive. If her whole case is built off of Kenneth Copeland, and Kenneth Copeland is truly going to tank your case, then she's probably super bitter about that because she realized nothing she does is going to resolve this because everything's built on Kenneth Copeland.
Potential redaction number 20.
Okay, let's go. They're not talking loud.
How about resignation? Because.
Yeah. Fair enough. All right. So, and whenever Mr. Selman joins us, we'll just take a pause with us and deal with that. All right, so we're now going to be on page. We're now going to be on page 75, lines 10 through 78, line 1. Hearsay about who shot at Woody and who shot Boo, and I'll have to look at it. Oh, and by the way, I was, going to circle back and listen and look at the video on that one item, and nobody, to my knowledge, sent me the video, so I haven't been able to look at it yet. Can y'all?
I uploaded, I neglected to inform the court, I uploaded that Dropbox link for recording. So.
I don't know if I still have that Dropbox link. I don't know. Can you just shoot me the link again?
Yeah, sure.
Okay.
I try to keep the same link for the transcript, so I will resend that link. And there's one long version of the video, and there's a smaller one where it breaks it into smaller chunks. I use VLC to operate. I don't know if the court has that player on your system.
I think so. I think we have that one.
I will resend that, Your Honor, right now.
All right, great. Thank you.
There's no reason to believe that they're not. That's the thing,
Okay,
Bruce.
so
I agree with.
I
agree with you agreeing with me.
I recommend that you send the smaller chunks, so the bigger chunks have a harder time.
actually sending, yeah. All right. And is this hearsay?
So, Judge, what did you,
So we're at 75 line 10 through whatever the next thing is, 70, where are we? 78 line 1.
So I don't have any objection to 75 line 10, where Dennis says, what'd you hear about them when they tried to shoot Woody? All the way down to line 17, no objection to that part. But when Quindarius Zachary starts talking about when he says, oh, you talking about where they got shot at, and then Dennis clarifies when they made this post the following day. Zachary says that's when their spot got shot up. That was the next day, though. You're right. And when I think it could be seen a number of ways, but when he says Woody went to the hotel party and basically Kel got locked up when Moochie's mama's house got shot up, and Zachary says, yeah. And Dennis says, right. And Zachary says, yeah. If that portion is being offered for hearsay, if that portion is being objected to on the grounds of hearsay, I would say that that's just a matter of showing a proper foundation. And I would ask that that not be excluded before that foundation is properly laid. If it can't be laid, if we don't lay it, then we don't try to get it in and we don't backdoor it in any way. So I would object to lines 18 through 23 on page 75, lines 1 through 6 on page 76. And as
Okay, well, I mean, that all seems to kind of be like the question on the floor for discussion, right? I mean, they're like saying, okay, what is it we're talking about now?
So, Judge.
Yeah.
Big Boo is someone who's deceased. But, oh, sorry. Big Boo is someone who is deceased, but what they're talking about him getting shot at, that was not what killed him, to my understanding. But this is all just nothing that Mr. Zachary, to my understanding, has any firsthand knowledge of. And then they talk about Woody getting shot at when he went to a hotel party. That case was never charged. I've never seen anyone say they know who shot at him, and this is just more speculation and hearsay. I have no reason to believe that Mr. Zachary was at that party. And then
I withdraw the objection. I'll stipulate.
Okay, so that carries us through all of 76 or down through more, it looks like.
Well, then they
through
start
78 line 1.
Okay, all of it.
Yeah.
Okay. Thank you. So that entirety of what is represented by our number 20 is redacted by agreement. All right, 21. That's page 79, line 14 through 22. Speculation about who shot at Thug's stepdad's house. Hang on, 14. Yeah, I mean, it's pretty clearly speculation.
We don't have a problem with
Okay,
that.
so that is out by agreement. So we pick up from there on line 23 down through 81, line 5.
And that's just, Your Honor, Tyreek, I think there's a gentleman named TJ Rivers.
Uh-huh.
I believe that's his last name. He's not charged in this case. And then Tyreek was his brother, and apparently he was killed by someone at some point.
Yeah, I mean,
has-
that all seems just like, they're kind of like, well, while we've got you in here, what might you know about any other shooting that ever occurred?
Right.
Yeah.
It has nothing to do with this case, as far as I know.
What say you, Ms. Love?
I have no objection to, I'm just gonna go down the list, the latter, page 79, 23 through 24. I have no objection to, page 80, the entirety of page 80. What do we want to do? And up through page 80.
They're saying 81 line 5. Let's deal with that. I mean, that all looks like,
So Slug Trontavia Stevens is a member of YSL. He's already entered a plea in this case. And Quindarius Zachary's association, knowledge of, affiliation with Trontavia Stevens. When investigator Dennis says it went quiet for a little while, and then Mr. Zachary, that is, gives this explanation.
is that supposed to say?
I can go without that. So
All right,
1 through
so-
5 I'll
Okay,
stipulate.
all right. Thank you. All right, and then our next thing is so that one's incomplete, it looks like. 81 line 13 through 82 line what, Mr. Sharp?
I think to the end of 82.
This is embarrassing.
Oh, well. You know, I would say 82 line 6. Or actually 82 line 3. I don't really have a strong opinion about it. I just, my problem is when the police start talking about ballistics and this matching this. I mean, if it's relevant, that information obviously can come in if it's relevant and you know, fulfills all the other requirements, but that would come in through a GBI expert matching ballistics, not through Investigator Dennis sharing information with Mr. Zachary.
Yeah, okay, so Ms. Love?
I have, if it is, and Judge, I apologize, Mr. Atkins just apprised me our server's down, so he wanted to get my external drive to share those videos with you.
All right.
So I was.
That's okay. So we're talking about 81 line 13 through 82 line 3 and
No objection to the rest of 81. So from line 13 down, no objection to that. So 13 to 23.
No, yeah, through 82 line 3.
No objection.
Okay. Thank you. All right. Now we are looking at 83 line 18 through 84 line 21.
That's already been agreed to.
Oh, perfect. Okay. We're looking at 88 lines 1 through 13.
So, Your Honor, let me be clear. This is my understanding. Mr. Zachary, after I read this and then I've since read his other statement. I reviewed them both. I should
Right.
say. I've read them before, but I was unclear if Mr. Zachary was claiming to have been present at the club compound incident. After reading the first in time, second in that I reviewed statement,
Mhm.
it's clear to me that he does claim to have been at compound.
Okay.
My understanding, but there seems to be a blending of what he saw versus what he was told, because my understanding is at some point he flees from the area. He is definitely, by his own words, not on 285 when Lil Wayne's bus is shot. So he can testify, or he has firsthand knowledge, presumably, about things he saw while he was there. But when he says Pee Wee ain't do the shooting, he wasn't there for the shooting. And when he says, I know who left and went behind it though, and he says DK and Shannon. So he's saying Walter Murphy, who's entered a plea deal, and my client went behind Pee Wee's car, Jimmy Winfrey's car. So to the extent that he has firsthand knowledge of things, I concede that he can testify to what he saw, and anything he has firsthand knowledge of that is inconsistent, if he had in fact had firsthand knowledge, he can be impeached. But there's certain things that he speculates, or maybe someone told him, I don't know, but it's not clear to me. So Pee Wee didn't do the shooting. That's a conclusion. He did not witness the shooting. He did not witness anyone do the shooting. So I think that's inappropriate.
Okay, so that is 88 lines 1 through 3, basically. And even the police are like, yeah, we know he didn't do the shooting, so.
Well, people in Cobb County would be interested in that, but.
Okay, well, I don't know. I mean, maybe they're just saying that to see what he's gonna say.
But then he says, I don't
I'm in
know,
Cobb
I don't
County.
know who was exactly in the car. I know who left out and went behind it though.
Yeah.
So to the extent that if he witnessed a cars leave compound, I get it.
Right.
But beyond that, things that he did not witness, that's what I'm objecting.
I understand. So I'm trying to kind of take it piece by piece, because you're saying he cannot say with certainty Pee Wee did not do it unless Pee Wee was with him at the time.
Amongst themselves.
Okay, do you have any basis for?
Well, the portion of it where, so Mr. Zachary, like Mr. Copeland, makes assertions about the shooting itself and who was doing what. And the way that the shooting happened is a person is driving down the road next to a bus. And in order to be able to both drive the car and shoot the bus, from the way that both vehicles are positioned, you literally have to have one hand on the wheel, and it was a precarious kind of circumstance that would be needed for the driver of the car, who is Mr. Winfrey, to also be able to at the same time fire the gun and shoot the bus. So in as much as it reflects his personal knowledge of all the people who were there and what was going on, we would argue that his assertion that Pee Wee didn't do the shooting would be subject to a foundation that, you know, we would seek to lay. And I can't say that we have laid that part yet. I think that he is just saying he didn't do the shooting. He was a party to the crime, but he didn't do it. He was driving. He couldn't have. But
So is Mr. Zachary in a second car that's involved in this?
so he is in another car, but he's not shooting, he's not in that.
He's not in the shooter car, but he says, you know, me and these other people went the other way. So he's
at the compound.
right.
Everybody shows up at this one place where
Yep.
the plane is in about 5, 6 different cars.
Okay.
And 2 of them at least follow the tour bus.
Okay.
He is not in one of the ones that follow.
Okay.
That's a
But
good
he's
question,
there
Donna.
when
We
you
don't
have
know
reason
emphatically.
you have evidence that will support that he was there to be able to say at least that as to the car that wasn't, as to some car, the car that went behind it, that he saw who was in those cars?
What does this got to do with anything?
Okay.
Mr. Zachary says, I know who left out and went behind the car. So he
Yeah.
says, and the fact that he's asserting Buchanan Shannon, if he's crossed on that, I would argue that goes, it's weight, not its admissibility of Mr. Sharp.
Okay, but yes, and thank you. But I guess what I'm at, or what I'm trying to get clarification on is Mr.
Amen.
Zachary. It sounds like from what he's saying is he's there when everybody kind of goes in whatever direction they're going, and you're saying that that's his basis of knowledge for who's in what car, right?
Yes.
Okay.
This is dumb.
Even at the point where, like in line 14 of page 88, he's saying, me and Trontavious, we don't went the other
Right.
way. Yes.
It sounds like that's all kind of contemporaneous that they're leaving out. Okay, so then I get that there is a basis on which to believe that he has firsthand knowledge to be able to say, I know who left out and went behind it. Who was that? Well, here's who it was. But coming back to the Pee-wee ain't done the shooting, if that's something you want in, then
Pee-wee
how
ain't
does
done
he
the
know that, what's your basis for him being able to say that?
At this time, I wouldn't even proffer it. So I would agree to it unless something is said that changes.
Okay.
Because I don't have, there's never been a time where I
It ain't stopped you from wasting time before.
Okay, so then by agreement then, well then why do we need 2 and 3 and 4? Because they're just confusing without line 1,
Right.
right? So 1 through 4 are out by agreement.
Come on.
So then 5 through 13, well, 5 through, how about,
but 5.
how about, I mean, the 5 through 9, I see as kind of a one little answer that he seems to be able to know. They say truth was with them. Well, and then what about that part?
I don't mind 12 through 13 coming out.
Okay. Okay.
So we're at, the next one is 90, page 90, 11, page 90, line 11 through 90, line 14.
Correct.
Those are words of the police.
Oh, Mr. Melnick is here now.
Does that mean
So
Woody's coming?
he's on, not here on the Zoom, virtually here.
Oh, wow.
Do y'all all have the Zoom link? I mean, you're welcome to, I see that'll show up.
I want the
Does
Zoom
it
link.
Show up on that big screen. All right, so y'all can just watch it on the big screen.
All right, let's go.
I am.
All right.
I think I say yes, and yet I think I need to probably turn my camera on. There we go. Hi, Mr. Melnick.
Okay, I see him. There we go.
We can't get enough of you. All right, so the reason I have asked again for you to join us, and thanks for doing this by Zoom at very short notice, but so I have essentially determined somewhat with agreement of the parties that we are just going to start over with Mr. Copeland. And he has an immunity. There is an immunity order in place. He has immunity protection. And I plan to bring him in and find out what he wants to do. And I would like for him to be counseled. And I just had him in here a couple of hours ago and asked him if he had an attorney. And he seems to think that you are his attorney still. And so I'm checking in with you to find out whether that is the fact, either still or again, whether you're going to be representing him, because I'm looking for somebody to just ensure that he is properly advised of what the immunity order means, what he could face contempt-wise, what perjury means, what inconsistent statement means, you know, the typical things you would want to advise your client who's going to be a witness in a criminal case.
Sure. So I've talked to him about all that stuff.
Okay. And so are you his attorney currently?
I am his attorney. Yes.
Okay. All right. So, and you're representing him, that you have in fact already advised him of all of those things?
Yes.
Okay. All right. So I would propose to, unless he just wants to come back this afternoon. I mean, I did think I told him to be available maybe 3-ish. But
Come on.
if you want to be with us by Zoom, but are you available tomorrow to be here in person? If we can have him here in person, that way, if he does have questions as anything's going along, and we're not going to take testimony. I just want to find out tomorrow, does he have any questions? Make sure we clear up a few things, and then, you know, find out what his intent is as to whether he's going to testify in this trial or not. We're just essentially going to wipe all of what he already testified.
Oh my
to
gosh,
start
no.
over.
Your Honor.
He could be there right now.
Okay. Oh, he's here right now. Okay. Apparently he's outside. So do you want to just stand by with us? And if he has any questions?
Sure.
Okay.
Oh, come on. We got, come on.
I would object to him being asked at this. I'm gonna just talk loud. Your Honor, I would object under all of the circumstances for a number of reasons to him being asked at this point whether or not he is going to testify. There have been so that he's made statements. Obviously, the state has brought him in as their witness to proper testimony against people in the courtroom. And he's made representations, true or false, he's made them regarding concerns that he has. He's made them in previous interviews with investigators, not just you.
Okay.
So, Your Honor, in the interest of not having sort of the opposite effect on him, and I'm not suggesting the court would, I'm just suggesting that perhaps asking him at this point might have a
when do you propose I ask him? Because if you're, I don't know exactly what you are suggesting, and I could be entirely off, but if you're suggesting that he has, are you suggesting he has safety concerns?
Well, he has made statements about people being willing to have him killed. Okay.
All right. Well, to the extent that those might be any of the people currently on trial, he is at some point going to have to sit in this witness box and say, with all of the defendants present, yes, I am going to testify because y'all are forcing me to because of the immunity order, or I do not care, throw me in jail, you know, essentially. So that's going to have to be in open court in front of everybody. So If that's your objection,
It was just the timing of it.
so would you rather I do it Friday? I mean, what?
No,
I
no,
don't
no.
understand what it is you want me to do.
What are you doing?
Preference, but I'm gonna, of course, defer to the court. It's just, you know, as I work through everything that I know has taken place, I'm just, trying to, make certain that the interests of everybody are protected.
Okay,
I'm not trying to create a.
No, I understand. And I mean, I'm just not sure what else. I can do it at a later time, but I don't know what that gets us really, other than more uncertainty.
Just
and I also
ruin it
realize
now.
he may say one thing right now and then another thing right before he is brought out in front of a jury. You know, I don't know. We can still check with him again because we are not at this point having a jury in here tomorrow. So at the point when we get to a jury, if we get to a jury again, then I can ask him again to make sure. I think that would probably be advisable, but everybody's here right now. So I would propose that we do this kind of right now. But before I bring him in, does anybody have anything they want to make sure I make clear with him?
Not for me, Judge.
Okay. So Mr. Melnick, you weren't here when we had our discussions about what was the outer limit of how long the court could hold him if he chooses not to testify. And it is my belief that the longest he could be held on contempt would be through the end of this trial. So if you need further discussions with him, let me know that.
I don't think so, Judge.
Okay. All right.
And Your Honor, and I know Mr. Melnick obviously knows how to do his job, but he wasn't, and I don't know how much he's reviewed the transcript.
Let me actually ask him, have you reviewed that transcript of the June 10th ex parte?
Mostly. I haven't. I can't say I've sat and studied every single word of it, but I've mostly reviewed it. Yeah.
So, I mean, the defense believes, and I don't necessarily disagree, that there, in addition to a different interpretation of how long he could be held, there is currently a different interpretation of the correctness of the advice about statutes of limitation. And we also think it doesn't ultimately matter because what is protecting him should he testify to something that he did that's criminal is not whether a statute has run or not anyway, it's that he has immunity. But it's possible that a couple of, every statute that you could be worried about has run is not accurate. So, I think you were aware of where in there they said something about a statute, and you're probably aware that there are things he could still be charged with. And does he understand that not every statute has necessarily run on everything he might be criminally involved in, but it doesn't matter because of this immunity order? Or I don't know whether, go ahead.
Yes, Your Honor.
Okay.
He understands.
All right. And then, are you confident that he has a sufficient understanding of what might subject him to a charge of false statements or perjury?
Certainly he does.
Okay. Anything else y'all can think of on either side of the aisle? Okay.
Yes, Judge, can we inquire as to whether or not Mr. Melnick, and I'm sure he has had an opportunity to discuss with him any potential federal ramifications he may have in regards to his testimony here?
Okay. And I my interpretation of the immunity order is use and derivative use. But of course, we're not the feds.
And Your Honor, the court has every ability to do this, but I would object to counsel for the defense. I've
I've asked them to raise anything that they think we ought to be thinking about. So I invited them to say that. So I don't know whether you want any additional time, having heard that potential issue, Mr. Melnick.
Mr. Copeland and I have had enough time to talk.
All right. All right. Okay, is there a screen where he can actually see Mr. Melnick over there?
Should be right there,
somewhere?
yeah.
Okay, thank you. All right. Let's go ahead and get Mr. Copeland.
Come
in.
on, let's go. Drop a Woody in the chat. Drop Woody in the chat. Let's get something happening here. Let's make it happen. Drop Woody in the chat. Come on, we need something to do up in here. Come on. Woody Wood. There he goes. Let's go. Oh, bro, don't be walking in with your hands behind your back, man. I was worried.
All
Don't
right,
do that
hello
to your
again,
boy.
Mr. Copeland. Your attorney, Mr. Melnick, is with us by Zoom right now. You can see him on the video screen and he can see you. If there's any time you want to talk to him privately, let me know that. And I know y'all have had an opportunity since you and I spoke this morning
Never fails.
from the bench and the stand to talk about the fact that the state is not interested in you pleading the fifth, and in order to avoid you pleading the fifth, they have secured an order that says you now can be essentially compelled to testify because we are acknowledging that anything that you say, we cannot prosecute you for a crime other than perjury or false statements based on something that you might say that would otherwise incriminate you if it weren't for this immunity order. And if knowing that you still choose not to testify, the court can and will hold you in contempt. And what happens in that event is that you go to jail. And the length of time that you could be held in jail for, if you don't change your mind and say, okay, I guess I will take the stand, is through the end of this trial. I don't know how long it's going to last. I think previous projections had been February or March of next year.
No way.
I don't know yet, but I guess that's not outside the realm of possibility. But it would only be through the end of this trial. It would not be through the end of whomever else might be severed from this case and tried later. And I know Mr. Melnick's talked to you in more detail about that. So I want to see if you have any questions of the court about that.
I didn't understand. Now you said it at the beginning.
Didn't understand anything. All right, so.
No, I'm saying like, I heard you, but I don't know what you're talking about.
Okay, so tell me what it is that you'd like more information about.
Everything.
You said something about what they said about immunity?
Yeah.
What you mean?
Okay. Does anybody, I think I've got the order. Mr. Melnick, have you reviewed the immunity order with him?
Oh, you saying it's the same from last time?
Hang on a second. Yeah, the same one as last time. Yeah,
Yes.
that one. So that's the one I'm talking about. And that is still in effect.
So you're saying that changed?
It has not changed.
All right.
So what has changed is, it's my opinion that I cannot hold you in jail if you refuse to testify beyond the end of this trial. I think you had maybe been told something different earlier, and I don't think that is.
So I ain't got to wait
accurate.
till every defendant that's not here.
Correct. But you would, if you choose not to testify despite this order, you would potentially be held in jail through the end of this trial, which might be February of next year, might be March of next year. I really don't know. It ends when it ends. And the state has 100 more witnesses, and I don't know, any defendant might also have witnesses. So it could take a while, but that would be the end of it, would be the end of this trial. Okay. So do you have any other questions? Okay. And do you want to talk to Mr. Melnick anymore about this particular issue?
No.
All right. So I'm going to ask you right now, because I'm planning to have the jury back on Monday. And I am going to tell them we would essentially start over, because I want you to have a voluntary, to an extent, choice and knowing choice,
Ooh.
whether to take the stand and be questioned and cross-examined or not. Knowing that if you do, other than if you lie, as Mr. Melnick's discussed with you, and it's something the state knows and can prove, they could charge you with perjury or false statements, but they can't, if you say, if you incriminate yourself about another kind of crime, they cannot use that to charge you with a crime. And they can't say, you know,
Well, can I speak?
you can,
I
yeah,
have
if you
told
have
the
a,
state,
huh?
I have told the state I have lied and lied
I
and
know,
lied and
I
lied.
know. And,
So how are they gonna be able to question me?
I mean, that'll be their problem. That's their case
Wow,
to
come
make
on.
or not make. I
Wow,
mean, that's
Woody.
not for you or me to worry about. So
They said they're gonna be able to charge me if I lie. Like when it's up to them to choose when I'm lying.
not prior. You've said you've lied and lied and lied in every, I don't know what you've said, but let's even say you've said you lied in every statement you ever gave to the police. If you get on the stand and say that again, or if you say, all right, this one was the truth, that one they cannot charge you with perjury for, because those are things in the past. What they might be able to charge you with is, I don't know, I mean, give me an example of something that you know he didn't do, and well, maybe not, never mind.
Oh my
Can I
gosh.
give you an example for what they told me?
Yeah,
Sure.
yes, and then I'll
Go ahead,
see
keep
whether
talking, Woody.
that's
Go
what I
ahead.
think or not. Yes.
So she said that the only reason she won't lock me up, I just want to know if it still applies.
Okay.
She said if I do two things, if I plead the fifth and I say that I killed Donovan Thomas.
Okay.
She said if I don't say them two, she will not lock me up.
All right. What was the first one?
Pleading the fifth.
Say it again.
Taking the fifth, Judge.
Taking the fifth. Okay, right. And you can no longer, so taking the fifth means I might say something that gets me in criminal trouble. I might give you evidence against me that you could then use against me. That's what it means to take the fifth, is say, I am not going to give you evidence to use against me to charge me. When they give you that immunity order, immune just basically means we can't do this anymore. It's like if you get an immunization, oh, I'm not going to get the measles now, right? Because I'm immune from it. Because it's like getting you a shot that says, I can say, I can admit to a crime on the stand, they can't charge me with it. They have said you no longer have a privilege against self-incrimination because we have committed to not being able to prosecute you, not being able to bring criminal charges against you because of what you say. We cannot take that evidence and use it against you. We can't take that evidence. If you say, well, I committed some crime, here's what I committed it with, I buried it in the yard. They can't go dig it up in the yard and then say, well, we've got this. They can't use any of that. So that's why taking the fifth at this point would get you in trouble. Being held in contempt is what we
So what if they don't have
formally call it.
they facts together? Like they saying something that they don't know what they're talking about, and then they ask me about it.
They can ask you about anything they want to. If in your answer you admit to a crime, they cannot charge you with that crime. Now, if you admit to a crime and they have evidence that is pretty certain that you did not commit that crime. For instance, somebody gets robbed yesterday and they have proof that you were in Europe yesterday. There's no way you could have committed that crime, but you say, yeah, I committed that crime yesterday. That was here in Atlanta when they know you were in Europe, and they got video of you in Europe and you sent a postcard that said, I'm having fun in Europe. That would be proof that you're lying. And so that they could charge you with perjury for, okay? Or false statements for.
Okay.
Okay? So what I want to know from you is when we have the jury back on Monday and you're still under subpoena, so you're still obligated to come, and I'm asking you now, when they're like, all right, we're calling Kenneth Copeland, are you going to say, okay, ask me what you want to ask me, I'll tell you whatever I'm going to tell you? Or are you going to say, nope, I don't care if you throw me in jail. I'm not saying a word. I am not getting on the stand.
It depends on how I wake up.
Okay. All right. Well, then we will just revisit it on Monday morning. So plan to be here at
Wait.
8:45 on Monday morning.
She gonna have
You're free to
the
go for
jury
now.
rehabilitated? That's very, and she's not gonna be there on Friday.
All right, Mr. Melnick, please be with us
Wow.
at 8:45 on Monday morning. Can you do that?
Okay.
Thank
I'm
you.
on a trial calendar with Judge Barwick, but I'll notify her what's going on.
All right. Thank you. Appreciate it.
She should have asked more questions. I'm sorry. All right, what do y'all think about that? Wow.
All right. So there we have our answer to the extent we have an answer. We will revisit this on Monday morning.
Monday morning.
Which is, by the way, when I plan to have the jury back.
There's no way it's gonna be back on Monday.
And we at least, I have some degree of confidence that he understands what his choices are and what his consequences are. Okay, back to Mr. Zachary's testimony. Everybody good? I mean, I know we just took a break. Anybody need a break before we dive back in again? Yes, all right. I didn't take a break before, so I could use one now. Let's take 10 minutes. Be back at 5 after 3.
Okay. Yeah, I see a lot of people saying that this was sad. The judge did her best. He looked scared. Run, Woody. So I wonder if Woody had said, "No, I'm not going. I'm going to plead the fifth when I walk up in here." Like, what would they have done? Would they have arrested him on the spot? Because he could have said, "Look, look, I'm going to plead the fifth on Monday," which, by the way, is foolish. There's no way they're going to be ready on Monday. There's no way. Because they still got at least a day of whatever their horse trading they're doing. She's not going to be here on Friday, which, by the way, she keeps talking about Friday, and she's not supposed to be here on Friday. So what is going on with that? Why does she keep doing that? But anyway, they got horse trading today and probably tomorrow. And when you get the jury in, you still haven't even polled the jury. The jury has not been in for 2 months. They're just going to walk in and get started? There's no way. Come on, man. Yeah, that was wild. All right, let's see. Oh, he would have gone to jail today? Okay, I guess that's why he said that then. Okay. I would have said that too. I mean, at this point in the game, I don't know. How do they know he lied? Now, of course, some grandiose thing that, I committed a crime in another country, that would be silly. But how do they know that he's lying now? If he said that he lied in the past, this is confusing. I mean, literally, Woody could just have fun. And this, sad to say, he could literally come in there and just completely ruin the whole thing. They got to poll the jury, right? There's no way. They're not ready to poll the jury. They haven't even decided what questions they're going to ask the jury. That's why I think all this horse trading that they're doing right now is foolish, because they don't even know what they're going to ask the jury when they get them back. Because you're assuming you're going to get all 16 of them back. Some people say that a person has moved, one of the jurors moved out of the county. What if they moved away? What if they passed away? Like there's too many variables to just be treating it like, oh no, this doesn't matter. Like, no, this really does matter. I agree with you, Ms. Fendi. Woody's going to pull out the stops. And the bad thing is that you could probably go online right now. He's probably on Instagram. He definitely is on YouTube. You can find him and communicate with him. Like, this is crazy. I don't know what I expect. No, I didn't expect there to be I expected there to be some engagement, which we have here. I kind of wish they had let him talk more and just kind of say, hey, tell us what you understand this to mean. Because I think that would have really gave him a little bit more clear guidance, rather than Judge Whitaker just kind of talking. Say, hey, Woody, what do you understand your situation to be? And see where there's some gaps in his understanding. That's what I think they should have done. Shannon, I wish I could understand this. I've had people explain this when all this happened. I didn't get it. Like, how can you compel somebody to testify if they don't want to? I don't want to testify. I don't get it. And what if? And I think the only reason is Woody is a criminal, so they got to use that immunity thing. Because if, like, could they force me to testify as just an average human? Just a run of the mill guy. I try to my best to, abide by the law. Do I have to testify? If they just knock on my door and say, "Hey, we need you to testify against your neighbor." No, I don't want to. I don't want to say nothing. I don't want to. Like, what in the world? I don't know. This is very confusing to me, and I feel like I got 2 college degrees. If I'm confused by it, I'm not putting any hope at all that Woody fully understands it. There's no way. I think Hilton will be back by Monday. I'm pretty sure. Look, trust me, Love probably blown up. Like, girl, you better hurry get yourself back over here. Okay, so his cell phone forensics indicates that he wasn't in the area of Nut shooting at the time. Okay, cool. So I hope he doesn't say that he did it. So, but if he does say he did it, he would go to jail for perjury. Okay, I got that. Okay, so all right. If I go back and listen, I thought she said she was gonna be out all day Friday for an appointment. But hey, if she comes back in the afternoon, that's cool. We'll just start the live stream a little later. That's cool. I'm good with that. Okay. Yeah, I agree. I think Love would have rather him come in tomorrow for sure. They got that SWAT information. What they got? They got their evidence from SWAT, not the law enforcement SWAT, but rather the Southwest Atlanta streets. That's what we call it. It's called SWATs. Absolutely. So if he does say that he killed Nut, let's say he gets on there and says that he does, they would more likely find some way to impeach that and prove that he did not do that and throw him in jail for perjury. That's what I'm understanding. So this is a very wild story. But at this point in the game, man, I'm disappointed because this case should have been over with. It should have been over multiple days ago, if not today, but definitely multiple days ago. It should have been finished. They should have said this thing is total garbage. We got to get it out of here. We got to fumigate the entire courtroom because it's garbage, a big old steaming pile. But they keep dancing around the pile like this thing is garbage. It's done. But I can't wait to see how they try to rehabilitate. I hope we can at least hear them rehabilitate the jury. I think that's going to be some must see TV, in my opinion. Yeah, I don't know. Maybe that's it. Maybe, but see, in my opinion, I hate the fact that win, lose, or draw. At this point, Kenneth Copeland will become a target because of this, whether it be from this gang or another gang or just somebody who wants some clout. And I hate that they're putting his life in jeopardy for what? For what reason? Because you got this trash case. Because if you had a good case, we wouldn't be having this conversation. We would never, they would already been in jail because you had this lockstep case that took 3 weeks to try, and the people repented as they got thrown in jail. I mean, literally, it'd have been that lockstep. This case is so bad. Matter of fact, if it was good, they would have tried it with Paul Howard. There you go. Fonnie Willis wouldn't even have this case. All right, yeah, they have not come back. Let me pull this in just in case they pop back in. Man, Netflix gonna make about 20 series out of this. You don't think he'll sit down long enough? I mean, yeah, Copeland's a grown man. I mean, I agree. At this point in the game, I don't think there's anybody, Melnick included. Like, I don't think Woody trusts anybody. Woody probably trusts Woody at this point. And then if that be the case, then he's just trusting that he knows the right thing to do for himself. And that's probably what it is. So he's probably going to move accordingly. Like, I know what's right for me. I'm going to roll with what's right for me. What's good for me to protect me. That's what I'm going to go with. Yeah, if their witness pleads the fifth, they don't have a case. It just seems like just such a foolish argument. We are all confused. Watch this. If we are confused, how do you think Woody feels? And how do you think the jury, who's not been paying attention to this for the last 2 months, 8 weeks, how do you think they feel when they get injected into this? That's my point. If they prove you have evidence, they can serve you a subpoena unless you hide till the trial is over. Okay. Then I guess that's the case then. I mean, so maybe you can't say, I don't want to testify against my neighbor. Okay. But it seems like they're running on the fact that the person is a criminal over anything. So I wonder if, like, for example, if my neighbor committed a crime and I find out that they come to get my neighbor and I'm really in good with my neighbor and it's such like that, no, that probably wouldn't work. Yeah, I have no idea. I just know that the poor jury is going to be, they're going to be so confused. Let's just pretend they're able to come back on Monday. They're going to be so confused. I don't know. At this point in the game, Cat, I think they're just making up the proof. I mean, I don't think the state has any evidence to the points that they're making. Even in somebody's talking about phone usage. Even in that, they use it as to corroborate something else, like closed caption cameras or physical evidence. They don't just run with, I don't think. Hopefully they don't. Let's go. Drop a one in the chat if you can hear.
Okay. All right, so I think we are on page 90, lines 11 through 14.
Cool. All right.
That's law enforcement speaking, basically saying that how Shannon involved in everything. So when they hear his beef, it's almost like call Shannon. That's the detective.
Mm-hmm.
And then the other detective follows it up with Shannon, the shooter.
Yeah.
Now, I will say on page 90, line 14, I should add this. I've reviewed all these statements and I've written notes where I feel that the transcript is insufficient. And my notes I have on 90, line 14,
Mm-hmm.
Underwood, Investigator Underwood says Shannon the shooter. And then Dennis says because, and then Underwood says Shannon the shooter again.
Okay.
So that's my objection, is to the police
All right.
labeling my client the shooter.
Well, the answer is good for your client.
I understand that, but I just,
But yeah, all right, what does the state say?
Your Honor, it's a question, it's
No.
not an assertion.
No.
They're asking is Shannon the shooter, and the inflection given by any person repeating it wouldn't do as much justice as listening to it.
Well, I will happily listen to that as well. But even if line 17 is a question that is saying Shannon the shooter,
Right.
then we probably could just go with line 17 and not like the 11 through 16.
So.
What do you think?
So 11 through 13, we would object to being excluded because that's Detective Dennis asking of Mr. Zachary something about one of the defendants currently on trial based on Mr. Zachary's relationship with him and affiliation with him. I don't have any objection to 14 through 16 coming out.
Okay.
That's what they want, but we would ask that the court, I think Mr. Atkins has had an opportunity to send the link to the, no, he hasn't. He said it's taking 31 minutes.
Yikes.
So I may be able to, I don't know if.
I mean, if y'all have it and could just pull it up, I can listen to it right now.
then also I'll bring it to you.
Talk into your mic, please.
On line 21,
Yes.
Investigator Dennis, my notes say, where it says indiscernible, it says about that action.
About that action?
Yes.
Okay.
Speaking of Shannon.
And let me ask y'all, are y'all actually providing a transcript to the jury when you play these statements?
I believe we may have done it once.
No, they're not.
I did intend that we clean up the ones that we have and provide a copy to the defense and see if they disagree with any
Okay.
cleanups and allow the jury to use the transcripts because they tend to prove helpful, but that we hadn't gotten to the cleanup part yet. We haven't cleaned it up entirely, and sometimes if the defense has a transcript they'd like us to use and like us to use, we welcome that as well, but right now.
Okay. And I don't know if the defense would have any kind of a position on whether on that issue.
There's a lot of issues with these transcripts, a whole lot, and just in all honesty, Your Honor, I don't see how we could agree to a transcript without all of us just sitting in here and going through with a fine tooth comb.
No, I agree. And it may come to that, but it may be, a lot of times I think when audio video is played, at least in my courtroom upstairs, there are a lot of times when it's hard to hear. It's kind of like muffly. Even if I take it in my office and listen on my computer and I can hear it crystal clear, for whatever reason, once it gets out here and gets played through, whatever, it's not as clear. Now, maybe down here in 1C, it's a better audio video system and everything's been clear. But I guess if it comes to it, we'll sort it out then. But
Judge, I can on behalf of Mr. Williams, I can tell you at this point that we're going to object.
Like I hear this voice who is talking. All right.
It's God. No, I can tell you now that on behalf of Mr. Williams, we're going to object to the jury being provided any transcripts.
All right,
based
and
on everything
what-
that's happened so far.
What would the basis of your objection be?
It's been our experience thus far that we just have significant disagreement with the state.
Oh man, what
The
happened?
transcripts that they've provided thus far.
Okay.
And we think, quite frankly, it's better for the jury to make their own determination about what's being said.
Okay. All right. Well, and I mean, it just may be that as we go on, if and when one day this trial wraps and a jury is deliberating, they may want to hear a whole lot over again, and we'll just all have to sit here and listen to it too. So y'all know that, and if that's that's what happens. That's what happens.
And Your Honor, we would also posit that there is the instruction that the court could give the jury about the transcripts not being evidence and that they are indeed supposed to listen and take what they hear versus what's written on the piece of paper as
Sure.
evidence.
Yeah, I mean, so I just was raising that to find out, had y'all already come to any kind of an agreement? What was the practice here with this trial? So it sounds like if you want to do that, first off, you need to endeavor to the extent possible to come to agreement on what a transcript says. And then second, if it's necessary, I will sort out whether I'm going to permit that or not. And I'll listen to the legal reasons for or against. But okay, so if you can tell me, I know that first thing you gave me 27 minutes, 30 seconds. So for this one, where would I be listening? Oh, we're going to play it here. Never mind.
We
Oh,
need the
no.
Zoom link.
Oh, it's the same one as it was a minute ago when Mr. Melnick was on.
Okay.
And for this, because the only sound appears to be coming out of those two little strange white speakers, can y'all turn one my way? And I think that may be the subject or the reason for the squelch, but I'm not going to be able to hear it otherwise, unless somebody wants to come up with a little speaker that I can have up here with me.
What is a plan?
Judge, could the court give me just a minute? I'm trying to get it open and then
Yeah.
trying to get to that point.
Okay. And as long as we're going to do this, we might as well listen to both of the ones, and I don't care which order we do it in, but.
Oh, so there's no audio. Wait, is there no audio? What happened? Okay, I guess they decided no audio. Yeah, what's going on? Oh, you miss Woody? Oh, come on. Woody came on through. He came on through. He said, "What's up?" It was interesting. We'll talk about it for sure. Excuse me. That's interesting. Well, we can hear nothing. But Woody rolled on through.
Y'all can go ahead. I mean, look, is the video matched up with the audio when y'all are showing video in court, or is there a lag?
Sometimes there's a lag
Yeah,
if we use a server, but if we do it from a hard drive.
Okay, so that's what y'all been doing, is using a hard drive.
We've done both, and
Okay.
that's what happened.
All right. What are we going to be doing right now?
A hard drive.
Okay, perfect. Because honestly, sometimes it helps to see what they're saying in addition to listen. What is this? What is this? Transcript.
Home office, is that for Woody's arrival? Oh, I don't have a problem with that. I just think it's just a little bit interesting, but I don't have a problem with it. At this point, I don't think we know anything. I think we're all just grasping at straws at this point. I'm still very confused. Why are they spending time doing this? And they don't know what they're going to ask the jurors when they come back. To me, that's because that's a horse trading. I mean, how are you going to? The defense is going to all disapprove of everything that the prosecution says. Everything. Like, why are y'all not working on that? That would seem to be like that's the most pressing thing, because you're not going to get immediately to this information at least for 3 days. So if you start on Monday, you're not going to get to it till at least probably Wednesday or Thursday. Let's just be gracious. But you're going to have Woody on the stand on Monday. So it means you got your rehabilitated your jury when, because she said come back at 8:45. This is so frustrating because I'm like, what in the world? It does not make sense to me at all, but they're going to keep on doing what they're doing. Yeah, this is uber inefficient. This is so inefficient, it doesn't even make sense. So while we're sitting here, I know you all have been wondering why Steele been so quiet. Steele just filed a new motion to get Hilton and Love disqualified. Let me go find it real quick. This is craziness. Let me let them zoom in on them for a second.
Which one are we targeting first?
The one on page 90.
Okay.
I'm just trying to get. So where we are, the line he's at right now is the line 25 on page 89.
Okay.
So if I may, I'll just.
Sure, that's fine. Yep.
Dang, Slug real just take care of him. So Slug ain't go on the bus yet? No. Well, I told you he grew up even on that. He got J, he hadn't grew up even really on that no more. But you said Shannon. How Shannon get involved in everything? So when they hear his speak, it's almost like call Shannon. Because that's what they say because Shannon too. Now, Shannon always be quiet. Right. He did. Yeah. He's scared. He should. When it comes down to it, he's not scared. Who shot him? Who shot him? They say he smoked. I don't know. I walked up.
All right.
Jail, I read you jail.
I heard what I mean. Okay. That's definitely a question. Shannon the shooter? And then the answer is no. He's quiet. So 17 is fine to be
Can the court remind me of the one before?
Yes, so that was with regard to item number 13. And y'all said it was around 27 minutes, 30 seconds. And I'm wondering, and we may need to play more of it than that, because I was asking, who is the they that they're talking about? And I was just gonna maybe listen a little bit in front of that. But then, so anyway, that was the issue there. So I don't know how much we're gonna need to listen to find out who the they is. Or if we can find out who the they is. But your item number 13, which was on page 54, but I'm thinking we need to go find the beginning of whatever this portion of questioning is. There's a whole lot of days in here.
I think that it would be helpful for the court.
To just have the whole, listen from the beginning. That's fine. I'll do that. That'll be my homework.
Does the court have, or Ms. Percival have a thumb drive? Because I can easily just copy it onto that thumb drive. That's probably the easiest thing to do.
Probably not here, but definitely in my actual chambers. We've got one. Maybe Miss Bugs could bring us one down before we finish for the day. Okay. All right. So I think that answers our on our number 25, which was page 90. We were gonna, by agreement, strike 14, 15, and 16, because you can't hear what they're saying anyway. But leave in, not by agreement, leave in 17 and 18. All right, so okay. All right, that takes us to 92, line 11 through 94, line 22. Dennis, who's Dennis? It's investigator Dennis. Okay.
So okay.
So it's not the entirety of 92. That's just to give me context. Is it 93 line 21 where the real objection starts? 92 line 15. Oh, if y'all don't mind turning those speakers back around now so we don't have squelch.
So,
Matthews, right around the corner.
Thanks.
Yeah, and it's right this way. That's good.
Okay.
So Investigator Dennis was present. He was working an extra job at Club Compound, and he's already testified, and he's provided live testimony about what he observed at Club Compound. Right here, and I think admittedly in the statement, he's just kind of going off his memory and he's confused, and he's testifying about, not testifying, but he's talking to Quindarius about what he saw.
Right.
And we've already heard from him sworn in court testimony about what he saw that night. And this is, in several of the interviews, he goes into what he saw that night. And I just think it's inappropriate for the jury to get Investigator Dennis's version of events through unsworn out of court statements. And they're likely to confuse it with what he said on the stand.
Okay. So can you pinpoint for me on page 92, is there anything? Well, I guess line 15, like
Right. He's leading into it. He's talking about DK, who's Walter Murphy, and I believe it was Pokey. That's Kaikendo, and he's actually wrong about that. Fatty is Kaikendo. And so he's just kind of setting the stage of the people he saw. And then
starting at where? 15?
15.
Okay. Yeah.
And then he's talking about the gun that DK had a gun and he recovered the gun, and how he pulled out his gun, and Jeffrey's sister Max took offense to it, and how the gun was put on Dolly. Dolly is Max. That's the same person. It's on Dolly's truck.
Yeah.
And so he's just reliving what he observed that day, and I just don't think it's appropriate for it to be played in an out-of-court statement like this.
What's the state's response?
Your Honor, with respect to the sections about Detective Dennis relaying and receiving input from Mr. Zachary, information about the Little Wayne bus shooting, as Mr. Sharp said, Detective Dennis was there that night, and as he relayed what he saw, Mr. Zachary's reactions are the more important thing. Obviously, the jury has heard Detective Dennis on the stand, and particularly at line 93.
On which page?
I'm sorry.
Oh, page 93, line
15 through 17, for instance. Where Detective Dennis says, but DK had a gun. I recovered a gun from DK that night. And Zachary says, yeah, I saw that. So Detective Dennis's words impact on Zachary and his responses to them are the more important thing than us trying to have him, as Mr. Shar said, testify. That's not what we're trying to do. Now, there are parts of these that we don't have a problem, consenting to.
All right, well, tell me what those parts are.
Okay, real quick, everybody, just by a show of hands, real quick. Do y'all want to go over
Or
Brian
the opposite,
Steele's
tell me
motion
what parts you
for
really maintain
Brian
you
Steele just dropped a
want
new
/
motion
need /
for
believe
recusal and
you're entitled to get.
disqualification of Adrian Love and Simone Hilton. Do y'all want to go over that, or do y'all want to continue to watch the horse trading? In the chat, drop a fire emoji if you want to go over the motion, or put a horse emoji if you want to keep doing this horse trade. Let me know what y'all want to do.
Okay.
Okay, or just write the word yes. I'm sorry, you could do that as well. As another option as well.
So we'll redact that by agreement.
All right. Let me see, Texan. I wonder, do you want me to do the motion? Okay. All right. It looks like the general consensus is go over the motion. Because it's horse trading right here. Yeah, no more horse trading. Okay, I got you there. I'll take that. I'll take that as a,
Okay.
yeah, they're going to still be horse trading when we get back. So I think, let me real quick trade this out. See what I did there? Trade this out. There we go. I traded it out. Here, let me mute that because I can still hear her in my ear. Oh my gosh. I can still hear Adrian Love in my ear. All right, there we go. Remind me that I muted it. All right. Let's go. Let's look at this. I think this is going to probably be way more interesting than what's going on over there, this horse trading. All right, so Brian Steele is sitting over there just quiet as a mouse. He over there and wrote a whole motion while he's sitting there. You see, this was filed today at 2:57. So this is literally while they're sitting in court. The state of Georgia versus Jeffrey Williams, additional motion to disqualify lawyers Love and Hilton comes now. Jeffrey Williams, by and through undecided counsel, hereby files this additional motion. He is not playing. He said, look, we got an additional motion to disqualify lawyers Love and Hilton in the above reference case. In support of the motion, Mr. Williams shows the follows. Okay, I want to see, I'm going to read through it and I'll try to real quick grab the initial one and see if there's any, what additional things he's added. So let's go. Mr. Williams is innocent of all the crimes in the above reference indictment. Okay. The Honorable Court denied Mr. Williams' original motion to disqualify lawyers Love and Hilton on August 1st. Okay, I remember that. Based upon Mr. Williams' assertion that he intends to call lawyers Love and Hilton as witnesses in trial. So, okay. So he's saying that, look, the reason you didn't disqualify them is because I said I was going to call them as witnesses. I got you. Okay. Okay. Keep going. You cooking. The water's getting a little warm. Okay. Mr. Williams respectfully requests that the Honorable Court to consider the ethical violations made by lawyers Love and Hilton in support of the motion to disqualify. See Ford Motor Company. Oh, so what she was reading this morning. Okay, we'll go over that. The enormity of violations of candor with the court, candor with the counsel, and the denial of ethical prosecutors on this case are too much to permit lawyers Love and Hilton to continue as lawyers in this litigation. The above is just a touch, not the whole thing. It's just a touch of love, a little bit, just a touch of the consistent misconduct by the lawyers Love and Hilton in this case, man. And remember, by filing this goes into appeal. So this will be more information that will be delivered to the appellate court. So if she doesn't accept this or she overrules it, whatever, it'll just be like he told y'all. He told you this is misconducts. So Brian Steele knows what he's doing. He's not just sitting over there being quiet, playing Fortnite. Recently, lawyer Love filed a motion with the Honorable Court that undersigned counsel had a duty to provide work product. Lawyer Love knows the same is untrue in case, and the cases that she cited in this motion do not support the propositions of the law that she asserted in the motion. And he gives an example right there. Wow. This was the fourth time that lawyer Love raised the same frivolous issue, attempting to hide Georgia law from this court that she was explained at the 3 prior hearings on the same exact issue. See, YouTube dated. Oh my gosh. Okay, so April 8th, she did this. July 30th, she did this. And I only see 2 in here though, Brian. There's April 8th, and there's a timestamp. Actually, and the timestamps are backwards too. 750 to 721. Those should be back. Those are, hopefully he'll make those corrections. This one's right. But there's only 2 of them, Brian. All right. In paragraph 11 of the state's ex parte motion for order to compel testimony necessary to the public interest, there's zero truth in the assertion that any defense meeting occurred with Mr. Copeland to impact Mr. Copeland's decision to invoke his Fifth Amendment or any other matter. No defense attorneys, or rather lawyers, on the trial had any connection with the involvement of Mr. Copeland or on or around June 6, 2024. This is a knowingly misstatement by Lawyer Love. Prior to opening statements, the former court ordered all parties to share with each other any demonstrative aids that they would seek to display with the jury during opening statements that were beginning on Monday, the 27th of November, 2023. Okay, I think we all heard that. That's Glanville asked for everybody to show their hands. Okay, so that objections could be made prior to the presentation of opening statement. And we see this on the YouTube channel on Friday, November 24th. All right, so this is when it's supposed to start, on the 27th. And it was Friday the 24th at 4:58. Lawyer Love shared her supposed demonstrative aid during opening statements at trial. Lawyer Love showed a completely different demonstrative aid in the violation of the prior court's order. Okay, got you. All right, and there's a YouTube channel right there. There have been no consequences for Lawyer Love's intentional, unethical, and continued misconduct. During the same opening statement, Lawyer Love defied another pretrial former court order without first obtaining permission from the now recused court by introducing to the jury that undesignated counsel had represented another person charged in this case. What? Okay. All right. Let me make sure. I think I understand that. Specifically, in her PowerPoint, Lawyer Love showed the jury that the undesignated counsel represented co-indictee Blaylock. Okay, got that. Lawyer Love accused undesignated counsel of knowingly and intelligently misrepresenting to the jury that Mr. Bean was taken to Grady Hospital by police from the scene of the arrest on September 11th, 2013. At a bench conference, Lawyer Love falsely stated that she had evidence on her table to prove that undersigned counsel fabricated the evidence that Mr. Bean never went to Grady Hospital on September 11th. Okay, I do remember that back and forth. I think that's the infamous "you're lying, calling me unprofessional." Lawyer Love's allegations against undesignated counsel to the prior court were proven beyond any doubt to be totally knowingly false. And he gives a documentation right there. I think it's killer that he's given all these links, because it's not just something that you can read. It's literally something to go watch. And I think we all can agree watching it is a little bit better than just reading it. Of course, having a live person telling you it is powerful too, but watching somebody talk about it, that's pretty stellar. Okay, so look, yeah, he's got all his timestamps are correct here. That timestamp in the beginning, that first one, was wrong. Over Mr. Williams' objections, when the state was attempting to introduce January 26, 2015, social media postings from co-indictee Garlington's account during the testimony of Detective Gaither, Lawyer Love told the prior court that only Mr. Williams' voice could be heard in the audio, except for one other voice saying, "yeah," in the background. Undesignated counsel told the prior court that Lawyer Love was incorrect and that several persons' voices are audible in the social media posting. Like, man, that's just like, we're arguing about voices on a TikTok. We're arguing about voices on Instagram. That's crazy. That is so frustrating, man, because these guys' lives are in jeopardy, and we're over arguing about that. Lawyer Love falsely accused undesignated counsel of misrepresenting facts to the prior court. Of course, Lawyer Love was proven to be a person who was untruthful and was again falsely accusing undesignated counsel of wrongdoing. This pattern of prosecutorial misconduct illustrates the enormity of unethical conduct of the lawyer, Love, and the state of Georgia in this case. And we got some examples right there. Wow, I wonder why it's spaced out like that. It looks weird. Yeah, interesting. Maybe because it's at the bottom of the page. But there's another good link. On Thursday, the 6th of June, as well as Friday, the 7th of June, Lawyer Love falsely accused undersigned counsel of purposely extracting and tampering with jail recordings of Mr. Copeland. Oh, yeah, we already heard this. Again, this is another knowingly malicious false and allegation by Lawyer Love as she continues in her unethical conduct. Wow. All right. Got to fix that spacing, my brother. On Monday, June 10th, 2024, Lawyer Love, Lawyer Hilton, and now recused trial court attempted to hide Brady evidence. I do think this is going to be powerful. Evidence from Mr. Williams and the other accused that was obtained during an unlawful ex parte meeting with sworn witness Copeland and his counsel. Specifically, Mr. Copeland made statements that everything he says is a lie, that he had committed all the crimes on the indictment and the like. These statements are impeachment for Mr. Copeland and squarely within the concept of Brady and Maryland. Okay, got you. Moreover, lawyers Hilton and Love, with the assistance of now recused judge, notice he doesn't use his name. I think that's petty. I love Brian Steele. Brian Steele is epically petty. Okay. I'm just going to say that again. I love that guy, but he is petty. He is not going to even use the man's name. Told Mr. Copeland that he would not get in trouble if he lied under oath unless he told a bold-faced whopper or a lie. I'm sorry, of a lie that could not be prosecuted based upon some enormous or rather erroneous, please forgive me, theory of the statute of limitations that run and Mr. Copeland would have remained in custody until all 28 co-indictees cases resolved. This is all unethical conduct in order to intimidate, coerce Mr. Copeland to testify at trial. I think we saw that right now. I think we saw that today. That right there is because they literally talk about it. I think they did that today. Okay, let's keep going. The above does not truly encapsulate the horror of working with Lawyer Love and Lawyer Hilton, not to be able to trust a prosecution to provide the simplest and most basic fundamental fairness, such as honesty in the tribunal and honesty of all the courtroom must mandate that both lawyers Love and Hilton be disqualified from this case. Wherefore, Mr. Williams respectfully requests a hearing on this motion, and at the conclusion of the same, ask this honorable court, to grant the above requested relief. And that's today. Wow. And this is a certificate of service. That means that everybody got served the same thing. It's going to be a mess. This is going to be a mess. Oh my goodness. All right. What do y'all think about it? Hey, by the way, real quick, thank you very much. I did not want to let this slide by. Please forgive me for letting this slide by. Kamala Norris says, FYI, go to EWU, search for Woody's police interrogation. All the dudes are ratted out. I'm sorry, he ratted out, and Woody now is saying everything I said to y'all is a lie. Just wanted to go home, so I told the detectives what they wanted to hear. It's a lie. Wow. Thank you so much. And first of all, thank you so much for the very gracious super chat, Kamala Norris. We're going to make you the stream sponsor with that. Thank you so much. Real quick. Thank you. Yeah. To be honest with you, I don't understand. I think as much as the state wants to close the door on a bad case or close the doors on a bad group of dudes, I totally get it. But Woody is such a bad chief witness, star witness. Like your whole thing, your whole franchise is built off of Woody. Like just think about that. That's your whole entire franchise. Your whole entire case is built upon Woody. That's scary. All right, let me jump back over to court. Let's see what they're over there doing. Nothing. Ain't doing nothing. That's a shame. Let's see. I gotta come back to this. I want to talk about this. Okay, they're still horse trading. I'm sorry. I'm gonna point out something. So there was a comment right here, and I talked to somebody during lunch, and I think I got a different perspective. Think about it like this. Hilton is going to be in hot water when she returns. Why? Why do you think she'll be in hot water? Because you and I probably work and live in an environment where if you don't do what you're supposed to do, and your mom or your dad or the teacher or your boss or manager comes and finds out, you're going to be in trouble. Is that fair? Okay. Just think about it. The state has been fumbling and mumbling and rumbling through this trial for what, almost a year, better than a year, and nobody's come through to rescue them. I personally don't think Fonnie Willis is going to do anything. I don't think she even cares. I know that sounds crazy. I don't think they even care. I don't. There's no way. If you believe, like, for example, if Fonnie Willis is some orator, some prosecutorial demigod, you mean to tell me she wouldn't have come in here and shut this foolishness down and just expressed her prosecutorial, wiggled her prosecutorial pinky and got this resolved? I don't think she cares. I don't think she cares. The only time she cares is when this is done and she can put her name on it and say, I prosecuted Young Thug and he got 100 quadrillion years in jail. That's it. That's it. I don't think she cares that it's failing. I don't think she does. Because if she did care, I can't believe that she would not have come and actually stepped in and actually said something. Or even at the worst, does anybody think that Fonnie Willis, again, prosecutorial demigod, she can, just wiggle her little pinky and make everything right? How many of you all think that when Love and Hilton got back to the office, they came in and kind of rallied around and kind of soak up some of the aura of Fonnie Willis and her deep intentional intellect? How many of y'all think that that was the case? That's my point. And the other thing that really proves it to me, remember yesterday, Abati came in yesterday to testify. Do y'all remember his body language? A lot of people were talking about his body language. You do realize that he's a peer of Adrian Love. He's her peer, her contemporary, her cohort. He didn't demonstrate any concern to help her get this done. Anything at all. He looked bothered. Dare I say he looked agitated, perturbed that he had to be here. Just imagine, that's your peer. That's somebody that's on my level. Didn't even want to help me. Where'd you think he get that from? Where'd you think he got that from? You think he got it from the lower links under him? The people that are trying to scrape their way up to the top? You think that's where he got it from? Absolutely not. That's probably they probably don't care. As long as this case gets something done, move some way. I don't think Fonnie Willis cares at all. So to think that Adrian Love is, Simone Hilton's going to be in trouble, I don't think she's going to be in trouble. I don't, because they've been in trouble and nobody's come through to help. Again, we thought Fonnie Willis was going to come in and argue those motions. The best she did was just write it for her, maybe wrote the motion and then signed it, or the response to the motion and then signed it. That's it. Yeah, she's not going to come in running in, on a white horse to rescue the day, to save the day. Absolutely not. These damsels are going to still be in distress, whether this case goes till next year or it goes to next week. They're going to still be damsels in distress. And the only time Fonnie Willis is going to pop up is if they get a conviction. That's it. That's it. I promise you will not see Fonnie Willis at all around this case. All right. That was it. Let me, they still this horse trading over here, man. And it's kind of embarrassing because I thought Woody was going to be a little bit more exciting, if you will. But let's see what you got. Gladiator Girl said, Abati had a look of Love and Hilton screwed this up. Now fix it. Absolutely. Like, think about it. Like, There's nobody's coming to rescue them. Nobody's coming to rescue them. They're going to keep her, Love, and the mute guy and Hilton are going to keep waffling and stumbling the whole way, whether it be to a mistrial, to recusal, to disqualification, to a jury verdict. That's all that's going to happen. There's nobody going to come in and help them. Nobody. I mean, for crying out loud, they didn't even have the interns that are sitting at the table behind them. They didn't even have them yesterday. I don't think Fonnie wrote those motions either. There were some names on the bottom of it, but I think you get my point. Like, that's the best Fonnie's going to do. She's not going to step in there and ruin her image, mess around with this big old dumpster fire. Absolutely not. But trust me, if this case was cooking, if Love and them had prepared themselves, for crying out loud, tell me that Fonnie Willis, well, I don't believe Fonnie Willis is a good prosecutor. I don't think she's a good researcher. I can get in trouble for that, but I don't think she's a good researcher. What I am going to say, though, is I think she's probably better than these people, but not by much. Do you want me to believe that these people are equipped to prosecute Young Thug when they're literally over here listening to jail calls through their right now? Okay. I do believe Fonnie knows. I'm not saying Fonnie doesn't know. Fonnie doesn't care. She doesn't care. If she cared, they would have real support. They would not, Love and Mute Boy would not have been sitting there for 2 days with nobody else there. Love and him would not be sitting there scrambling and scraping with the little cart and carrying folders and files all over the place, looking disorganized and disheveled. They wouldn't be doing that. They'd be coming in there every day, clean and press, ready to impress every day. But they don't, because Fonnie doesn't care. That's my theory. Again, my name is Jason. I'm a pre-K law student. I don't know what I'm talking about, but I've seen people who don't care. I'll tell you, give you a perfect example. As a classroom teacher, especially in the inner city of Atlanta and elsewhere, you see children who don't have parental support. And for whatever reason, there's lots of reasons why parents don't support their children. But then you can tell kids that don't have any support at home. So you already know, if I pick up the phone and call little Johnny's mom, or I pick up the phone or I email, I used to text, I used to do everything to contact little Sally's mom or dad, I know nothing's going to happen. I know that. So I have to fix this problem right here. There's nothing I can do. I know if I reach out to parents, nothing's going to happen. But watch this. At the end of the year, when we have the end of the school year party, hey, how are you? Oh, hi, you're you're little Johnny's mom. Okay. Oh, hi, you're little Sally's mom. Okay, nice to meet you. We've been in school 180 days. Where you been? So, you know it. You already know there's parents like that. This is what I'm looking at, right? This is little Sally and little Johnny. They don't have parental support. They don't have somebody to support them. Now, you could have like a deep bench of family that supports you. I've had families where mom, dad, grandma, the granddad, the baby mama, the boyfriend, they all show up. They all supporting this rascal. Church members, I got church members coming to support their kids. Like, there's some situations where you got a big old bench of people like, man, I can call your pastor. Well, you better sit yourself down, call your Sunday school teacher, that kind of stuff. Tell me that they got that. Now, of course, this is grown folk and they're adults, but they ain't got no support. Nobody's supporting them. They're over here scrounging, hemming and hawing. I'm sorry. There's no way. You can't convince me otherwise. Fonnie doesn't care about justice. Just a check in the win box, and probably thought everyone would plead out. Say this again. I really think that was it. I really believe in my mind that's what they thought was going to happen. Everybody's going to just cop a plea, and it's going to be off to the races. She only wants to vote. She don't care. But this is what I think is the benefit. This is what I think is the blessing of seeing this trial in 4K. Watching what they're seeing. I think the blessing for us is to see this. The blessing for Fulton County is y'all can see this. You don't have to elect people like this. If you get tired of your Lenox Mall turning into a third world country, if you don't like the fact that you can't drive down Peachtree Street without dodging bullets and such like that, you'll change the people that you choose to support and serve your communities. Fonnie Willis is somebody you should probably maybe you should consider changing. I'm just saying. Yeah, I mean, again, like I'm gonna find it. There's a case in New York. They literally just did it. But again, it's got literally every alphabet government entity, the GBI, it was in New York. It was the FBI, the CIA, the ATF, the Homeland Security. There's all of these government entities were supporting this case. And they arrested like 20, 30 of these crazy gang members. It was wild. All at one time. It was a coordinated assault. They got them all and, arrested them, all that kind of stuff like that. There's no way in the world there's going to be two people stumbling and fumbling. And they got caught up on Rico, right? But that right there looked like Rico. It smelled like Rico from the watching on screen, like, yo, that's Rico right there. That's it. This right here just looked like you just want to put somebody in jail, want to highlight. I'm just saying. All right. They're not equipped. I'm sorry. This is a bold statement. Blurry lines. Y'all don't nobody. I don't think this team is equipped to go against a doggone high school debate team. I'm sorry. I just don't believe it. If this is the level of preparedness that you have after a year, let me get a high school debate team. I can go get some high school dropouts and get them prepared to at least debate you on some topic. I mean, come on. Like, this is insane. And again, the part that really gets me in the feels is that this is these men's lives. We're not talking about something ancillary like debating about, HOA covenant agreements or whether or not Starbucks puts too much doggone coffee in their each drink. We're not talking about that. We're talking about these men's lives. Their actual living, breathing lives are in jeopardy. And these people, these unprepared, dare I say, unqualified, unscrupulous villains are holding their lives dangling over a flame. That should scare everybody that's breathing. Dear Fulton County, y'all got to do better than this. What the jury already has been through, how the judge is going to tell them to disregard much of what they have heard. I don't. At this point, Dee, I'm just here for the laughs and the giggles. I'm just like, you know what? I'm just glad that Jesus Christ is Lord. And at the end of the day, he will judge rightly. That's the only hope and faith I have. Because I don't believe that Fonnie Willis could judge whether her right foot is in front of her left foot. I don't think Adrian Love could determine whether or not she has a pink jacket on right now. That's how bad it is. I have zero faith in it. None whatsoever. She doesn't even know there's a pink jacket. And she put it on. So I'm not going to lose any sleep over this. I watch this and I converse with y'all because I think it's super interesting. And again, it's right here in my hometown. I live here in Atlanta. I could drive and I could be on the camera like, hey, that's me. I'm not going to do that. But again, like I think it's super interesting. But to hear and to see just the amount of that thing right there where they were debating about whether or not they could throw Woody in jail, that kind of broke my heart. I'm like, I don't know Woody from a can of paint. Right? I don't care. But I'm like, yo, y'all over here horse trading a man's freedom. Y'all over, yeah, we can just throw him in jail for like till we get tired. Yeah, I could throw him in jail till my athlete's foot clears up. What the heck's wrong with you people? Yo. I'm talking. I'm not listening to the court because they ain't talking about nothing. I'm sorry. No, I'm sorry if I'm loud. What they're talking about, they've just been wasting our day. And I'm on a rant. So I do apologize if you're new to the channel, please forgive me. I just wanted to rant. I'm perturbed. Again, I'm listening to these people horse trade a man's freedom. Oh yeah, hey, we can keep him for 5 years. I'll keep him till the end of the trial. And then, yo, hold on, time out. Yo, you unqualified villains. I feel like we're watching the Injustice League up in this piece. Just pure villainry. at this point. Like y'all are wild. This thing has gone well over over the limit of being insane. All right, y'all, I'm done. I'm finished ranting. Let's get it back. Let's see what they're talking about. I'm sorry. Again, thank you very much for listening to my rant. My kids are like, y'all, this is what my dad does all the time. So my kids, they're probably laughing at me. I'm sorry. See, now we arguing about whether it's salmon. See, we already arguing. See. I just can't. I personally, you know what? I feel like we're being punked. I really think we're being punked at this point. I'm sorry. I feel like we're being punked. Oh my gosh. They're talking about little Tony getting into a fight. She says, what's that got to do with the case? Oh my gosh, man. I feel like we're being tricked, man. This has got to be oh my gosh, you got me laughing so hard. I'm crying. Can't hear the court, you said? Can y'all hear the court? Let me know. One in the chat. No sound. No sound, they said. Okay, let's try again. All right. Sorry about that. Hold on one second. Let me real quick. Let me fix that. Sorry about that. They said no sound. All right, my bad. See, that's what I get for sitting there ranting. That's what I get. All right, let's see. We got this right. Can you please let me know if you can hear that? No, this is not going to share either. Darn it. Why is it doing this? That's not right either. Why is it doing this? Hold on one second. That's what I get. That's what I get for ranting. I apologize for that, y'all. All right, let's see this. Let's see. Get this to act and behave correctly. All right. So, for one reason or another, okay, let's try this.
And 18 through 21 seems like that legitimately could come in. And then that brings us
Can you
then
please let me
to
know?
22 through
Did I mute
the
the
next
tab? Did I
page,
mute the
line
tab? Why is the
1,
tab
about,
muted?
okay, here are the details on this mistaken beef again. So that out, and then just 18 through 21 in.
Real quick, can you let me know you hear it? Okay, I'm sorry about that.
Because it seems like
I
20.
did turn it down. Sorry about
You're
that.
okay with that?
I did.
So I don't have a problem with, you're saying 23?
22, yeah. Well, actually through the next one line
Okay,
on the
sorry about
next
that.
page.
Correct.
Okay, so thank you. Okay.
Are we at 109:23 now?
Yes.
Can we go through the exact?
Yes, so on the ones that I just said, okay, so if we go back to page 107, 1 through 13 are in without any objection. 14 through 17 are out by agreement. 18 through 21 are in over objection. No, was there an objection to that, Mr. Short? 18 through 21?
No.
Okay, are in because there's no dispute about it. And then 22 through 108, line 1 are out by agreement. All right.
And then we're moving to 109:23.
Yes.
I have no objection to 23. I have no objection to 23 through 25 on 109. And 1 through 13 on page 110.
Okay. All right, which I guess means that if there is objection to 110 lines 14 through 19, is there?
Yes, because,
Wait, so y'all want that out?
no, we don't.
Yeah, so I'm asking the defense.
Well, if 14 through 19 is played, there's going to be no context to it at all. Because it starts with, they've been shooting at each other for how many damn months? And no one's even going to know The last
Right,
time we talked, they were talking about
right, somebody
Nut
else.
and Greedy and
Okay.
Kel being half brothers, and
Right. So,
I mean, honestly, I'd be okay with. I've identified this as hearsay. I don't have any problem with it coming in, to be honest with you. But
okay,
you know, if the state needs to play 14 through 19, I just say play the whole thing and
Okay.
give context.
all right. So then that actually starts with 109, line 23, or no?
Yes.
Okay, all right, so basically they're withdrawing their objection to that. Page
Oh, there you go.
111, lines 7 through
I
9.
was right. Okay.
Okay, what does the state say as to that?
That Mr. Zachary's response, no, Thug just stopped messing with booty.
Uh-huh,
And the subsequent lines are important evidence in this case. Obviously, Booty is Mr. Copeland. He's the one on the stand right now.
uh-huh.
I can't,
Yeah, no, and he doesn't object to line 10 and 11 and 12. He objects to 7 through 9.
7 through 9 is necessary because they cause the response. That is line 10 through further down. And it is necessary, it is Mr. Zachary's reaction and response to Detective Dennis's question
It's not a question, though.
between.
Yeah, it is a question. I mean, it might not have a question mark at the end
Well,
of
it
it.
says,
I mean,
word I got
Right.
is Shannon started putting in more work than Woody. That is a declarative statement, and it gives the impression that other witnesses have told Investigator Dennis that, and that I've never heard someone tell Investigator Dennis that, and
yeah,
even if they had, that needs to be come from the stand.
He starts out with how did she.
yeah. So the how did Shannon part's really not a problem. I mean, could you redact out after the dash? How did Shannon? And I know we then don't have the word Woody in there, but Mr. Zachary provides the word Woody. No, Thug just stopped messing with Woody.
Why don't we just start with line 9, just with why Thug start pushing Woody in?
That works. Thank you. Thank you.
Thank you.
One 13 line 23, 114 line 3. So do y'all, before we dive into the substance of this, we're not gonna unfortunately get through the entirety of this one statement today. So we can look forward to doing more of this tomorrow. But
We're gonna phone this in
there
tomorrow.
are, how many, two other statements? Okay.
I can provide all of them to the court.
Okay. Here's the thing is, I mean, some of this I am having to make rulings on, but a lot of it, it's like, it might be, and I'm not saying it's the first time you're looking at it, but it's the first time you're looking at it for the purpose of trying to think about whether you're okay with redactions. And that's not really the best use of court time.
Amen.
By which I mean time that we are all here between 9 and 5 in court. So can you endeavor, and I know this is a lot, but y'all should have done a whole lot of this before now. So can
Oh
can
my
we,
gosh.
sort of maybe by the time we all reconvene tomorrow, have a whole lot more of this sorted out so that y'all can hone in on the things that I need to make an evidentiary ruling on.
I have no problem with that. I know
Thank
this
you.
is-
But you ain't did it already though.
He's got, this list is great because I just need, okay, I need the responses to winnowed. All right, great.
Okay, he gave it to us for one of the other interviews. We need the last one, Ms. Priya.
Okay, well, do you have that one ready yet? Mr. Shart is ahead of y'all on these interviews, so maybe while y'all catch up through the rest of these two, he can be finishing the third one. If he doesn't have it yet.
Basically, this is pretrial work. She's right.
I'll talk to the state afterwards. I want to make sure I'm on the same page about the 3 different statements.
Okay. So I'm
This is pretrial work.
sort of thinking, I don't want to do any more of this. How about that? Because y'all can maybe do some things to make it all easier. So I will take a look at the beginning of this video. Y'all, the state, are going to go through what you have so far, which is the rest of this statement, potential redactions, and then whatever the second statement, not in time, but you know what I mean, potential redactions, and have it crystallized more for tomorrow. And tomorrow we also, I think, can't remember what I told you to turn in by tomorrow, but what was it?
Your Honor, we do the open court exhibit.
Yes.
And I have a very nerve-wracked and nervous person working on that. They're asking, what if we don't have everything?
I'm gonna throw them in jail. I'm kidding. I understand this is a monumental task, which again, should have been done before now, but given that it wasn't, we're doing the best we can. If they do the best they can, it's not what we're gonna be dealing with, but it's not for me anyway, it's for the defense. So to the extent they have whatever they have tomorrow, turn it over, and then the rest of it by Friday. How about that? That seems.
But you're not
reasonable.
supposed to be here on Friday.
All right, what else?
Maybe I'm missing it. Maybe I missed it.
The court asked us for, at the beginning of the week, to have the next.
Yes, the next
30
tranche. Yes.
Yes. So
Okay, where are we on that?
we count, even that tomorrow night is the end of the beginning of the week, but I don't know. So we're in there.
You're okay. All right. I'll check in with y'all again on that one. Okay. Mr. Harvey is going to produce a potential 105 limiting instruction within the next couple of days before Friday for me to consider.
Will the court give the state an opportunity to?
Oh, absolutely. Yeah. I mean, but we got to have something to at least start with.
Yeah, I thought she said she's off Friday. Maybe I'm missing it.
Oh, y'all are also all supposed to be thinking about what it is that we tell the jury about why we're starting over with
Now you're
Mr.
gonna talk about
Copeland,
this. Now you're gonna talk about
which
this
may
now.
not, necessarily need to be a whole lot of detail, but we are going to be starting over with him. So it's going to be a disregard everything you heard so far, and then we either hear from him again or we don't. I don't know. We'll find out depending on how he wakes up that morning.
What'd he say? He don't care.
But I'm gonna that'll be, it's gonna be a strike everything you heard, and then we'll see what happens next, But any kind of suggested instruction as to that as
This is
well,
embarrassing.
since we're starting over on him.
Okay.
Yeah.
So you're not talking about trying to offer it up and work it out now?
And no, I think, didn't some people have objection to any of that? Right? I mean, hey, if y'all want to, super, that's easier. But the gist I was getting earlier today was that there were some defendants who objected to that, and that it might be just cleaner to just start entirely over. And frankly, if he ends up, it depends whether he ends up testifying or not. So, I mean, yeah, I'm happy with if he ends up testifying and y'all are like, yeah, we're going to use this day, whatever, all of it, whatever. I don't care. But that's going to have to be because y'all agreed to it.
Your Honor?
Crazy.
Yes.
I knew it.
I thought the
I knew he would come
people
back.
charged here position was, and I think the state's position was just to include the 7th, which really was not anything, and then the 10th, which is Monday, the 12th, which is Tuesday, and part of the 11th, 10th, 11th, and 12th, part of the 12th, but nothing thereafter, not strike everything. There was a lot of exculpatory information on the 10th, 11th.
Here's the deal, though. And if he ends up testifying and y'all want to say those 3 days, great. But if he ends up, since what I am trying to do is sort of circumvent the whole issue of potential coercion and give him an opportunity fully and correctly informed to make a decision about whether to testify, then if he says, no, I don't want to, throw me in jail, then that means none of his testimony should come in unless everybody wants to agree to it, which would be kind of, I mean, an odd scenario.
That seems really
If we don't get
weird. I
to
don't-
cross-examine Mr. Coben, we would like to strike all of his testimony under
Okay,
that
right?
circumstance.
Yeah, right. So, and then, you know, if y'all want to try to call him as your witness, if anybody's calling a witness, then try that. I don't know. If you want exculpatory parts of it, but then that of course comes with risks. So it just, you know, a lot of this is up in the air depending upon, I think if he says now that I'm fully informed, which I am not saying that any of his decision before was because of any incorrect information. I just think, like he said, it depends how he feels when he wakes up in the morning. So
Man, that's sad.
anyway, yeah, in order to try to tackle all of the issues surrounding this, this is the best I have been able to come up with.
Or you could just
So,
declare a mistrial.
I
mean,
so
that's
y'all
an
be
option,
thinking
too.
about that.
Did Your Honor get the thumbs up?
Yes, magically. All right, anything else before we break for the day early? Because I'm going to go do some work on it, not in court.
Just for your edification, we'll file a written motion. The state yesterday gave us a Dropbox link, and it includes additional telephone numbers that I was unaware of,
Okay.
where an expert, he's already been qualified. His name is Agent Bernie, Berni, from the FBI, has done now an analysis of historical cell site location data. And I'm objecting to that very late, I believe, notice.
Oh, man.
And then the state has a couple other, they changed charts. I personally don't have a problem with that, but I need to study them. But the new reports and data and a new phone number, I am not agreeable to.
Okay, an entirely new phone number. Tell me some more, Miss Love.
Yes. So the new phone number there was another person in the vehicle during one of the murders in this case that investigators were still investigating during the time we began this trial. They were trying to hash out whether or not this particular person was even in the car, if you will, with
Okay.
some of the alleged
Okay.
parties to the crime.
Okay.
Since that time, during the course of this trial, the investigators with the Atlanta Police Department that were doing their deep dives into forensic data determined that this person, I don't think that person has been arrested, but this person was also in the car with the co-conspirators during this particular murder.
Okay.
We got it before now, but we got it after the trial began, like
Okay.
between,
It's
I
the
think,
exact same thing.
January and now.
This is the same
And
thing that
I think
happened
it
in
was
Alec Baldwin.
inadvertent,
Same exact thing.
That it had not been disclosed.
All right, can I stop you and get some clarification?
Yes.
When you say we got it, do you mean we got this report from this agent, or we got information that there might have been yet another person in the car and that person had XYZ phone number and that was going to be investigated?
So those are two separate things. The
Okay.
report from the investigator, from Detective Bernie, involved plotting.
Sure, I understand what that means. When did y'all get that?
We recently asked him to plot those two, because the green store is a thing that came up recently during trial, and the other location was.
I know what a green store is. Y'all, come on. Like, what else do y'all need to do? They just trying to get disqualified. What else do you need to do? Judge Whitaker, what else does it take? What does it take? It is going to keep doing this in order for you to disqualify them.
So we have two understandings of what the court is asking. So we're not talking about plotting of those cell phone numbers. We're just talking about the Boyer cell phone records. We're just talking about the cell phone records.
We're talking, I don't know what we're talking about. That's what I'm trying to pin down. So
there was.
hang on, yes.
We were given cell phone records linked to a last name Boyer.
Boyd, B-O-Y-D?
B-O-Y-E-R.
Boyer, okay.
On Monday, on yesterday?
Okay.
Yesterday. And so that is the late disclosure that we're speaking of.
Okay.
And they were charted as well.
Okay.
Which leads
Nobody
me to-
really, I'm sorry, do y'all care, is the objection to the charting or?
It leads me to believe that they've had them for a while if they've plotted them.
All right, so the plotting of the cell site location information report done by Agent Bernie, that's of this Boyer phone number?
Yes.
Okay, and y'all just recently asked for that based on some
Let them talk. Let them talk.
testimony about something?
No, that's a different thing. I literally sat there and conflated two different.
Okay, all right, so then let's back up to the original issue. When did you find out that law enforcement believed that there was another person in the car and had a cell number that they were going to investigate with regard to that to find out whether, in fact, that was a reasonable lead?
Your Honor, I'd like to check with another team member.
Okay.
Because I don't know.
You ain't got no team. You ain't got no
Can
team.
you give me an idea? Let me clarify. You said about something that it was sometime between January and May, and that might have been that you got something. What was that about?
So the conversation that I had with the team member most recently.
Wow. Thank you, Doug.
2 days ago was that I have to turn over these phone records.
Right.
This person was someone that they believe might have been in the car.
Okay.
And they got phone records, and now we know that Based on the phone records, this person's been.
Okay, so when did they ask for, we or they, not we, but y'all or they ask for the phone records because they thought that might be,
I begged the court to allow.
all right, find that out. And then, do you know when y'all got the cell phone records?
When you said we, I thought you were talking about us. I don't know the answer at all for the Atlanta Police Department, but I can find out.
Okay, so unfortunately for you, we equals, y'all equals, the state equals both the DA's office and the Atlanta Police Department. You know that, and I know sometimes
This is
there's
embarrassing.
a little
This is
lag
so
in
embarrassing.
communication, but I need to know, was it, if they were provided to the defense on Monday, you know, was it last week or was it 4 months ago?
Okay, I can find
No.
I guarantee you it's not
Because-
last week.
Okay.
Don't even warn them.
And what do these cell phone records reveal? That this person did appear to be also in the car? And
There's two cars.
okay, do you know which car? I mean, there are two cars that obviously one, well, not obviously, at least one contains at least one shooter, right? Is there any assertion that others contain shooters as well, or just people that are involved? Okay.
Why give them this much slack?
White car with my client and Mr. Garlington in
Right.
it, and then another car with Mr. Nichols and Mr. Farley in it. And now it sounds like they're saying that this Boyer phone, whoever owns this phone, was in one of those cars, and I'm inquiring what.
Mm-hmm.
I don't know anything.
I'd like to provide that information, if I can.
You don't know, you want to check and make sure on that, okay.
This is embarrassing. This is embarrassing.
Yes.
As
Okay,
unprepared as they've
how long
been.
has the defense known anything whatsoever about this person named Boyer?
Your Honor. Oh, except for this, I could tell you from my understanding of the discovery, there is zero information on Mr. Boyer except one mention in a jail call. That is it. That from my whole database, I have one mention. That is it. And I have no reports. So the police been investigating and found out that this person allegedly was involved in this killing.
Right.
I still, to this day, have no reports on it. I've
Okay.
never interviewed him. I didn't open on him. He could be
Right.
a great defense. I have no idea who this person is.
Yeah, I mean, yeah, this is, I mean, you know, potentially significant information for the defense to know about.
Sit down, love. Just sit down.
I
Sit down.
can't say that at the time we did openings that the police had this. I'd like to be able to say.
All right. All right, we'll find out, but there's
No,
been
she
a
needs to know right
long
now.
period of time between opening and now.
Right.
8 months to be,
That was 24, okay.
Don't-
7 or 8 months.
Who cares? It's been longer than a week.
So, yeah, we need a lot more information about this. I love how y'all save all of the like bombshells for late in the day,
That's-
right
that's
before we're
Steele.
wrapping.
That's
Y'all
Steele
like
does
going,
that.
hey, guess what? So, okay. I mean, it is what it is.
Still likes to ruin your night. I love it.
Okay. So we'll
Wow.
need to find that out and put that on the record and sort that out tomorrow. Okay, so exhibits, next 30 witnesses, and then you
slow
also, I believe, we're going to get by tomorrow, actual, like a list to the defense of here's what we think is a co-conspirator statement, right? Okay, so we'll be waiting anxiously for all of those. Anything else? As if that wasn't enough.
Your Honor, somebody I wrote down said that there are 3 Mr. Zachary statements. I have 2.
Okay, and I might have misspoken. Did I misspeak? Miss Love misspoke. Did Miss?
Girl, she needs to stop. She needs to stop. Stop talking. Let mute man talk.
August 2015,
This is embarrassing, y'all.
March 17, and the proper. I'm sorry.
mercy, y'all.
Okay, so you think that maybe there only are two, but you'll confirm that for us tomorrow? All right, and so if there are only two, then Mr. Shart, you've done all of the proposed redactions because you've done redactions to two full statements, right? Or proposed redactions.
I didn't quite finish the second one, but I don't believe that the state is going to be trying to use it. It's a discussion with ATF agents and.
All right, y'all, we're going to get together and sort that one out too. Okay. Sounds good.
And Judge, if the board needs to finish the court, just allow me to get this thing copied.
I don't know, Don. That's a great question, though. I'll look into it. That's her strategy. She loves to kick it down the, and sadly, Glanville used to give her this a lot. And Whitaker needs to stop doing this. I don't know at this point, Marie. I mean, they're literally just showing you like, yeah, we had information. We were sitting on it. They literally had information. They were sitting on it. This is very much so what happened in the Alec Baldwin case. And she knows that. Judge Whitaker knows that. This is insane, man. At this point, it's just like, you can't be this obtuse. I'm sorry. And you're chief prosecutors and such of that nature, high level people. These are not just mistakes. These are freshman year mistakes, not
right,
master's degree,
that's fine.
doctorate
That'll work.
level
Thank you.
mistakes.
All right, see y'all at 9 tomorrow.
Mm.
We'll be 8:45 at it when we have the jury. Okay.
Love looks so distressed. I don't know. Yeah, I mean, we're trying to give you the grace, man, Mike. Like, there's no way you can make me believe that you didn't know that. And she literally just said, like, oh yeah, we just had this information.
We're adjourned.
And she says, well, from when we started, we didn't have it when we started. But y'all started back in November 2023. When did you get it? Is the question she asked. And they're trying to find a way to finagle it. They're trying to white it out. They're going to try to find a way to say that, oh, we got it last week. That's what they're trying to say. That's what they want to say. But Brian Steele already put them in the trick bag because he said that there's charts. That means they analyzed it. Same thing with shards. Oh, there's some. It means they've had time to do this. Triangulation, I'm sure, showing where the car was, showing where the phone was, rather. Man, this is embarrassing. I have no idea. And I'm gonna leave it up. I'm gonna talk for a few seconds just to make sure they don't pop back up. Because the other day, they popped back up right after we ended the stream. But yeah, this right here is bad. And I'm like, Judge Whitaker, for real? Like, what do you need else? You're literally watching these inept people, and they're doing, now, mind you, again, maybe I'm wrong. I could be wrong. I know there's legal minds that'll check out this commentary after the fact. So please let me know if I'm wrong. I'm willing to be corrected. I want to learn. Is this not the same thing that happened with Alec Baldwin? The exact same thing. They got information. They decided they didn't want to share it. They say it was not that important. It wasn't important. They got the information and it didn't immediately run to go show it and share it. But it's kind of weird because Adrian Love made all of that hay about Brian Steele not sharing information with them. And she herself had the same thing. This is gross. Gross. And the fact that, I'm sorry, Judge Whitaker, the fact that you let her keep saying that, oh, you can do it, turn it in by Friday, turn it in this day in the future. They need to go do that right now. No, you need to go find out right now. Where did that come from? The reason we're in study hall court right now is because they're not prepared. That's embarrassing, man. That is embarrassing. I, I don't, I don't think so. But I mean, it's possible at this stage of the game. There's very little that I will say is completely outlandish and outside the realm of possibility. So you know what, Gladiator girl, I wouldn't be surprised if I run into Judge Whitaker at Whole Foods and I ask her and she says this. I wouldn't be surprised. Yeah, we're in study hall court. Like we're literally doing stuff that they should have been doing for the last. I'm sorry, they should have did before church before court started. They didn't go to church. They should have done this before court started. So it's study hall. It's study hall court. I don't know at this point, Ray. I don't even know anymore. I'm like, how much more do you need? I literally did an entire video explaining why Judge Whitaker could have walked in on Monday morning and been fine. And I talked to people who are in the law field before I did that video, and they said, "Yeah, you're right. This is what she could do this." And I talked to them previous week when I said why I think that she'll do it right after the motion tsunami that came back on YSL motion upload day or whatever we called it, motion delivery day or something crazy. And again, she could have done it then and been fine. At this point, it's like how much more wet can the Titanic get? The Titanic can't get any wetter, but I don't know what else she needs. I don't know. I have no idea at this point. How much more do you need to declare? Mr. Love is getting away with murder, and Glanville created this monster. I agree. And Judge Whitaker should call a stop to this. We should still be on right now because Judge Whitaker said, no, y'all need to go get that stuff right now. Because you hear it in her voice. She's about to say, like, yo, this is Brady. This is a Brady violation. If you're not familiar with Brady, Brady is whenever the prosecution gets evidence, they have to share all their evidence with the defense. The defense doesn't have to share all of their information with them, but they can choose to do so. That they're going to use to impeach or nullify, whatever like that. But they have to share, they have to put all their cards on the table. So you can't say, oh, I don't want to use this card and this card is not important and I'll just put it away. You can't do that. You have to share all of your information. Just go back and listen to the last hour and a half of the Alec Baldwin case and you'll hear it. The judge articulates and lays it out perfectly. It's beautiful. Where the prosecutor has to explain why she didn't accept the bullets from another place and all that kind of craziness like that. It should still be made available to the prosecution. But yeah, this right here, I don't know what they'll say. I have no idea. I do expect there to be some motions filed tonight. There's going to probably be a lot of, okay, it looks like it really did end. The stream really did end. There's going to be a lot of motions filed tonight. I'm pretty sure of it. If Brian Steele has not already filed a motion for Brady violation, I'm sure it's coming in a few seconds because it makes no sense at this point. I have no idea. I can understand that she wanted a clean mistrial and she wanted to make sure it didn't get overturned. I mean, the thing is, the thing is cemented over, right? It's cemented in mistrial. I don't think there's any way possible to get that thing uncemented and flip it back over and overturn it. There's no way. So that's what I'm saying. Like literally, it's infuriating because literally I'm like, how is this on Friday? Remember Friday? They just dropped, or the other day they dropped the extra ex parte meeting, the one that happened on the 7th of June, just out of the blue. Oh yeah, by the way, there was another ex parte meeting. What are you talking about? Now they got this. Okay. And again, something else that the prosecution has not talked about. And they're sitting there looking like, hey, how dare you not give us all your discovery? But they have something that they literally have not given. Okay. I guess I don't even know what to do anymore. It's frustrating to watch. It's crazy. I'm like, y'all gotta be kidding me. Yeah, yeah, Alec Baldwin is a case model for Brady. I mean, it was almost perfect. Again, it's not really long. It's only 3 days. And But literally, I think you could watch the last 2 hours, last hour and 30 minutes, where the prosecutor gets on the stand and she explains why she did not tell the defense about this. And then she tries to explain it. And then the judge said, okay, we can put an end to this. And she just gives them the business. It was perfect. I'm not convinced of this anymore. And the only reason being Kamala Norris, and I'm not trying to be I talked to somebody who explained, you and I might think like that. Like, I want to make sure I cover for my friend or whatever like that. This place is cutthroat. Nobody cares about anybody like that. If you mess up like this bad, nobody's trying to cover for you. I don't think people are trying to cover for Glanville like we would think they would. I could be wrong, but I've had too many people tell me, yo, no, that's not how this works. Nobody cares. Nobody cares. And like I said before, the reason Fani has not come riding in to rescue the prosecution is because she doesn't care. Nobody cares. They're gonna have to. They shot it. They got to eat it. You got to eat this, and it's a big giant sandwich of excrement. He's not her boss, though. That's the thing people don't understand, Rick. He's not her boss. He's just the chief judge. It's a title. It's a title. It's not a position. The chief judge gets rotated every so many years. So one day, if Paige Whitaker stays in Fulton County, she'll be Chief Judge Paige Whitaker. It's just says it's a title, designation. It's not your boss at all. It is not a boss status at all. No, it's not a boss status. Judge Krause could turn around next week and be Chief Judge Krause. It's a title. It just means you're the judge that they look at first. That's it. It is not a positional status like I am the father of my children. I am positionally above them. There's no way that's going to change. There's no way that's going to change. If they call me their bestie, their best friend, that's just a title. It don't mean nothing. It don't mean a doggone thing. If you got teenagers, you know good and well, it don't mean a thing. It means nothing. Best friend means nothing because it means something different this week than it did last week. Yeah, it's just a paperwork position. It literally rotates. Go to your city and find out who in your county or however your judicial systems broke down. Find the chief judge. That's not a superior court judge or appellate court judge, trial judge, and not a magistrate. Find the chief judge and then find out like how many years does that rotate? Every 2 years or 3 years, whatever. It's nothing else. That's all it is. So a lot of people think that Glanville, she's trying to cover for her boss. No, no, it's not that. Sorry. The Trump trials. Oh, by the way, don't tell nobody. Okay, just keep this between me and you, Brandon. The Trump trial is done. Don't tell nobody. Because a lot of people still holding out, hoping and wishing. Please understand, the Trump trial is finished. It's going to appeals, and they're not even going to listen to oral arguments. Oral arguments are like pre-trial work. They're not even going to listen to oral arguments until December 5th, 2024. Now, you probably know exactly why I brought that up, because the election is November 5th. They don't even care about this anymore. All they wanted to do was get that man dinged with the title felon. That was it. All these were just some horse trade to get felon on his title. So whether it be New York or Florida or Georgia or Nantucket or wherever else they were trying to sue the guy. Whoever came up first, it was New York. That's why they're not stressing about sentencing. They just wanted the title felon. That's it. DearWolkC@gmail.com. If you have a question, comment, concern, we can figure it out. But yeah, that trial has always been shaded. I'm sorry. I'm sorry, y'all. This is just what they saying. What do you mean? Okay, Thunder Drop. they just found out that defense had information about cell phone data that may have helped the defense, and they just found it. And I'm sorry, just made it available to them yesterday. So, and Judge Whitaker was asking ADA Love, when did y'all have this? And of course, ADA Love doesn't know. So she's got her homework that she has to go find out, when did they get this information? And so that's where we are. Yeah, this is really disappointing, because it just seems like y'all don't even care. And again, if we were talking about your HOA or bike lane commission, it'd be a different game. But you're literally talking about men's lives are hanging in the balance, and you don't care enough about preserving the rule of law and preserving the legal system to make sure that the information that you're given is the best information to do the right thing for the people of Fulton County. Because this just keeps happening. I don't know how much more this needs to happen before somebody actually says something like, yo, this is out of pocket. This is out of pocket. That, again, this is what you would expect from a pre-K law student, not the chief. ADA Love is like responsible for tough witnesses or something. I forgot her proper title. But no. She can make the same mistakes that I make. With all the power of Fulton County behind her, she can make the same mistakes that I can make. Okay, that makes perfect sense. Makes perfect sense. Perfect sense to me. That's gross, man. If this doesn't make you upset and infuriated, I don't know what to do. I don't know. I'm like, yo, this is like y'all playing with these men's lives. These are whole grown men. Again, they might be criminals. They might be as dirty as today is Tuesday. They might be. But again, we don't know, because y'all do such poor job of actually doing your job. And I hope the people in Fulton County are paying attention to this. I really pray that the people in Fulton County are paying attention to this. And see Melson. I mean, this could be the banner over the entire live stream for like the last month and a half. Love ain't gonna do nothing more. She gonna try to figure that out on a car ride home, or maybe in a car ride in the morning. She is not gonna do any work to find this out. She's writing right now because she realizes that they've messed up. So they realize that, yo, we got this back in April. Yo, we got this back in March or whatever. They know it wasn't yesterday. That's for sure. So they're going to sit there and try to figure this out. How do we spin this? Let's go ahead and write the motion, because we know Brian Steele is right now writing the motion. All he's got to do is put the dates in. You know, like I know, that Brian Steele is writing the motion for a Brady violation palooza right now. Him, Shard, Weinstein, Ponytail, the whole gambit, all of them writing. They might even tap some other people. Everybody write this motion. And so she's over here. She already knows it. She already knows it. She got to come up with a good lie for why they did not give this information to them as soon as they got it. They should have sent it directly to them, because it was on a thumb drive. It was on a Google Drive, he said. So it had been curated on the drive. I'm sorry, man. This should make the people of Fulton County should be infuriated. Somebody said they should be out protesting. And I agree, man. They should be out dang near rioting over this. Because like, if they do this to Young Thug, and the only reason we know about it is because Young Thug has money. If Young Thug was broke, if Young Thug was just your average run-of-the-mill gangster, your run-of-the-mill trigger puller, shooter, he'd already be in jail, under the jail. Only reason we know about this is because he had money. That's it. Well, she uses chat. If she uses legal chat, legal AI, or was it AI lawyer? I pray, please at least read over what you put out. Because if you go back and listen, Judge Whitaker is throwing shade at her because there's like grammatical, phonetical errors in the writing. She says like this is bolded and this is underlined. And she's pointing out the fact that it shouldn't be bolded and it shouldn't be underlined. So she's calling out the fact that whatever this legal AI lawyer did, it didn't do it correctly. She's calling her out. She's throwing shade. Shout out to Judge Whitaker. Yeah, man, this is very disheartening to see how easy this woman, I'm going to say she's evil. Evil. Catch me outside, Adrian. Hey, just catch me outside. DearWokesy@gmail.com. She's evil, man, that she would go time and time and time again, make light of the fact that, oh yeah, I can just throw you in jail until I get tired. I can throw you in jail until I get out of menopause. What the hell's wrong with you? What's wrong with you? And you built your whole, that's your fault that you built your whole case. The case that should never have existed, mind you, because Paul Howard told y'all it wasn't a good case. But the fact that you would still want to do this to these men, dragging these men through there. All I think this is just a money transfer, dragging these men through there. And again, she's not alone. You're right. I'm just using Adrian as an example, but I'm holding mute man guilty. I'm holding the junior achievement lawyers at the back table, Hilton, everybody that's come over there whispering in Adrian Love's ear, asking her what she wants from Panera. Every last one of them is guilty. Every last one of them. Everybody that's done a report that knows that she be using AI chat GPT to write her motions. Everybody. And the fact that nobody is interested in providing the support that these men need is just it's ridiculous. It's grossness of the highest order. That, oh yeah, it's okay. I don't care because I'm not in jail. Because if they didn't do anything, they wouldn't be in jail. Only reason you need to care is because you're a criminal. Well, I'm not a criminal, and I'm very, very concerned about how you're treating fellow image bearers just because you don't like them, just because you can get a come up, just because you can see a political gain or career advancement off the back of somebody else. And you do such a shoddy job of doing your job. Like, can y'all imagine how far afield this would be if they were still with Glanville? I mean, this would be crazy if they had not recused Glanville. This is ridiculous, man. And I really don't know. I'm at a loss for words for what we just saw. And again, shout out to Brian Steele. Brian Steele likes to do that right at the end. He's been sitting quiet all day. Y'all notice Brian Steele hasn't said a word all day, just about all day. And out of the blue, last thing, and he sat there and wrote a motion. He didn't posted a motion to get them recused. And then out of the blue, he says, oh yeah, by the way, you do know this, right? Amazing. Amazing. Y'all, thank you so much. Let's do this. I don't even know. I'm not going to even say it. I'm not going to say it's going to be the last day. I'm not going to say who knows how much longer, because shoot, the way this is traveling, Judge Whitaker going to sit there and believe the lie. I don't know how she's going to do it, but I'm disappointed in Sis Witt, because that we should still be doing this right now. Sis Witt should never turn the camera off. She should say, y'all need to find out exactly right now who you need to call, who you need to text, email somebody, and find out when you got this information. She shouldn't even let them go home. She should have said, no, we good, y'all. Go ahead. We could order some Domino's. We got Domino's on the way. Y'all got to find this out. When did y'all get this information? The fact that she let them go home is problematic to me. I'm just, she shouldn't even let them go to the crib. Like, no, y'all, I already told y'all gonna work late anyway. She already told them that. So if this is an 8 o'clock party, then it's just 8 o'clock. If this is 12 o'clock, then it's just what it is. Y'all better find out, when did y'all get this information? Names must be named. Times must be given. How did she let them go? I'm sorry, Paige, you shouldn't have let them go. They should still be there in the house. That is amazingly gross. Like those are people's whole bona fide lives, whole adult lives are balancing in the hanging over a thread, over a flame, and we playing games. Oh, I just got this information. You're a liar. You're a liar. You did not just get this information. And I mean, again, if Brian Steele had not been paying attention, not been doing his job, not doing, again, shout out, because who would have known? I'm not willing to do that. I think she's trying her best to keep this thing on track. But watch this, watch this. My four girls, I'm being honest again. I'm trying to be a fair dealer. I think she's trying her best to do the right thing. And I think she's taken aback by just how inept the state is. We are watching an NBA basketball team play against a junior high school team. Dare I even say a junior high school soccer team? Like that's how bad it is. They're not even playing the same games. They're not even using the same equipment. This is just a much more advanced, intelligent team. So I think she's overwhelmed. Like, yo, I can't believe how inept you are. I'm trying to get this thing back on track so we can get justice here. And at the end of the day, it's just, I think she's overwhelmed by just how inept the DA's office actually is. But again, hear me, my four girls, we don't got to part ways. Okay. We ain't got to part ways. I'm just willing to say, this is what I believe is happening. I could be wrong. I'm willing to admit that I could be wrong. Okay. Y'all show me proof and evidence tomorrow that Judge Whitaker is dirty. Guess what? I'm going to call her dirty wit. But I don't think that's the case. I think what it is she's overwhelmed by just how inept. And please keep in mind, this case was completely trash when she got it. It was trash when it was with Glanville. So it didn't get untrash. And now all of a sudden it's revealing the crookedness of Judge Whitaker. No, it was hot garbage when she got it. And it's only proving how much of a hot garbage it is. That's my little 2 cents. DearWokesy@gmail.com. I mean, they literally are threatening the dude on the stand. Today was amazing. I'm going to have to save today's video. I was cleaning through my external hard drive on my computer. I'm going to get another hard drive. I was cleaning through my external hard drive on my computer and I was getting rid of some old videos. I was like, yeah, I'm not going to probably go back and revisit this one. This one here, I'm about to like lock away in a vault and never get rid of it because my goodness, in the morning, there was so many problems. They literally are sitting there talking about how they can arrest somebody because they don't want to talk. The man is doing life, okay? Whether you like him or not, whether he's a witness or not. The man is out here doing his own life, minding his own business. But y'all say, hey, if you don't do what we want you to do, we're going to put you in jail. And we're going to put you in jail until we decide to get, until Whitaker grows an afro. Like, what the heck is wrong with you people, man? I'm sorry. I got to laugh to keep from crying. Like, what's wrong with you people? And somebody's going to tell me in the chat, I'm wrong for saying Adrian Love is evil and all of them are evil. They are EVIL, wicked. What else you want me to call them? What else you want me to call them? Y'all wouldn't let her teach your kids Sunday school class, so go and be quiet talking to me. Oh my gosh. Like, you got to be kidding me. But is she covering? Okay. And hear me, my four girls. Look, I'm not saying that she's trying to cover his wrongs. There's no reason to do so. There's no benefit in doing so. Like in 4K, like just think about it. Like in 4K, why would you want to cover for somebody who's ruined his career? So you're going to ruin your career by trying to cover for somebody who's ruined their career. You have a much better track record. You have you're seen in the judicial system as a better judge, if you will, more productive. Why would you want to ruin it for him? Like what's the benefit of it? That's all. Because you're going to have to prove like, oh, there was some advantage to Jason being a dirty cop or Jason being a dirty, gerbil thrower or whatever. You'd have to show that there's a benefit. Like, what would be the benefit of me doing that? Just because? Just because he works in the building with me? For what? I don't see any reason. But again, I'm at this point, you can show me, if you email me, you email me evidence, I will come on here tomorrow morning and I will give her the business. But yeah, yeah, this was wild. Yes, and this is another great point. And Woody knows this. Felicia just asked, can't the Fed still charge Woody? Yeah. So if he says something, sure, the state might not charge him. Fulton County might not charge him. If he says, yeah, it's a federal crime to throw gerbils, right? Yeah, I'd be chucking gerbils and throwing them over 285 and, throwing them, whatever. The state might say, okay, we're going to let that go. Use immunity. Was it transactional immunity? Got you. But the feds could say, well, hold on, wait. You throwing gerbils? That's a federal crime. And he can come do that time. So I don't think you can get away with that. I don't think you can just say, get away with immunity. Like, oh, I'm a trafficker. I traffic, illegal substances. Well, they might say they're not going to charge you, but the feds, now that might put the feds on your tail. They might not use exactly your this, that, and what you said on stand, but does that mean they can't pull your cell phone records? Now they know where to look. They know who to look at. Come on now. I think that's what Woody's most concerned about. All right, y'all. I appreciate y'all so much, y'all. Y'all just listen to me rant. And again, that last hour, that last 30 minutes was a gut punch. Like, you've got to be kidding me. Y'all are okay with this? And you're literally kikiing away the fact that, again, unprepared love, the most inept attorney on the planet, again, has shown that, oh, I just had this. I didn't give it to you. I would love to say, yo, tomorrow there's going to be a mistrial declared because of Brady. I'd love to say that, but I don't even know what's going to happen anymore. And then for them and again, man, I'm super hit in the feels about how they were just horse trading this man's freedom. Like, oh yeah, how long can you keep him? If he don't come and testify, we can keep him until this time. And they were just fine with it. Everybody was fine with that. I'm like, wait, y'all do realize you're talking about a man's freedom, right? Man was he living his life, whether you like him or not, whether he's a bad person or not. You just gonna throw him in jail? Just throw him in jail. And then now you like horse trading about how long to throw him in jail. Oh, okay. All right. I guess that's what it is. And this is crazy. And then for a case, and then let's keep in mind also, yeah, shout out to my brother. Why my brother texting me? He usually texts me when I get off, or calls me when I get off the air. But I guess because I'm going long talking, he's like, now he just decides to start texting me. Shout out to my brother James. I think that's wild. And think about it. Woody would testify and put himself, let's just say YSL is as bad as they make it sound, right? So he would put himself in harm's way, in jeopardy, dare I say, and the case still goes to appeal. He puts himself in jeopardy. He sits in the booth and he just sings like a mockingbird. He gives all the details and it still gets overthrown. It still goes to appeal. But now you got him out here testifying and now he out here in the streets. How's that going to work out? What do you think is going to happen to him? I don't even. Shout out to James. Shout out to James. I think he texted me again. Is he on are you on here, James? What are you doing? Like I said, he usually texts me as soon as I hang up. So shout out to my brother watching. He did. Trump said the young thug was being mistreated. I'm just glad this didn't happen. And then Trump was being interviewed, because I'm sorry. If Trump runs out here and says free young thug, I'm telling you. If Trump comes out with a free young thug t-shirt, I'm just laughing to keep from crying because this is so insane. Like, do you realize we are watching people literally skirt the judicial system and create new law, argue stuff that don't make no sense? I'm surprised they're not starting to argue stuff from Game of Thrones. Okay, I'm expecting them to argue stuff from Voltron or something. They're just making up stuff. They have no. Do you have evidence to that point? Yo, this is, and again, like, do y'all realize that we would not know this? I'm gonna say that this is the last time I'm saying it. We wouldn't know this if it wasn't that Young Thug was a very wealthy man. Again, if he was just your run-of-the-mill ex-classroom teacher, I'd be in the jail. I'd be under the jail. Okay, I'd be under the jail. I'm not built for jail. I'm just not. But I would be in jail. But Young Thug, because he could hire an attorney like Brian Steele and the others, that's the only reason we're here having this conversation. That's crazy. Like, you got that. Like, that's just like, whew, talk about the skin of your teeth. Okay, I'm sorry. TikTok was named in court. TikTok must be named. What was yesterday? Yeah. The Trump thing was yesterday. I was saying, like, can you imagine if that was today and this had come out? Amazing. Amazing. He did pardon Lil Wayne. He sure did. Trump did pardon Lil Wayne. But this don't even require a presidential pardon. This does not even need a presidential pardon. There are so many missteps. This is like, again, a toddler serving up a underhand pitch to you. I mean, if you can't knock this out the park, that's on you. You ever play baseball? You're your own pitcher, so you throwing the ball up and then you hitting. Okay, I mean, that's what it looks like to me. Like, but you're not hitting with a regular bat. You're hitting with a bat that's like a foot wide. Like, there's no way that you're not going to hit this. There's no way. If you miss this, that's your fault. I'm sorry. This is craziness. I am. What the kids say. I'm shook that we are literally watching people horse trade with people's freedom, play games with their freedom. I hope Young Thug is able to sue Fulton County for this, because it's crazy. Like, if they get, I mean, you trying to tell me this is not a delay in prosecution? They have a right to a speedy trial. I mean, I don't know what violations they have not violated. That's probably a shorter list. What have they not violated? Unlawful imprisonment, failure, not able to confront your witness, speedy trial. Which one of the rights do they not violate? Would probably be a much shorter list. I'm done. I'm done. I'm just amazed. I'm done and amazed and done. I really like. I don't even know what we're doing anymore. This is crazy. Oh my goodness, y'all! This is a good old. Is this on Twitter? Black law student. I was literally about to go. I knew I should have left. We got black law student in the building. Black law student has written a RICO indictment against Fulton County DA's office. I got a feeling it's going to probably be really good. Let's see. Wow. Real quick, let me pull up. Oh my gosh. All right, let me pull this in real quick. You want to jump on real quick, black law student? Let me know if you want to jump on. Pull up my RICO. All right, there it is. That good old Judge Whitaker. What's she saying? Judge Whitaker said she wants to know more about these breaking. YSL judge wants to hear more about a potential Brady violation tomorrow in court. Amazing. Amazing. The fact that this even, I don't think she should have let him go. Truth be told, I think she should have said, y'all gonna sit right here and figure this out. Y'all got to answer this tonight. I don't know. I have no idea why she even let them go home. She should have said, y'all is here for the night. We ordering pizza. What y'all doing Taco Tuesday? We doing tacos. That is true. If Woody pled the fifth, watch these YouTubers raise money for him. That's probably true. That's probably true. I can't say I would not pitch in a couple bucks. Who should not be represented? Who should not be representing Woody in court? Caleb Bumpus, Jacoby Hudson. Who's that? John Melnick. None of these above. I think Jacoby's like an outright criminal, though, right? Wow, none of the above is like, man, y'all savage, man. All right, I have got to blow this popsicle stand. Yeah, I think she should have made her stay. I think they should have said, y'all got to stay here tonight and get this figured out. I don't think anybody on the defense would have been mad if they said, yeah, we're going to stay here tonight. I think the defense should have said, look, Your Honor, this is a grievous misstep. And how do we know? Well, that's a great question. Somebody just said, how do we know what love tells them is true? I don't think we don't know that emphatically. That's a great question, Laura. The only saving grace is that whatever is shared probably has some kind of digital timestamp. If it was a report sent from your coworker, like an email. Remember when she was reading the emails and it's such like that. So that's the only saving grace, is that there's probably a digital footprint to it. So if it was, again, a timestamp or it came at this time, whatever like that, that's the only reason. But, and please understand, she's cooked, by the way. She's cooked, because if she rolls in there tomorrow, let's just say Adrian Love comes in there and she done whited out the timestamp on something and said, oh, we got it on Sunday night and we made it available to you on Monday. Got you. Who's it from? It's from Officer Rufus or whomever, right? What are they going to do? They're going to ask to see Officer Rufus as an expert. They're going to ask him to come, and it's going to be off to the races. Because if Officer Rufus says, yes, I sent this on Sunday night, he corroborates what DA Love said. If he says, no, I sent that back in January of 2024, she's cooked, flambéed. It's over. Oh, wait, what shirts? Are the new shirts? Where are the new shirts? Oh, we got new shirts. I got to check these out. Here, let's roll in the morning and let's, are there new shirts on my site? What do you know about that? I'm ready to check them out. Okay. Now I'm excited to go check them out. Also excited to go see my wife, Lady Dear World Christians, in the kitchen. Yeah, I don't know. I don't know. See, Melson, I think this is a great question. I wonder if people wrote the mayor or the governor protest because I'm surprised it hasn't happened yet. Okay. Sorry about that. All right. Let's do this again, y'all. Y'all, appreciate you so much. Thank y'all for being my therapist. I have to send y'all a little. You know what? In honor of that, tomorrow I will come back, Lord willing, at 8:45. So we'll do this again tomorrow. And prayerfully it'll be better. Who knows? I have no idea what to expect. But I do appreciate y'all. Thank you so much for listening. Thanks so much for hanging out with me. Everybody, thank you so much to the very generous super chats, by the way, too, and memberships and the such of that nature. Thank y'all so much. It does go a long way to help support what I'm doing here on this channel. And it does let me know that you like what I'm doing. So I appreciate that you find value in it. So I thank you all so much. But I appreciate y'all just watching, hitting the like button on your way in, being a part of the best live chat on the planet. Thank you so much for all of that. It means a lot to me. So you guys rock. I appreciate you all. And until next time, everybody, grace and peace. Take care.